Yes, Suman.
Please, Lordship. In the present case, the petitioner is the elected representative of the Burmah and area, Lordship. He has raised the issue of the pathetic conditions of the medical health, Lordship.
What is
And
the
What
is the issue?
Lordship, all the important posts of doctors are lying vacant. Kindly when actually P1 page number 7.
Notice. AG Saab accepts notice. Instructions to response by the next date of hearing. आज क्या date है?
21st, Lordship.
28th.
Please, Lordship.
Please, Lordship. Kindly wait.
Yes, Mr. Mukesh Sharma. Mr. Gurudev Negi.
This is my petition under Article 220. So, for my enforcement of my right under Article 21 of Right of Life, my because my lord may kindly have the page number 40, my lord. This is my first complaint to the STM Chiog to page number 40, my lord. That says ये कि पार्थनी इस उपरोक्त पता के ग्राम के रहने वाले और हमने काफी पहले से सरकारी नाला चक की चश्मा से बराबर सतर पर अपने पाइप लगाए हुए थे और इस पाइप से हमने पृथक पाइप में अपने घर के लिए पेयजल पानी लगाया हुआ था और ये हमारा पानी का एकमात्र साधन है सर। और हाल ही में उस चश्मा में पानी कम हो गया और प्रत्याशी ने मेरी पाइप को इस चश्मा से उखाड़ कर बलपूर्वक फेंक दिया। अंडर दिस कंप्लेंट मिलोड द STM has conducted detailed inquiry, my lord. That is the Naib Tahsildar has conducted and report, my lord. That is on Annexure P6, my lord. Annexure P6, the Naib Tahsildar in his report he says that कि यहाँ पे चश्मा एक ही है भाई और अल्टरनेटिव सोर्स कोई नहीं है जी पानी का। और पुलिस को भी STM ने यही भेजा जी। Annexure P5 में एक कलंदरा बनाया जी, कलंदरा में भी यही आया कि यही चश्मा है।
The petition is maintainable.
Because of the fact, my lord, the article, my lord.
Prayers article सबको पता है. Please read the prayers.
Prayer, my lord.
How can the High Court under Article 226 issue a writ of certiorari against a judicial order?
This is judicial order is, my lord, if there is a gross miscarriage of justice.
Don't teach me law. Answer the query of the court.
Please, your lordship. This is the judgment of Honorable Supreme Court, my lord, in Radhesham versus Chabina.
पता है 2015.
2015 का जिसमें ये बोला हुआ कि जी gross miscarriage of justice.
Sorry. All Supreme Court has categorically stated in this judgment the subtle distinction and difference between 226 and 227.
Please.
Read the last para of this judgment.
Please, your lordship.
Please read the last para.
We may deal with the submission made on behalf of the respondent that Vive in Surya Devi Rai stands approved by larger bench in Shale Mahindra Sari Emporium and Salim Advocate Bill Assam on that ground. Correctness of the said view cannot be gone into by this in Shale. No reference has been made to Surya Dev. The same is only for the purpose of scope under Article 227, as is clear from para 3 of the said judgment. There is no emporium, therefore, there is no emporium. Their reference to Surya Dev Rai is made in para 9 of the judgment only for the proposition that no subordinate legislate can whittle down the jurisdiction conferred by the Constitution. Similarly, in Salim Bar Association.
Last para पढ़ो सर, मैंने last para पढ़ो.
ये last para यही है.
पेनल्टी में 5-6 लाइनें पढ़ो उसकी निकालना जरा 2015. सर क्या citation है इसकी 2015 volume?
2015 volume 6.
देना जरा digest देना 2000. मैम क्या इसकी citation है?
2015 volume 5 SCC 423.
अपना मैंने बोला था प्लीज रीड पैरा 29. बुक्स आपके पास होती नहीं है कभी भी
में
तो यही तो प्रॉब्लम है.
माय लॉर्ड में
अकॉर्डिंगली मैं सुन लो उर्दू में समझते हैं ना
जी.
अकॉर्डिंगली वी आंसर द क्वेश्चन रेफर्ड एज फॉलोज
जी.
जुडिशियल ऑर्डर्स ऑफ सिविल कोर्ट यहाँ तो आप क्रिमिनल में आगे हुए हैं आर नॉट एमिनेबल टू रिट जुरिस्डिक्शन अंडर आर्टिकल 226 ऑफ द कॉन्स्टिट्यूशन ऑफ
इंडिया.
So judicial order is not amenable under Article 226.
But my lord,
you are aggrieved by the order, challenge it under 482.
I have challenged under 227 of the Constitution of India, my lord. The Honorable High Court is
27 नहीं लगेगा ना दोस्त मैं आप 226
मैं जनाब के एक जजमेंट पे आया हूँ जी. मदन लाल जजमेंट में जनाब ने एक वो किया था कि जी इंक्रोचमेंट का केस था जिसमें स्टेट बोल रही थी थी कि ये पर्सन जो है इंक्रोच करके बैठा हुआ है। जनाब ने मदन लाल में बोला था जी कि राइट टू एसेस वाटर एंड इलेक्ट्रिसिटी इज फंडामेंटल पार्ट ऑफ माय लॉर्ड में काइंडली है बिकॉज माय लॉर्ड माय हस्बैंड इज वर्किंग इन
Dismissed.
then my lord may kindly grant me liberty to move an application because of the fact my lord article 4 section 482 of
Article 20 बिस्लरी खरीद लो,
डिक्शनरी पर यहाँ पे
बिस्लरी।
मैं वो खरीद लूंगा जी बट माय लॉर्ड में
There is a serious
पानी
problem.
का सोर्स ही नहीं दे रहे हैं जी, पानी का सोर्स ही नहीं, मेरे को 30 किलोमीटर आगे से पानी लाना पड़ रहा है जी।
Appreciate. We are not sitting here in a sentimental mood. We are sitting here in a judicial mood. Please read the prayers. You are seeking the quashing of an order that has been passed by.
Lord, I have also seek the prayer, my lord, that is prayer number 1.
I am dismissing it.
My lord, may kindly have the prayer number 1, my lord. She is single lady, my lord. Her husband is working in ITPP, my lord, but the person are restraining her from SS to what?
It is a single lady, dear. What do you mean that she is a single lady?
My lord, वो अपने घर में अकेले रहती है जी, इनकी वो हस्बैंड जो है वो ITPP में जो, my lord, may kindly have the prayer number 1, my lord. Prayer number 1, my lord.
I am dismissing it. लिखो सर इसमें.
My lord,
I have this writ petition.
then my lord may kindly grant me liberty under section 482 because 482 for
But you,
challenging.
why do you people take your clients for a ride?
No, my lord.
No, sorry. You take your clients for a ride. Please read the order passed by the. Please read. पहले तो आप अपनी prayer clause पढ़ो.
Prayer class, but
पूरी हो गया हुआ है.
my lord, this honorable के मैं कल
ना D पढ़ो D.
D तो मैं इसको बोल रहा हूँ जी कि question set aside कर
Can
दे.
it be done?
My lord,
Are the reliefs correlated or not? ये should I take it? That, just listen to the query of the court. Should I take it that ये रामगोपाल वर्मा की डरना जरूरी है या डरना मना है, जिसमें एक ही मूवी में there are 7 different stories. देखिए movies. There are 7 different stories which are not related to each other.
पर मैं एक और
Sorry, sir, all the reliefs are interrelated. Your reliefs are interrelated. These matters have gone up to the learned judicial officer. They have adjudicated rightly or wrongly in your favor or against you. If you are aggrieved by that order, challenge it in consonance with law. How can you directly come to the High Court challenging the judicial orders in the GARP Article 1, Article 21?
my lord, I am on the point of my lord's only judgment, my lord, where my lord has says the कि
इसमें लिखना, in the light of the prayers made in the writ petition, after making the submission of some time, learned counsel for the petitioner prays for is permitted to withdraw the petition so that the order passed by the court of
learned additional district and session.
learned additional session judge to Shimla camp at Thug can be assailed in accordance with that.
Then liberty may kindly be granted.
Don't take it otherwise. ये interlinked, दो चीजें interlinked होती
पर my lord मैं
हैं. Let us take a case. मैं आपको वैसे बोलूं.
बिल्कुल जी.
Let us take a case tomorrow. You file a civil suit of injunction
Please, your lord.
against your neighbor
Please.
that he be injuncted from disturbing my light, air, etc., etc. Civil court refuses to grant you injunction. Interim. Will you come to the High Court?
But my lord,
Filling the order, Article 21.
नहीं जी, यहाँ पे एक क्वेश्चन है जी, नेचुरल सोर्स ऑफ वाटर which our हाई कोर्ट ऑलरेडी सेटल इन द.
मैं विड्रॉ कर दूंगा ऑर्डर.
नहीं जी, हाई कोर्ट के ने बोला हुआ है जी नेचुरल सोर्स किसी इंडिविजुअल का नहीं है जी, दे आर इंक्रोचिंग ओवर द नेचुरल सोर्स ऑफ वाटर, my lord. My grievance is that
Yes, please. Ramlal Thakur.
I am elected president of Gram Panchayat Nachir Bangla.
Yes.
My lord, respondent number 5 passed a suspension order, my lord, without hearing, personal hearing the petitioner, my lord. And after that, I assailed that order before Deputy Commissioner, and Deputy Commissioner passed non-speaking order, my lord, at page 90, my lord, typed copy. कुछ भी नहीं इसमें लिखा, my lord. My appeal under section 148 of the HP Panchayati Raj along with the stay application against the order of suspension of Uma Devi, Gram Panchayat Nachir Bangla, Tehsil Palampur District Kangra, Block Development Officer Palampur District Kangra, HP dated 12 March 2000.
You challenge the order passed by the Deputy Commissioner.
My lord, my lord,
Now that order has merged in the order of Divisional Commissioner.
my lord,
Please read the order of Divisional Commissioner.
my lord. Divisional Commissioner, my lord, relevant page, my lord, at page number 24. जिसमें मेरे खिलाफ एलिगेशन गया, रिप्रेजेंटेटिव ऑफ रिस्पोंडेंट नंबर 1, Jasveer Singh, Junior Assistant DPO Kangra, stated that no scheme has been implemented by the revisionist. Only 2% fund after 15th Finance Commission have been spent till date. Further stated that as per record, there is 39 work schemes sanctioned from the year 2022-23 and not started yet by the revisionist. Video concerned issued letter to the revisionist and revisionist not replied these letter, not taken any action on the pending work schemes, hence action initiated. Preliminary inquiry conducted and received in DPO District Panchayat Officer Kangra on dated.
Read the statutory provisions
My lord,
which provide for how a person is to be put under suspension.
my lord, my lord. पहले तो मैं ये बोलना चाहूँ मेरे खिलाफ
ये कहानियां नहीं सुननी में
my lord, my lord.
स्टैट्यूटरी प्रोविजन पढ़ाओ पंचायती राज एक्ट
145 my lord.
प्लीज रीड इट नजर देना प्रेरणा देना जरा यस प्लीज
My lord, 145 section 2A my lord.
किसी ने आपके खिलाफ कंप्लेंट की
My lord,
सुन लो ना
my lord,
किसी ने आपके खिलाफ कंप्लेंट की
my lord,
फिर उसमें एक प्रीलिमिनरी इंक्वायरी हुई होगी
my lord. Preliminary
एसोसिएटेड विद द प्रीलिमिनरी इंक्वायरी
no my lord.
नो
और second thing my lord,
द ऑर्डर आर टू द कॉन्ट्रैक्ट
my lord. Second thing my lord, जिन्होंने कंप्लेंट की 4 लोगों ने वो भी उस इंक्वायरी में आए नहीं, प्रेजेंट ही नहीं हुए.
kindly appreciate what are the requirements of placing someone under suspension. Please read it.
My lord, suspension my lord.
Please read.
The prescribed authority may suspend from the office of C my lord. C, where the complaint made against him the preliminary inquiry prima facie disclosed the misappropriation, but I am not misappropriate at any fund my lord, misutilization or embezzlement of panchayat fund, or he has been found guilty of misconduct in the discharge of his duty. That providing any officer bearer if placed under suspension against whom charge have been framed in any criminal proceeding under clause A shall remain under suspension till the final decision of the competent court.
Please read the order of suspension.
My lord. E1 my lord, page.
Pado, kindly read it.
My lord. यह खंड विकास अधिकारी विकास भवारना वर्तमान में पालमपुर कार्यालय पत्र संख्या 67 माध्यम से प्रधान ग्राम पंचायत नछीर बंदला विकास खंड पालमपुर द्वारा विभागीय आदेशों की अवहेलना करने व पंचायत के विकास कार्यों को निष्पादित न करने संबंधी रिपोर्ट इस कार्यालय में प्राप्त हुई, जिसका अवलोकन करने पर पाया गया कि श्रीमती उमा देवी प्रधान नछीर बंदला अपने कर्तव्यों के निर्वहन में अवचार की दोषी पाई गई है। प्राथमिक जांच रिपोर्ट के अनुसार ग्राम पंचायत नछीर बंदला में 15वां वित्त आयोग मनरेगा व अन्य मदों के विकास कार्य 1 वर्ष से लंबित चल रहे हैं, के निष्पादन हेतु उन्हें खंड विकास कार्यालय द्वारा खंड स्तर पर की गई समीक्षा बैठकों में श्रीमती उमा देवी प्रधान ग्राम पंचायत नछीर बंदला को कई बार निर्देश दिए गए हैं। इस संबंध में खंड विकास अधिकारी विकास खंड भवारना के कार्यालय पत्र संख्या 8523 दिनांक 13/9/2023 को पत्र जारी संख्या प्रधान द्वारा स्पष्टीकरण मांगा गया था, किंतु उसके द्वारा स्पष्टीकरण का कोई उत्तर नहीं दिया गया माय लॉर्ड, जबकि डिविजनल कमिश्नर के ऑर्डर में इन्होंने माना है कि मैंने उत्तर दिया था। इसके अतिरिक्त खंड विकास अधिकारी भवारना के कार्यालय पत्र दिनांक 29 फरवरी 2024 को खंड विकास अधिकारी विकास खंड पालमपुर के कार्यालय पत्र संख्या मार्च 24, मई 24, मई 24 एंड 6/6/24 और इसके द्वारा 15वां वित्त
Notice reply. 3 weeks list on dash.
My lord, kindly entry may be granted. My lord, my fact is similar to my lord. I have delivered the judgment and CW 250.
Then file a reply. We'll see. 3 weeks. Actually,
My lord, तब तक मेरा कार्यकाल पूरा हो जाएगा my lord. 2 weeks कर दे my lord.
when was the order passed by the divisional commissioner?
My lord 11 अप्रैल में.
तो आने में आपने मेहरबान देर कर दी.
My lord, certified copy मई में मिली my lord.
राजेश कुमार.
My lord, kindly
3 weeks. Next, Ramesh Kumar.
My lord, I have approached this one court with a opposed request, my lord. My lord, in this case, my lord may see, I have made representations to them.
Who are you?
I'm an alumni of the college, and because the B.Ed was running, everybody understood that this B.Ed is being run by the government, my lord, government college.
What is your locus? What is the locus to file and maintain this?
My lord, the only thing is that the standard of the education.
No, sorry, you don't have any locus. Who are you in life?
I'm an alumni of this.
Alumni. I'm also an alumni of St. Edward School. But can I come to this?
Yes,
Just listen.
because
In my capacity as an alumni,
please, lord,
let us say I'm an alumni of Himachal University.
please, lord.
Can I raise an issue relating to chemistry?
My lord, only one submission. One submission. My lord, may see, I made representations to them. They considered. They sent back me the letters, and once these letters were sent back to me, because in the appellate authority send it back to the NCT. The decision has to be taken because the recognition was withdrawn. It was already withdrawn, and it was withdrawn on the count that 16 teachers are required for running the B.Ed course.
You see, you are a busybody.
No,
No, sorry. या तो आपके कंधे पे बंदूक रख के ये इंस्टीट्यूट को चला रहा है.
इंस्टीट्यूट से तो कोई है ही नहीं जी. हाँ, इंस्टीट्यूट से तो कोई है ही नहीं. The only thing is because what
No one.
because what is either I can file a stating therein.
No, that the division bench will see whether you have locus.
Yes.
According to me, you don't have any locus.
So my lords may permit me to withdraw to avail the.
No, I'm not allowing you to withdraw.
No, then I will not be in a position to file that also.
मैं नहीं कह रहा हूँ.
जी.
I'm not even remotely suggesting. According to me, you don't have any locus to maintain the retreat.
So that is why I'm saying, because my lords have come to this conclusion, I may be permitted to withdraw.
Without liberty.
नहीं, liberty वो तो मैं
Merit पे उड़ा दूंगा.
नहीं, merit पे तो उसमें ये रहेगा.
पे उड़ाऊंगा मैं.
Then my lords may simply have it at 2, my lord.
2 p.m. Okay.
हाँ जी.
1:60.
हाँ जी.
1:60.
1:62.
2 बजे नहीं लूंगा.
हाँ जी.
2 बजे नहीं. 1:60.
1:62.
बस. ये नहीं है. No.
नहीं, वो actually
So you see, Mr.
नहीं, मैं वही बता रहा हूँ.
किसको दिया हुआ है?
किसको जी?
Locus किसको दिया हुआ है?
कॉलेज में.
वो हाँ जी.
आप कौन?
नहीं, वही मैं बोल रहा हूँ. एक चीज जो इसमें बड़ी इंपॉर्टेंट है ना जी. So the only thing which I am bringing to notice of this on court, that our college is showing the teachers who are teaching in some other colleges,
No.
other colleges.
That is not. Ramesh Kumar Ranak, Vivek Negi. Yes, please.
So in fact, an agreement was executed between the petitioner and a private, between respondent number 2, my lord. There certain disputes arose and our matter was referred to arbitration, my lord, at Delhi. There the arbitrator has held that the document is not stamped and it needs to be stamped, my lord. An order has been passed in view of the judgment passed by the Honorable Supreme Court in 2024, volume 6, page 1, my lord. That the document would be inadmissible in evidence, but will not be void, my lord. Therefore, it has to be stamped. So we approached the deputy commissioner that it may be stamped. Both the parties would be present there, but he is not taking any call on that.
दो को आपको दस्ती सर्व कराना पड़ेगा if you want earlier.
We will have him.
Notice एक के लिए notice, 2 को दस्ती छुट्टियों के बाद. ठीक है सर? Return for 17th. Steps by tomorrow.
कर देंगे.
Steps by tomorrow. Dusty notices be handed over to the learned counsel by Monday.
Pardon?
Dusty notices be handed over by Monday.
ठीक है.
16th को.
ठीक.
Learned Additional Advocate General to have instructions on the issue of the next letter. Hitinder Verma. Yes, Verma ji.
Lord, in fact, this is a case where grant of a mining lease has been given on a private rights of the private stakeholders, and I am one of the co-sharers without the land being partitioned and without any objection. Before I proceed, my lord, may I seek your lordship's indulgence, because I was not here in the court yesterday, my lord, because of some urgency, medical urgency.
Let us see है क्या case क्या है. These are small issues.
I will just assist your court because I'm very keen to do this case.
These 6 साल पुरानी writs and
Perhaps because I was not here yesterday.
let us see है क्या. We'll study together.
Any event, Lord, I may give the summary. In fact, a mining lease was granted in favor of the respondent number 10, and that mining lease was pertaining to one khasar number 997, which was unpartitioned. And as per the statutory rules, my lord, he was required to obtain consent of the private stakeholders because this khasra number pertained to more than 80 persons having rights in the property. So he obtained certain no objections and consent from the private stakeholders, but not from me and not from very many others. And I categorically state that the land was never partitioned, and I have every right over every inch of land till it was partitioned. And authorities, without verifying that the sale has taken place and the land has traveled to me, and I am having the equal stakes over the land, without my consent, the sale was this lease was granted. This I say.
So the mining lease has been granted to the private respondent on which khasra numbers?
997.
997.
Oblique 3.
Oblique 3.
3.
So
Show me from the writ petition
yes, ma'am.
documents appended therewith that you are a co-sharer as far as this land.
Yes, ma'am. This is this is P2
कौन सा P2?
of the writ petition,
हाँ,
Page 19.
page 90.
page 19.
कहाँ जैसे मिस्टर जीवन?
ये जी.
What is the name of the petitioner?
This is Vijay Kumar. शुरू में लिखा हुआ है. This is 3780 भाग विला हिस्सादार विजय कुमार पुत्र शेर सिंह पुत्र महेशा.
Who is the private respondent?
Your Lordship, I'm hearing.
This is
क्या नाम?
number 10.
Anil Kumar.
Anil Kumar.
He was also co-sharer or
He succeeded his father because his father's.
father was a co-sharer?
Yes.
Yes, what is your stand?
Your Lordship, my submission is that they had, I applied for the mining lease in 2009. At that very point of time, he was a stranger to this land. He has not obtained any right in this land, Your Lordship.
When was the last time mining lease was granted to you?
Yes, Your Lordship.
When was the last mining lease
In
granted?
year 2011.
Let us see that. Challenge कौन सी की हुई आपने मिस्टर जीवन?
वही जी,
हमने वही की
15 साल के लिए मिली थी ना जी.
कौन सी 2011?
2011.
Show me that annexure. Where is the mining lease?
Sir.
रिप्लाई के साथ लगाई है आपने?
एक मिनट.
नहीं जी.
पेज 24.
P4 is
वो तो joint.
this is a joint inspection report.
Okay. Now Mr. जीवन,
My lord.
ये कह रहे हैं कि जो माइनिंग लीज है ना 2011 में मिली थी.
जी.
He says that you were a stranger as on the date when the mining lease was granted. Is it a fact?
Lord, no.
Did you become?
ये नहीं बोल रहा हूँ, ये नहीं बोल रहा हूँ.
हाँ.
मैं बोल रहा हूँ जब मैंने अप्लाई किया था in year 2009, at the time of applying for mining lease, Your Lordship, he was a complete stranger. He purchased the land prior 2 days prior to granting of the lease to me, Your Lordship. I applied in year 2009. I took an NOC from the panchayat. I took an NOC from the.
If it is a fact that you purchased the land 2 days before the
Yes, Your Lordship.
start of the lease, इनको सपना थोड़ी आ रहा था कि कोई और बंदा भी आ रहा है.
Lord, what I'm submitting, that if your lordship have a look at page 6 of the reply, filed by respondent number 4, 6, and 7. Yes. And another reply of respondents number 1 to 3, that is the relevant department which had granted. It is page 3.
Order number 1 simply says that in the Jamabandi which was
Yes, submit.
submitted by him,
May I submit?
our name was not there. That is their.
Can I submit? Page 3. Page 3, first paragraph. It is second paragraph. It is further pertinent to mention here that as per the condition number 1, the grant order dated 20th of April 2011, the respondent number 10 submitted the fresh revenue record, that is the Jamabandi of the year 2007, 2008, and Tatima duly attested by the concerned Kanungo as on 18/4/11, Lord. 18/4/11, Lord, in the office of respondent. He was called upon on 22nd April 2011 to submit the updated.
When did you buy the land?
25th of April 2011. 24th of
20?
24th of April 2011.
And lease deed कब execute हुई है?
10th June 2011. 10th of June 2011. He was
He purchased the land on 20th April 2011.
yes.
And the grant order issued for me, to me, your lordship, is on 22nd April 2011.
But he must have purchased the land from someone.
Yes, your
Had
lordship.
he given a no objection certificate?
Yes, your lordship. In my favor.
Then
Suresh Kumar ji.
he had given a no objection certificate. Enter into his or her foot.
Please, your lordship.
May I submit one thing, Lord? Because to satisfy the things, on 22nd of April, rightly the department called upon him to provide the updated revenue documents.
I'm not interested.
Lord,
No, sorry. Mr. Jeevan, issue is very simple. Issue is this. He applies for the grant of mining in 2009. In terms of the provisions of that particular mining policy, etc., he was supposed to give the NOCs.
yes, Lord.
He gives the NOCs of everyone
Yes.
to purchase the land. Now, if your predecessor has given the NOC, you enter into the footsteps of that person.
My Lord, what I'm submitting, that on 22nd of April 2011, the Department of Industries, with a view
Forget
to
the
ensure, that
Even-
as on that day,
even you
as
are
on that day,
you are in a constitutional court. Forget the Department of Industries. We are on the issue of equity.
yes, Lord.
We are on the issue of equity. You appear to be someone who now wants to put a spike in.
Lord,
Yes,
I cannot put a spanner there. I cannot.
Not doing that.
I cannot. Lord, what I'm submitting, I write only accrued.
I'll pose you a question. Answer is yes. Answer should be in yes or no from your instructing counsel. Is it a fact that your predecessor in interest had given a no objection certificate when he applied for the grant of lease?
Yes,
Khatam.
yes,
Then
Lord.
the answer is yes. Then as
Submit.
petition is concerned, it is dismissed.
With due deference to what is falling from the bench, I'll be just responding it. That while processing his case on 22nd of April 2011, the sanctioning authority, with a view to satisfy itself with regard to the updation of the Jamabandis as prevailing on that day, called upon him.
आपका है कब तक है?
26 तक है।
अगले साल सुनेंगे इसको. Let the period go by. Admitted है नहीं है?
नहीं है जी।
Admit नहीं.
Admit. Post admission notice list in due course. अब इसके बाद आओ. Interim तो नहीं है ना?
नहीं है,
Interim, there is no interim.
Rejected है क्या है?
नहीं है जी।
इसमें हमने प्रे भी नहीं किया था.
तो इसमें देखते हैं राजीव.
All eyes be yours.
I would have interfered had your predecessor in interest not given a notice.
Yeah.
And immediately इसमें जो कर देना था. But
Due deference to what is falling from the bench, Lord, the cause of action accrued to us when the department called upon him to provide the updated. Everything vanished into insignificance.
even court can always lift the wheel and see what is behind all this. ये सारा ड्रामा होता है सर. हो गया, अब एडमिट हो गया. Yes, Deepak.
Actually, by the directions of my lord, we have received the instruction also. As per the instruction also, we have paid all the payment. अब हमने ले लिए जी 14 लाख, 11 लाख सोई लॉर्डशिप.
Date mention is 11/1/2020.
तो भी है ना सर. These are disputed issues. That is what-
बिल जो अप्रूव करे हैं वो
No, sorry. That is what I am objecting to, Mr. Kumar.
बिल्कुल.
That is
ये मेरी और कोई कंडीशन.
मैं आपको ना, I'm just closing this file and keeping it here. Mr. Baba is sitting there.
हाँ
He was the advocate general. अगर आपने 3 करोड़ की रिकवरी का सूट फाइल करना है, एड वैलोरम कितनी कोर्ट फी पे करेंगे?
इन
स्टेट से बड़ा मूर्ख मैंने नहीं देखा. Hundreds of cases are coming in the High Court under Article 226. Mandamuses are being requested for, prayed for. Release 2 crore rupees, release 3 crore rupees. What about the court fee?
नहीं, और केसेस में ऐसा हो रहा है जी कि वो कोर्ट फीस का वो है बार में.
ये नहीं है.
नहीं, बार में
I have my very serious issue regard to the invocation of this jurisdiction by us. Go to the civil court.
There are many judgments, my lord.
मैं कुछ बोल नहीं सकता ना.
I'm gonna keep it next week. I'll
तो withdraw करो with liberty.
मैं verify कर लेता हूँ जिसको.
मैं कह रहा हूँ with you.
नहीं मैं
Additional advocate general.
जो ना 23 का वो कर रखा है.
So Deepak, point is very simple. All this becomes disputed, and once the facts are disputed, High Court cannot exercise under its jurisdiction under Article 226. This is the first principle.
बिल्कुल जी, मैं बिल्कुल ठीक बोल रहे हैं जी. मैं सिर्फ ये प्रे कर रहा हूँ जी. Let them put it on affidavit. अगर if it
इतना सा affidavit दे दो.
हाँ.
Learned additional advocate general submits that. As per the instructions which have been received from Executive Engineer B&R Division, HP PWD Joginder Nagar, as of today, nothing is due from the respondent to the petitioner. However, recoveries
My lord will kindly see last 4 lines. Now the balance amount to
thing is
the contract.
कैसे लिखना क्या लिखा आपने? The balance amount which is payable to the contractor is rupees 3,19,260. However, this amount is to be adjusted against recovery of rupees 15 lakh, which is to be effected from the by the respondent. The senior counsel for the petitioner submits that let this be put on affidavit, be put on record by way of affidavit. Learned additional advocate general submits 2 weeks time be granted to do the next. Yes, please. Who will address the argument first? You will address.
Yes, ma'am.
Yes, yes.
Filed by the DGP.
I have read it. I have read the affidavit filed by the Director General of Police.
Yes, sir.
I have also thoroughly gone through the inquiry report submitted by the ACS. So I need not hand it over to you, but after adjudication of this petition, I'll make it part of the record, so it will be available. It will be available.
So only thing is that since still we have not taken a
I'll place it on record update.
because it is Malad only for perusal of the honorable court. My objection would be that the report is to be considered by the government one way or the other. Malad, during these proceedings, when
you see, my job is only to take a call
not sure.
as to whether the investigation
Yes, in a fair manner or not.
In a fair manner or not.
Therefore, I am saying that
1 minute. I am not sitting here to give any certificate of guilt or non-guilt to anyone. I am not
no medals to anyone or no medals to guilt on
adjudicating upon the allegations which are being leveled by the petitioner. My job is to simply see as to whether the apprehension of the petitioner that the not being carried out in a fair manner are correct or incorrect.
Yes, sir. So therefore, I am
finally hearing the case today. Prima facie, I may say so that the affidavits which are on record, more so that of the DGP, demonstrates that everything is being hushed up for the reasons that are best known to you.
I'll explain everything of affidavit of DGP.
Let us start with the affidavit of DGP. DGP has gone to the extent of saying that officers who are insubordinate to him, they are not listening to him. They are not appearing before him. They are not giving the requisite information to him.
This may be his incomplete.
Then on the basis of the report he has received from FSL, he goes to say that after the receipt of that particular pen drive जो है, उसको इन्होंने 22/3 या कौन सी डेट है, उसको क्लीन किया हुआ इन्होंने. उसके बाद उन्होंने he has referred to the conversation recorded of 3 or 4 constables. कि वो मैं नाम इसमें लिखा हुआ है.
Pankaj is one of the.
So all this.
I'll explain all.
Very serious.
I'll explain all this. DGP has committed a mistake by relying on. He said in bold letters that SIT has committed a mistake.
Judgment of the Supreme Court.
No, which SIT has committed a mistake? That is a issue before my lordship. I'll explain all those issues.
It's not an issue before me.
Yes, your lordship.
Before me, the issue.
Therefore, the SIT was changed
as to whether
Therefore, the SIT was changed immediately. If I may start the explanations each, because if my learned friend wants to point out anything of the investigation,
Yes, Lordship.
let us
let
us hear Mr. Bawa, then I'll hear.
Yes,
I will
sir.
just read the affidavit and thereafter I will go on. Lordship can have.
First of all, Mr. Bawa, let us see as to what is the main issue being raised by the petition.
Yes, Lord.
In
Lordship.
your own words.
Yes, Lord. Lordship can have the petition, my Lord.
यार मेरा पैड लाना अंदर मेरा आईपैड होगा there is a judgment of the honorable supreme court. Honorable Supreme Court has given a judgment of April 2025. अंदर से मेरा पैड देना मैम 2nd of January की 2nd of April 2025 की जजमेंट है मैं आपको साइटेशन देता हूँ निकालो मेरा पैड होगा उसमें विवेक अग्रवाल वर्सेस स्टेट ऑफ हरियाणा या क्या है नहीं some Agarwal versus state of I've read it
Gone to the extent that every case should not be given to the
exactly
this doesn't fall within
this is my lord, we have brought 4 judgments.
and
this is the constitutional bench.
One constitutional bench is.
The other judgments are also there.
Main is this constitutional bench, para number 70, 2010, State of West Bengal.
Yes, State of West Bengal versus Democratic.
Yeah, exactly. Sir, this is Vinay Agarwal.
Para 70.
Vinay Agarwal versus State of Haryana, 2025 Supreme Court cases online SC 704.
That is in the
Instructing counsel का काम अब हमारे को करना पड़ता है.
नहीं, we have already managed.
कोई बात नहीं.
For such important matters, you should be on your.
Yes, Lord.
You have to burn some midnight oil.
मैं रात को 3 बजे तक पढ़ता रहता सर.
ये आपको नहीं बोल रहा था.
मेरे को तो मिली 8 बजे.
इसी counsel को कह रहा हूँ. I'm 100% sure you and learned AG have done their job. But what about the youngsters?
नहीं ये लड़का तो बेचारा अभिनव तो he is very quick.
Yes, Mr.
No, Lordship can have my writ petition, my Lord. I specifically said in para A of the grounds of the petition.
Let us have a few facts also.
Yes, Lordship. Facts are, my Lord, that the deceased, my Lord, he was reported missing from 10th March to 2025, my Lord.
Just one.
Vipul Agrawal is Delhi High Court.
Vipul नहीं है, मैं आपको देता हूँ.
That is मारे तिवारी, विशाल तिवारी.
I'll just hand it over. This is Vinay.
Vinay Agarwal के facts
नहीं, facts are different. वो तो उसमें there was this person who was imposing as a DG, Director General of Police.
Yes.
देना ही.
एक मिनट देना.
उसमें सुप्रीम कोर्ट ने बोला कि the high courts under article 226 rather the constitutional courts have got the jurisdiction to refer to CBI but provided they fulfill the touchstone that have been laid down by the honorable constitutional bench
in 2010. In 2010.
2000.
That is done.
Para 70 ये है.
Yes, sir.
इसमें they have relied upon 2010 and 2002 दो judgment.
Rare and exceptional circumstances.
Yes, sir.
Now the facts are, my Lord, this that the deceased he was missing from 10th March to 2025, my Lord.
Okay.
Then they had a launching report, and
at the relevant time he was serving as a chief engineer cum general manager.
Chief engineer of the general manager of the HPCC. He was on secondment or deputation to the HPCC.
The deputation. HPPCL.
Yes, Lord. He was holding all the
parent department HPSCB.
PSCB.
Okay. He went to this PCL in June 24 or kab?
June 24.
He came to headquarters on June 24. Prior to that, he was in deputation, but he was looking after the Shongtong project.
The Power
Corporation, but it is in Kinnaur itself. For the first time, he was given the charge of energy resources when he joined in the in June 2024. Headquarters. So he was handling the charge of 15 June, my learned friend is correcting the date. Handling the charge of renewal, General Manager, Renewable Energy Sources. This is correct?
In June 24
Yes, Your Lordship.
as General Manager.
And the charge was of renewable energy. Yes.
Renewable energy पूरा क्या है हमिंदर?
General Manager
Electrical.
oblique renewable energy.
General Manager Electrical.
Oblique renewable energy.
Okay. GM Electrical oblique renewable energy. Okay, sir. Yes, Mr. Babu.
One of the fact is at the moment he came here on 2nd June, he was given the charge of this Peku Villa.
No. Sir, एक मिनट पेन देना मेरे मिस्टर लेट हिम से जो आपने कहना होगा यू में कंट्रोवर्टेड आप लिखते जाना है ना व्हाटएवर इज
So these
he was given the charge of
Peku Villa, madam.
Peku
Villa project.
you have the spelling of
PEKHU
PEKHU PEKHU कहाँ पे था डिस्ट्रिक्ट
No.
ओके ये हाइड्रो प्रोजेक्ट है सर
नहीं सर, it's a solar power renewable energy project.
सोलर पावर प्रोजेक्ट
Solar power project, renewable energy project of the state.
सोलर पावर कितने मेगावाट
32 megawatts.
32
ये 32 megawatt का जी.
ओके
And one of our contention is that Peku Villa is a 32 megawatt and it was awarded for 220 crores. And in Gujarat, 135 megawatt was awarded for 144.
ओके
Now he went missing on 10th, my lord. Then missing lodged, and on 18th March 2025, his body was recovered.
Yes.
And when the body was recovered, my lord, the serious doubts were raised. And before that, my lord,
was the body recovered sir
on 18th March. And my lord, between 10th and 18th,
on 18th sir
on 18th March,
कहाँ पे सर
ये मिली जी गहार.
at GAHA
हाँ जी जी.
क्योंकि उसको वो requirement
ओके
So my lord, in between this 10th,
बिलासपुर
now in between this 10th and 18th, my lord, the wife of the petitioner visited the office of the authorities and reported that husband is missing. My written representation was made that they are not doing anything, and thereafter on the representation of that is already on record, my lord, dated 18th March 2005, my P1, my lord.
ये वाला इधर मेरा ड्रॉस खोल के ना उससे 3-4 नए वाले पेन उनको पता है नेक्स्ट प्रेजेंटेशन यस
Also got it, man?
यस
And in the
so Baba before we proceed further please call either way I'll like to plead Union of India at this
yeah, at my
please call Mr. Balram Sharma sir Balram Sharma will
probably CBI or some other councils. Jayesh Mal. If my lord want to plead CBI,
दोनों को न कर दे
जो
Union of India has no role, lordship. Then it's a
Mahajan, Mr. Mahajan and Balram may be gone.
उनको कर देते हैं उनको फीस लेने दो
Balram and Mahajan.
In the course of the hearing of this petition and in the light of the clears that have been made by the petitioner, this court is of the considered view that Union of India through Home से ही होगा through Ministry of Home and the Central Bureau of Investigation through through Superintendent of Police Shimla are necessary parties. On request of the London Council for the petitioner, they are added as respondents 5 and 6. Mr. Balram Sharma and Senior, Deputy Solicitor General of India, waive service on behalf of respondent number 5. Mr. Janesh Mahajan, waive service on behalf of respondent number 6. The registry to make available the paper books to the Learned Council. आप दे देना sir.
मैं दे दूँ.
Learned Council for the petitioner undertakes to supply paper books to the Learned Council during the course of the. बस बैठ जाओ. Yes. P1 is the representative.
P1, madam. Second para of the P1 may can be seen. Lordship got it, man.
Yes.
आज दिनांक 18/3/25 को उनका पार्थिव शरीर जिला बिलासपुर के बाकड़ा डैम में होने की सूचना मिली है. मैंने अप्रूव पत्रों के माध्यम से पहले ही सूचित किया था कि मेरे पति विगत 6 माह से यहाँ से पावर कॉर्पोरेशन के उच्च अधिकारियों विशेषकर देशराज निर्देशक विद्युत
No, Mr. Baba, this is a representation made on, this is Thana Grah Adhikari SHO New Shimla.
Yes, yes.
You said,
We call it complaint or represent.
नहीं, आपने बोला था कि after the gentleman went missing,
हाँ जी.
till the body was recovered, उसके बीच में भी representations दी थी, वो कहाँ है?
उससे पहले वाला भी है क्या? पर we have not an expert.
No problem. Yes.
मैंने उपरोक्त पत्रों के माध्यम से पहले ही सूचित किया था कि मेरे पति विगत 6 माह से पावर कॉर्पोरेशन के उच्च अधिकारियों विशेषकर देशराज निर्देशक विद्युत एवं प्रबंध निर्देशक द्वारा मानसिक रूप से प्रताड़ित व दुर्व्यवहार किया जा रहा था। उन्हें उक्त अधिकारियों द्वारा जानबूझकर रात को देर तक किया जा रहा था। बीमार होने के बावजूद भी चिकित्सा हेतु इलाज नहीं दिया जा रहा था। बार बार प्रशासनिक कार्रवाई की धमकी दी जा रही थी। इसके परिणाम स्वरूप उन्होंने अपने जीवन को समाप्त कर दिया है। रखते हुए निवेदन है कि आप उपरोक्त खिलाफ आपराधिक षड्यंत्र व आत्महत्या को मजबूत करने हेतु आपराधिक मामला दर्ज करें। Now this was the there. Then FIR.
Yes.
P2, my lord.
Yes.
FIR has been registered, my lord. Before that, they don't do anything. At the foot of this representation, my lord, you can see presented on dated 18/25 at 11:32 p.m. To Shri Sundar Negi, son of Shri so and so, resident of so and so. And on the basis of this, they registered the FIR, my lord. Now FIR is P2, my lord. And prior to that, P2 का मजमून जो है ये पेज 30 पर जी। इसमें दर्ज है कि शिकायतकर्ता श्रीमती किरण नेगी पत्नी स्वर्गीय श्री मुख्य अभियंता सोनसो निवासी गांव सोनसो का एक शिकायत पत्र में संलग्न कागजात के थाना प्राप्त हुआ है। मजमून जेल है। देन दे रिपीट दिस एंड देयर आफ्टर द दर्ज कर शीघ्र
This FIR is registered against unknown persons under section 108.
that is what I want to point out.
108 and
the 108 and this 53 my lord of the BNS. 35 of the BNS.
Section 3 subsection 5.
Within 5, हाँ जी, subsection 5.
Then sir.
Then Lordship will kindly at this stage, my lord, in the FIR the names are given, and while recording the FIR they are saying अज्ञात पर्सनों के खिलाफ from the very beginning.
Okay.
By name is there. They had been doing it, and they are saying कि अज्ञात लोगों के खिलाफ किया जी.
ठीक है.
From the very beginning, doing all these things, my lord. They are not fair to me, my lord. And my lord, thereafter, what happened? That then the postmortem was this Panchanama was done when this was this body was recovered, my lord. Then this pen drive and other things on the body of the deceased, my lord, they were taken into possession, my lord. Then the body was sent to the AIMS for postmortem, my lord. And after the postmortem, my lord, the kindly have the this. Now, as far as the postmortem, in postmortem is conducted on 18th, my lord, 19th. In the postmortem, that will be in possession of my learned friend. They say the date of death is within 5 days from the date of postmortem. Let him deny this fact.
Okay, just one. As per Mr. Baba.
Yes, sir.
Post-mortem report suggests death within 5 days of the recovery.
5 days from the date of postmortem. From the date of postmortem.
Within 5 days from the date of.
Yes, sir.
Within 5 days. Okay.
No, for 19th, 5 days means 14th. So from 10th to 14th, he was alive.
Okay, just 1 minute. So, went missing on 10th, was alive till 14th. Okay.
No, for these 4 days, Lordship, you can see the investigation report which we have already read, my lord, of the SP Shimla. Nothing has been said.
No, but that the question ये है कि where was any missing etc. complaint lodged officially या जिसको
Missing report is there. वो इनके पास है जी, मिसिंग रिपोर्ट
कब जमा कराई?
वो तो हमने उसी दिन कर दी जिस दिन में, हाँ जी
15 बजे भी मंगाया जी फाइल,
जरा ऐसे पता करके बताओ।
एक फाइल मंगा रखी है जी बेनिफिट में।
now these
10th को इवनिंग को 10th
evening, that's what I was saying. You are very fair, sir.
So 10th evening missing report
is there.
कहाँ पे दर्ज हुई थी
ये मैं इसमें थाना सदर में ना, इसमें this is Sadr
Shimla. Yes, Sadr Shimla by the wife. By the wife.
by the मैं तो
HPPCL official.
By HPPCL. By the employer. One cousin. By the employer and one relative. By the employer and one relative. ठीक है. Okay. Then sir.
Now, Lordship, why I am stressing this is, we have already read the status report filed by the SP also, Madam. Nothing has been said by him what happened in between 10th to 14th. We say the possibility of assault, other things that cannot be ruled out. And from the very beginning, they are coming on these assumptions that he has committed a suicide. 306 का case है जी. And they are bent upon to make him a mentally sick and mentally disordered and all that. Now, Lord should kindly have
just 1 minute. Possible.
By DD 41.
DD number
41. Dated 11/3/2020.
10th evening को नहीं हुई है यानी ये
11/3/2025.
11th 11/3/25. क्या DD नंबर क्या है?
41.
Okay. Yes, please.
Then, Your Lordship, the body was recovered, postmortem was conducted. We raised the doubts, my lord. We met the authorities. The matter was pursued, my lord, and thereafter, from the very beginning, the investigation is not fair, my lord. We had been agitating, and we had.
How do you say that the investigation is not fair?
Because of the fact, my lord. The facts which have come to our notice are that I have already demonstrated the FIR, my lord, which is the FIR is there. Then one of the accused, my lord, he came here for grant of bail. The bail was rejected. For days together, he was not arrested.
Who is the accused who came for this?
He was, my lord, Devraj, my lord. Desraj.
And registration Meena.
So whose bail was rejected?
Desraj bail.
By High Court on?
That was rejected on, just give me 1 minute.
26th of April, sir.
I'll give the exact date. 26th of April.
26 April. Okay.
Then, my lord, he was not immediate. He was
rejected or dismissed as withdrawn वगैरह क्या है?
dismissed on merits, my lord.
Merit पे.
Merit पे.
Okay. ठीक है.
Then, Your Lordship, what happened that the man was not arrested and he was given a long time to secure bail from the Supreme Court. And when the matter was listed before the Supreme Court presentation by the state government,
What happened? He was granted bail by the Honorable Supreme.
the result was that till further, till the next date, he was granted the relief.
Where is the order of?
Of course, the order may not be passed.
It is that no course access.
Where is the order? अब हवा में बहस मत करो. Please give the order. Okay. Okay.
My lord, lay my hands on that, my lord. इनके order है ना जी हमारे को इतनी जल्दी मिलते हैं. Then, Your Lordship, what happened? We have meeting the authorities, including the Chief Minister. Now, Chief Minister makes a statement in the House saying that the family is satisfied. Lordship can straight away come to this is page 33, P4. The relevant is
I have given date of 26 March, 25 or April.
हाँ. March है.
March.
तो अपना मोबाइल दे दो मेरे को. अब तो लेकर आओ. Yes. Okay, let us not as far as the proceedings of the assembly are concerned, Mr. Bawa, they may not be all that relevant. What transpired
only to this extent, that we had been agitated.
No, you see,
and the government says that we are satisfied.
Maybe he might have said that the family is satisfied with whatever we are doing. No one will be satisfied who has lost a family member. Let us concentrate on the main issue, that is investigation.
Now, Lordship, you can see, so far as
then come to P3. P3 is relevant. Page 32.
Now they constitute a inquiry committee, madam. Whereas Shri Vimal Negi, General Manager, Himachal Pradesh Power Corporation, has died in an unfortunate circumstances, there are allegations that he was under pressure in his organization. The issue was raised in Vidhan Sabha media and representation.
AG,
Lordship.
On a point of fact, I want to have one information. ये जो special investigating team constitute हुई है, whether in the course of investigation it has taken note of the inquiry conducted by Mr. Onkar Sharma?
Now they are taking, because it is not handy over to, because it is not made public to anyone.
Just 1 minute.
Lordship.
When a crime takes place,
Lordship.
SIT, as far as my limited knowledge is concerned,
Lordship.
SIT is not governed by the nuances or the niceties of whether the inquiry has been accepted or not.
No, it is not made public yet.
There is no question of making it public.
It is not.
No.
Lordship.
You see, SIT or the investigating team or the investigating officer, he has got every right to have access to every document which may help the investigation. Now, it is in public knowledge that after this unfortunate incident takes place, the state had called upon one of its senior officers to hold an inquiry.
Yes, sir. Lordship.
Hold an inquiry.
Yes, sir. Lordship.
Whether that inquiry was accepted or not, SIT is least bothered. Just in order to ensure that SIT was on the right track, minimum that was expected was that they should have had procured a copy of the inquiry report so as to ascertain as to what was contained therein.
That process is going on because investigation is not complete.
हुआ कि नहीं हुआ?
अभी तक तो हो ही नहीं सकता था. This inquiry for the first time is seen by my lords.
No. पहले आप लोगों में देखा.
और उससे पहले लगा नहीं बोल रहे हैं.
SIT did not bother.
No, they could not.
No.
They have not. They are independently doing their work. SIT, Malat.
Mr.
Yes, Your Lordship. This is a fact-finding inquiry, Malat.
Take a case.
Lordship.
That there is an FIR registered against a minister or let us say against a police officer, high-ranking police officer. And there are certain documents which are necessary for the investigating team to have access to carry out the investigation. Will it wait for the nod as to whether the documents have been सीधे जाके छापा मारेगी और कागज कब्जे?
Every document which pertains to because I have the documents, and DGP has also placed on record some documents. Every document which is necessary for investigation.
In this case, issue is very simple. Issue, though I'm not interested in curtailing the contention of the learned senior counsel.
Not sure.
The case of the petitioners is very simple. Their case is that Mr. Vimal Negi lost his life because of the undue coercive pressure that was put upon him by his superior officers of HPP. That is their case.
That is
their allegation.
one allegation.
That is their allegation.
One allegation.
Then the thrust of their contention is that, as he has also argued, that what is now being tried to be converted into a case of suicide might not be a case of suicide, and it may be a case of, and there may be some foul play.
Murder is not at all.
I am not saying that.
Yes, sir.
His contention.
His contention is it is not a suicide.
Now, the purpose as to why the inquiry was, you ordered Omkar Sharma to hold the inquiry was to ascertain as to whether there was any element of correctness in their allegation that there was some pressure exerted on Mr. Negi by his immediate superior.
Unfortunately, what has happened?
Report in so many words points out toward that.
My lord, unfortunately, report says, if my lord said,
why unfortunately?
Unfortunately.
Why the state is so
my lord, what has happened?
Why the state is why are you going out of your what should I say, way to defend the persons?
I am not defending anyone. I am not defending.
You go through the affidavit.
They will defend themselves. I am not. Not sure.
The state. Why I am to go through the affidavit filed by Mr. Omkar Sharma.
Yes, sir.
Section R4 appended therewith.
Yes, sir.
He says that after I submitted my inquiry report, I received a letter from one of the officers that you should have the version of the officers.
Delinquent officer.
Delinquent officer. Under what law?
The fact finding, my lord, permit me to reply. Permit me to reply for 2 minutes.
Both you and I.
Yes, sir.
We are more of service lawyers and service judges than.
Yes, sir. Lordship.
Simple principle of inquiry is that an inquiry is held by an inquiry officer. Inquiry officer submits his reply to the superior officer. Superior officer, after perusing the inquiry, then he
to the charge sheet.
Yes, charge sheet to chodo aap.
Yes.
In my cases, there is no charge sheet. But after the authority received the inquiry report,
Lordship.
Authority could have called upon the officers that, sir, I had ordered an inquiry. This is what has come in the inquiry. This is the inquiry report. Please respond. This is
the one process of to find out the fact. To find out the fact that
की मूवी थी एक ही रास्ता.
हाँ जी हाँ जी.
एक ही रास्ता था इसमें.
एक आखिरी रास्ता भी आई थी इसमें.
वो बड़ी
मूवी रास्ता है जी. If my lord permit me to say.
3 innocent persons.
Yes. Yes.
नाम नहीं याद. You see.
But one only thing I can say, Lordship. Inquiry officer record, which I have gone through, recorded the statements of all parties and said and reached to the conclusion. When the file was placed before the competent authority and the chief secretary was of the opinion that some officers are being asked to be investigated, not only investigated but departmentally proceeded. So those officers must get an opportunity to see the whatever material against them, statements against them, and let those officers submit a reply and inquiry officer.
There was no occasion.
There was the occasion, my lord. Because there is a direct that you either now we have to proceed, accept that we are proceeding in that inquiry report because he has resubmitted it. We are proceeding in a manner that whatever is to be done, whatever his recommendations, either is to be accepted or to be rejected. That call is to be yet to be taken, but we are taking that call. That is not the case that we are not taking.
Let us read the reply filed by Mr. Omkar Sharma.
Yes, Your Lordship.
Your arguments are over, Mr.
No, my lord. I have to add, heraldry I can add, my lord. So far as we have specifically said that this inquiry committee, this Secretary Home, he was appointed as a chairman of the inquiry committee. The inquiry has taken place, and they are not supplying us the copy of the inquiry report. And the inquiry report now, the facts which have emerged now, that shows that the inquiry report has been submitted. They are not supplying me the copy, nor they are proceeding further.
No, my lord, we are not.
In the middle of it, you start jumping.
Don't worry.
Please, Your Lordship. Yeah, please, Your Lordship.
Now, my lord, so far as the inquiry report is concerned, my lord will kindly appreciate that this inquiry was with respect to the circumstances which led to the death of the deceased man. This was not an inquiry commission, where the inquiry report of the commission is to be accepted or rejected. It was for the inquiry of the facts and circumstances which was given by Mr. Omkar Sharma. They had no business to toss the file here and there, ask for the opinions and other things. Number one. Number two, the moment SIT came into the notice of SIT that inquiry is also there and report is also there, they were duty bound to take into possession that report also. No, during the course of the case, it was not regarded that they will take in possession only when the government says that it can be taken into possession, or we have accepted it. It's a corroborative piece of evidence.
Please come to annexure R3 appended with the reply filed by Mr. Omkar Sharma.
Yes, Your Lordship. Regarding inquiry report with respect to unfortunate death of
Please read para 2.
It has been advised by the inquiry report is a set of statement has traveled beyond the scope. Yes, my lord, that is there. My lords may see the scope of the inquiry. My lords may have the annexure R1. That is our internal decision making process, but it is not a final. Once the officer said no, I will not do it, that it is not for that. Again we are saying no, you do this only. The matter ends. The Shri Omkar Sharma will hold an in-depth inquiry. He will associate the family members, employees, anybody else to wish to give his or her inputs. He will submit inquiry within 15 days. Ensure credibility of inquiry. Both Harikesh Meena.
Where did he go overboard? If I may just ask, where did he go overboard?
Well, then
he has pinpointed everything with regard to the subject matter of the inquiry.
No. To this controversy,
no.
This is an internal communication between the state and the officer. Once that,
I am again reiterating,
Lordship,
there is an inquiry held that how the person has died, then the only report should be because he stopped breathing.
No.
Exactly.
Reasons for stop breathing are to come forward, Lordship. Reasons must come forward. And if my lords, I may take.
The thing is because
if
adequately dealt with the allegations.
He has, that is the difficulty that he has only.
Why are you?
But I am not.
Why are you bothered?
I am not.
Why are you bothered?
We are not bothered.
Let us assume.
I being a member of government.
Let us assume that
making this submission because I have a first-hand information of it.
When the learned advocate general is addressing his arguments,
Lordship,
Israel is bombing Hamas. How are we bothered? Let Hamas cry.
People are dying.
Let Hamas cry.
People are dying.
Let Hamas cry.
Humanity is dying.
Hamas has a mouth.
Yes, your Lord. But everyone is for humanity. Here also we are for humanity, Lord.
So-called Hamasis, if they are aggrieved by all this, they can always.
My Lord, none is aggrieved. My Lord is taking it as that the government, there are two adversaries.
I'm not.
We are saying
you are
in a decision.
In my mouth.
In a decision making.
Office of the Supreme Court during investigation.
Wait for a minute.
Which does no right.
In a decision making process.
Cite this.
In a decision making process, there are hundreds of decisions taken. Decision restored.
This inquiry, according to me, cannot be said to be of per se criminal nature.
Yes. It's a total different preview. It's a preview that whether Harikesh Meena, whether this DS Thakur, whether another officer, or whether any engineer of HPCL was misbehaving, or they were maltreating this the senior officer of HPPCL, and whether their maltreatment and misbehavior has led for suicide or any other which caused the death of the deceased Bimal Negi. Matlab, that is the object of that inquiry only. No political aspects, angles came into it. Yes, Your Lordship. We are not.
You should now let me correlate
Lordship.
the inquiry report with this particular case. You see, here the petitioner is before this court on the ground
Lordship.
that the deceased met his end on account of some pressure or some something which was beyond his control, under duress, etc., from his superiors.
That is allegation.
That is allegation. I am not saying.
And HPCL record is before, my lords. But our record.
The FIR is also to that effect, if you read it.
FIR is to that effect.
So at least the inquiry report corroborates what the allegation is.
Inquiry report says that it has taken the statements of the members of the employees, officers of HPCL, who after the death has all said, yes, so and so used to abusive language, who has to use to pressurize.
No, you see.
Beyond that, there is nothing in the inquiry.
No. Beyond this, there is everything. Beyond there is there is a fact that undue favor was being shown to a particular company. This gentleman was called at 9:53 AM, I presume. He went to his house कि रात को 1:30 बजे या 2 बजे ये घर गया. ठीक है ना, वो पूरा करके.
No, that is in headquarters. Malad, I am told there are statements recorded of the employees that the Mr. Negi said on the first day when he joined headquarters that after 5
facts remain,
they should leave.
The face of record.
People say that headquarters can never be left at 5. We are working till midnight oil.
We have gone through
anyone burning midnight oil for his organization is said to be he should be awarded rather than discarded.
Let us see the affidavit of the Director General of Police.
Yes, Lord.
वो तो हम ला ही रहे हैं.
Report is being filed in the compliance with the direction issued.
वो दे दो.
My daughter did.
वो निकाल दो ना.
CWP.
निकाल दो सारे.
It is fairly submitted the copy of the procedure order.
Just for my own information, I was keen in knowing one fact. Please read page 24 of the affidavit filed by the Superintendent of Police.
Yes, sir.
There is a communication addressed by the Senior Superintendent of Police to Director General of Police. 8th of May 2025. Appearance of investigating officers in connection with FIR number so and so. Kindly, this is in reference to notice for appearance issued in connection so and so. On account of the commitment of officers to tackle or mitigate disasters under high tension situation at international border. What was the duty assigned to the SHO Shimla on that particular day? Which missiles?
Here I'll explain.
Which missiles were at this Vikram Chauhan protected? Which missiles was Shakti?
No, I'll explain the thing.
The DGP, honestly speaking, I would have taken
him to task. Yes.
Disciplinary action.
I agree with this. I agree with this. It's
derogatory.
I agree with it. But what is happening is, why DGP has filed a reply? If I may permit it to explain the things.
Before he says it.
Let him plead. I'll give a date wise everything, Lordship.
We'll read it.
Actually, what had happened?
How they have tampered with.
Let us, Mr. AG, we'll read from internal page 5 of the affidavit.
Yes, sir.
Pursuant to this order, I issued a letter number so and so dated 3/5/2025 and CR number so and so 6/5/2022 to send the file to the concerned case along with the IO of the case. However, SP Shimla did not respond till the stipulated date, that 7th May 2025. After which Navdeep Singh, additional SP, head of the SIT, was directed to appear with the case in all relevant.
My lord is reading DG affidavit.
Similarly, Shri Shakti Singh, DYSP, member of the SIT, was also directed to appear, as also Shri Vikram Chauhan, DYSP, and Manoj Kumar, Inspector, past and present members of SIT expected to be familiar with the investigation simultaneously. Receiving no response of the Superintendent of Police Shimla till the stipulated time, the Director's State Forensic Service Laboratory was requested by letter dated so and so 7/5/2025 to provide reports and findings concerning this case by 9/5 to 2025. So
My learned friend is taking 10 minutes, Lordship. I may
filed in Honorable High
it's one another. मैं एक इसका please
concerning this case, provide reports
Note करना.
concerning this case by 9th May 25, so that a proper status report could be filed in the Honorable High Court in terms of its action. In the meantime, on 7th May, a letter was received from Deputy Inspector General of Police, Southern Range, DIG SR, Shri Anju Mara, IPS, as reply to PHQ, letter dated 5/5/2025, wherein she replied that the SP Shimla has replied nothing specific about the allegations of missing pen drive as published in a newspaper, Dainik Jagran, as alleged by MS Kiran Negi, wife of Shri deceased Shri Vimal Negi. There was also a letter from SP Shimla dated 8/5/2025, wherein he expressed his inability to allow IOs to appear with facts known to them and the documents connected with the case. He also wrote stating that the progress report in detail has already been submitted by his office through DIG SR. Now it was felt that without independent examination of case files, case diaries and related documents, an independent report cannot be filed. This is actually similar to the status report dated 2/5/2025 submitted in the court regarding matter of anticipatory bail, in which the issue of missing pen drive has been skirted at para 25, stating that during the course of investigation, various digital evidences have been seized. clear as to whom those phone numbers belong to. There is a chat between Nanta, Head Constable, and Sandeep Vashisht, Agniditya, 2006, Ashok Dota, and Anup Kumar, dated B3 In this chat, there is a talk about
hash value of pen
the pen drive, regarding seizure of the pen drive, unique number of the pen drive, alarming on date of modification of the file and folder, software changed in the case, and same shall be the date of the copy files. There is incomplete data. There is a talk in the chat about copy pen drive बदला जा सकता है material copy करने के बाद. The date of modification of file folder changed in that case, and the same shall be the date of the copy files. At another place, there is a talk of whether pen drive could be changed or not. Interestingly, all this chat is going on B3 one day prior to formatting of the pen drive in question above. It is reiterated that due to the volume of data provided by the SFL, it has not been possible to go through the each and everything. In fact, 2 seed envelopes, possibly with pen drive inside, containing 2 dockets, serial number 2 and 3, could not ever be opened in the DWD. Pertaining to the docket at serial number 1 only, data related to pen drive could be examined to the extent possible, and that to the laptop could not even be examined. Another point to note is that in the report pertaining to docket number 3, in which mobile chats have been found, the report says that clue in the chats, pen drive and clue Vimal Negi were used to get those data wherein chat regarding copying, altering, replacing pen drive has been displayed as discussed above. However, another procedure adopted in some organizations is to get a cloned copy of the digital service to the investigator and try to find data using more clues or keywords, because the IO knows best about the case on which the clues or keywords in that sense, the report may still not be complete, where it is required to allow application of more clues to find relevant data. There is enormous digital data which has been collected by only investigator knows that what is relevant to the case. On 14.25, Navdeep Singh, additional SP and head of SIT, and Shri Shakti Singh, DYSP, a member of the SIT, appeared with documents pertaining to the case at 11:30 a.m. The meeting with the members of the SIT started at around 11:45 a.m. The SIT member had come with the summary of case diaries and short status reports of the case. They also came with many boxes of documents which they said contained their case file containing case diaries. Now, see the conduct. Documents seized during the investigation and other documents pertaining to the case. I started in the summary of the case diaries before breaking off for the lunch at 1:30 p.m. During this discussion, I pointed out that I would like to see the report sent by additional SP to SP CDR of the ASI Pankaj, who had recovered the pen drive, the case diary of 13/4/2025, CD number so-and-so, in summary of CDs as provided about missing pen drive written by Manoj Kumar, SHO, New Shimla, wherein mobile phone of Shri Sunil Kumar, fisherman, was seized, with which contains video recording and some photos of ASI Pankaj, where he can be seen talking about the recovery of the pen drive recovered from the body of the deceased, and statement of fisherman Sunil Kumar, supplementary statement of fisherman Mahinder Singh, supplementary statement of ASI Vijay of PS Sadar, and head constable Kamal of PS Sadar. These were written at para the summary of the case diaries. I told them that I intend to see the actual case diaries along with statements after lunch. Similarly, I said that I would like to see the auditor's report, personal diaries of Shri Vimal Negi, mentioned at so and so, as CD number 4 of by 325 by Shri Navdeep Singh, additional SP, Shimla, at para 44. Summary of the CDs provided to me recovered, and the complaints of the deceased family and others in the case before proceeding to examining other documents brought by the 2 members of the SIT. However, after lunch, they assembled at police headquarters at 2:40. The 2 members of the SIT expressed their inability to continue with the meeting as they had to prepare documents relating to bail application accused in the case. As a result, other documents of the case and those case diaries which were found to
इसको छोड़ के अब पैरा H पे आ जाओ, internal page 12
उसी पे आ गया था जी,
नीचे जैसे. On the basis of the documents that
on the basis of documents I have been recurrently provided by the SP, and many important statements such as Vimal Negi diaries and actual case diaries in district so and so, I have some comments on the subject of investigation done by the SIT under the overall supervision of Sanjeev Gandhi, Superintendent of Police. Why was the pen drive formatted as per SFSL report, and how many people knew that pen drive had been recovered from the dead body way back on 18th March itself? This was never disclosed even to the family members. These questions need to be answered, as it casts doubt on the integrity of the investigation carried so far. Who was ASI Pankaj speaking to regarding pen drive after it was recovered from the dead body of Shri Vimal Negi? during the discussion with the two SIT members on 14/5/25, it was verbally told to me that I could be SHO Sadar Shimla, DYSP Amit, MHS, PS Sadar Shimla. There was no clarity on why it was not clear from these three officers were in turn speaking to when CDR, IPDR of the above three officers could have revealed.
Pushpinder, ask the ladies to sit. आप लोग बैठिए आराम से. Yes, please. Yes.
There was no clarity on why it was not clear. Three officers were in turn speaking to when CDR, IPDR of the above three officers could have revealed. These are very basic and intuitive next steps of investigation. The fact that this conversation of ASI Pankaj was also recorded in a mobile phone of a bystander fisherman should have enabled the SIT to time stamp this conversation of ASI Pankaj and thereafter investigate the chain of the people on the basis of metadata from CDR and IPDR to reveal who those persons from whom ASI Pankaj spoke in turn. I have serious concern with two SIT members' refusal inability to show Vimal Negi diaries on 14/5/25 when they met me. They abruptly said after lunch that they had to go to prepare the case summary, etc. related matter of Shri Rishikesh Meena in this case. It seems to be an afterthought. It is difficult to imagine as they did not know in the morning that the date of this bill matter in the court is next day. It is to be noted that the two members of SIT, after a lot of resistance from SP Shimla, had come with suitcases and trunk full of documents, gave me only 2 to 3 hours to examine them and have since not returned till the writing of this report. Also, CCTNS record available electronically to superior officers were not found to be updated. It is also important to note that a note of SIT found by me to trace then missing Vimal Negi was sent to handle formalities after sighting of dead body of Shri Vimal Negi in Bilaspur was reported. It is noteworthy.
This investigation, Mr. AG, this investigation, it instills what kind of a confidence? That is the primary question. What kind of a confidence? जहाँ पे आपका DGP helpless है. He is as helpless as the family members of the.
Number one, helpless. Number two, he has said that they are not fair. Not fair to him, not fair to the complainant. And the entire the files have been corrupted. The pen has been tampered with. Electronic evidence has been tampered with. What else is to be made for the transfer of the case to the CBI? Taking into consideration the detailed affidavit filed by the DGP.
Speaking for myself, it is your stand. In the peculiar facts and circumstances of the case, the state would be well advised to welcome a CBI inquiry rather than trying to shield the persons or give an impression. I'm not saying that the state is involved or give an impression.
It is also important to note that the non-member of the SIT formed by me to trace then missing Vimal Negi was sent to handle formalities for after sighting of the dead body of Shri Vimal Negi in Bilaspur was reported. It is noteworthy that the past reputation of this person, now he says, DGP says, reputation of this person, ASI Pankaj, is not the best as he has been involved in case FIR number so and so of the Arms Act at PSS. Then Lordship can come to para 4.
Yes.
Para 4. Also notable in the fact that the Inspector Manoj, who has written case diary number so and so dated so and so regarding seizing on phone of fisherman Sunil Kumar, which had video recording of ASI Pankaj Kumar talking to someone regarding recovery of pen drive from the body of the deceased as told by SIT member, and who recorded statement about these, and DYSP Vikram Chauhan, who recorded statement on Naveen Kumar, Ashwini, Naman Mishra, Manoj Kumar, who represents the site Varda, where the dead body of Shri Vinu were recovered as per DCD number. So went on relatively long leave in the middle of the investigation immediately after in recording statements regarding sighting of pen drive along with the dead body of Shri Vimal Negi. The summary of the case diary number so and so submitted to me by two SIT members on 14/5/25 does not have details of the statements and was not shown to me after lunch when requested. Going to the fact that these 4 people who gave statements and were present at the site of the recovery of the dead body of Shri Vimal Negi, the statements may contain regarding sighting of the pen drive, the long leave of DYSP Vikram.
Yes.
the statement of the long leave of DYSP Vikram Chauhan and Inspector Manoj Kumar at this juncture of investigation have been noted by me. It is not clear whether and when was action taken against ASI Pankaj, despite on 13/4/25 showing that he kept the pen drive with him after recovery on 18/3/25 and surrendered it only after multiple witnesses' statement. Even though SFL report has come in around 9th May, there was enough evidence of misconduct in mid-April itself. Para clearly indicates the misconduct during the investigation. That means that investigation is not fair. There are unanswered questions as to how 4,000 plus files were examined by a single ASI.
In 3 days. In 3 days.
There are unanswered questions as to how 4,000 files were examined by a single ASI and decision taken to format within 3 days. My lord, right. Were there more people who were assisting him in this job, and if so, who are they? As discussed above, there were chats about keeping a copy and then deleting. Where is the copy? Efforts must be made to retrieve it. A belated move to possibly add section 238 of the BNS for destruction of evidence only against ASI may not be enough. Question also arises as to whether all documents have been retrieved from the formatted pen drive using the forensic tools available with the SFSL. Junga, I am received of a letter from DIG SR wherein he has mentioned that about 3 cases in which case materials were sent to CFSL and they recovered more data than what was recovered by SFSL. Junga, in any case, some files in the pen drive were found to be corrupted. Superintendent of Police Bilaspur has also sent a letter in which he has mentioned regarding recovery of dead body of Vimal Negi in the presence of who spotted the dead body and has commented that the initial search of the deceased Vimal Negi was conducted by Pankaj or fisherman Sunil Kumar on the direction of ASI Pankaj prior to the arrival of the police station team. PS Talai. He has further written that Inspector Manoj Kumar SHO PS New Shimla seized a mobile phone. Now, this mobile phone has not seen light of the day till today. Seized a mobile phone and disclosed over phone that ASI Pankaj has produced one pen drive that was recovered from the dead body
of the deceased.
Shri Vimal Negi, SP Bilaspur, has conducted a fact-finding inquiry regarding recovery of a pen drive from the dead body of the deceased. Shri Vimal Negi, after social media news circulation of an article published on P4/25, the promptness of SP Bilaspur is in sharp contrast to the efforts made by the SP Shimla. I have noted with concern that whereas 2 personal diaries of deceased Vimal Negi was seized on 22/25 and some of his other material including.
Let us see the affidavit of SP.
But that he has filed a long affidavit. He says that accept the writing that he boarded a taxi, went to the Bradi, then he saw the bridge, then had a round around the bridge, then he said the pani kam hai, and all that. He has not touched anything, my lord, as has been rightly pointed out by the DGP.
That the course of further petition is pending a jurisdiction before the Honorable High Court and was listed on 22/4/25 when the Honorable Court has pleased to.
आप क्या पढ़ रहे हो?
SP की रिपोर्ट जी.
आप पेज 28 पढ़ो.
शुरू से पढ़ते.
ना मरने दो. पैरा 70.
ये भी एडमिट कर.
मजा ही पिछले एंड के 15 मिनट में पूरी फिल्म क्यों देखनी? लास्ट के पढ़ो. प्लीज रीड पैरा 17 onwards. Roman 17.
That during the course of investigation, charge of duties, the role, responsibilities, decision making, reporting, upward execution, onwards, supervision, command and control, and amenability to office discipline was examined vis-a-vis deceased and superior and other colleagues. The record pertaining to the office functioning of the deceased was investigated in an elaborate manner when it was detected that the deceased was a gentleman officer, amenable to office procedure, regulations, hardworking and dedicated person. That the documents pertaining to the office correspondence who are decision taken and received from implementation were seized and analyzed in the light of the contract agreements entered between the employer and the contractor. It was detected that as such no decision could be detected with 36 projects of renewable energy and 7 hydropower projects. Decision or orders were found in conflict with the rules or procedure established for any contractual related matters so far. However, the record seized.
Oh, this is important. This is extremely important. What Onkar Sharma says, he क्या बोलते हैं, he went out of the brief given to him. when he says what he says in his report. What the SP says, you please read it carefully. Documents pertaining to office correspondence for decision taken and received for implementation were seized and analyzed in the light of contract agreements entered between the employer and the contractor. It was detected that as such, no decision could be detected vis-a-vis 36 projects of renewable energy and 7 hydro projects. Decision or order was in conflict with the procedure established. This is the issue. Your ACS says they were in conflict. Was it the job of the SP to give a clean sheet with regard to as to whether there was any violation of contract agreement? Is he an arbitrator in a contract, in a dispute between the contractor and the employer? His job was to see as to whether the allegations leveled against the so-called seniors were correct or incorrect in facts of the case.
He's trying to hush up the matter and all the corruption angle he is denying. The culpable homicide angle.
Mr. Pushpinder, let us hypothetically take a case that there is someone 100% honest, work alcoholic, who comes to his office at 6 a.m., leaves his office at 1 a.m., and expects everyone to be on his frequency and he wants everyone to work like him. 10 आदमी तंग आ गए और 2 बंदों ने सुसाइड कुछ कर लिया. एलिगेशन है कि सर इस आदमी के खज्जल करने के कारण उन्होंने स्टेप उठाया. The job of the IO is only to investigate as to whether this allegation is good or bad. Nothing more than that. Let the learned AG come. We'll hear him on merit, on rather legal issues. If you want.
Continue करेंगे या उनकी आगे करेंगे?
क्या चीज?
I have a lordship can.
You make a submission in his presence. That will be better.
अच्छा.
ठीक है sir. Let us wait. Ask the learned AG to come. समय तब तक बाकी नहीं
I will not take more than 20 minutes.
That is why I spent some time yesterday reading.
Yeah, grateful.
So that. Yes. We'll finish it before lunch at any cost. Or today we are going to miss our lunch. Yes, sir. बाकी के.
ऋतुराज का है. वो का हमारा ऋतुराज.
I'll throw this case out of hand. Let us concentrate on our normal work. Yes. ऋतुराज, ये क्या है पुष्पिंदर?
ये कंप्लाई विद द ऑर्डर.
डायरेक्शंस क्या थी?
Consider and allow the claim of the petition option accordingly the objective individual division July. He directed to grant the regularization work translator to Shri Rituraj with the effect from the so on motion basis after एक 2006 on the.
अरे लाओ फिर को खत्म करें. लो बाबू. इसके बाद मैं आराम से अपना दूसरा काम. AG, because all of us have gone through the affidavit, I'll request you to address the court on the issue as to why the prayer of the petitioner that the matter be referred to CBI be not exceeded. Yes, that is the only issue. That is the only issue.
Let him show that the investigation is fair. In view of the affidavit filed by the DGP and also Omkar Sharma.
Yes, Mr.
No, but believe करना ना करेगी. But so far as their own head of the department is concerned.
I start with the affidavit of DGP.
Yes.
investigating officer, investigating team are the IOs, Lordship, under supervision of the SP. And my lords have directed DGP in their order that every one of the respondents shall file their independent affidavit. So my lord, once this is directed, the SP DGP asked the IOs to come to him with records and submit enable him to file their independent reply before the honorable court, provide him documents. Well, those are the communication which the DGP has placed on record, which I may submit that it's an intra communication between two officers. IO was of the opinion in this, as it reflected from this, that I am independently investigating and no authority as per orders of the honorable court can interfere in my investigation. But he was of the opinion that I need reply.
See, there is no direction by any court.
No,
To anyone.
it is
not a SIT has not been constituted by the court.
no, it's a general orders. It's a standard law that nobody
Of any
no, not it is a general law or a settled law that independent investigation will be carried out by the IO without any push and pressure from any quarters. That is a settled law, Lord. Now DGP has written, my lord, two things. Apart from their own communication intra-departmental, which may not lead that for this reason only the matter be referred to CBI. But one system, one thing at para D, page 7 of the DGP affidavit. He pointed finger about one pen drive. But the reports provided bar 12 dockets out of 4, only 4 dockets have been examined and reported by FSL Junga. Para D I am reading to others. But this is the bone of contention. And then I'll come how this is being dealt by the present SI. The rest of the pending examination due to the delay caused by the and above paucity of time, enormity of data, even 4 reports only data contained in pen drive, as in docket number so could be examined. The report of pen drive para 3 marked question 1 says that property of drive was suggestive of the blank pen drive. It says that thereafter the image of drive prepared using table disk duplicator TDU 2U and the analyzer using FKT images. No matter the system volume informed that defined formatted and 21/3/2025. This is a serious misconduct on the part of SIT, wherein a pen drive presumably found on the body of the deceased containing crucial evidence has been tampered with or destroyed after recovery. What had happened, Roger? On 10th, an report was lost that a person deceased was missing. 11th, as I informed to my DD report was registered, and on 11th itself, SIT was constituted. On 15th March, on 15th March, the Director General of Police constituted this SIT. Headed by ADGP. Till 15th March onwards, a missing in SIT was constituted to find out the missing person.
So this SIT was constituted only to trace the missing person.
Missing person by the DGP. This SIT, while investigating the matter on 18th, found the body. Inquest was prepared. And on 18th, this pen drive was found by the members of this SIT, wherein the SHO concerned had deputed another ASI to go to the Bilaspur and take the body and take all the proceedings. But this SHO had taken this pen drive and kept it with himself. ASI kept it with himself.
ASI Pankaj.
ASI Pankaj. He was a part of that SIT.
So there is an admission on the part of the state that one pen drive was recovered from the dead body of the deceased.
Yeah, yes.
So there is
it is in our investigation.
Okay.
Then after this, the SIT, this missing inquest was complete. Another SIT, the body was brought to the HPCL headquarters. by the family members of the deceased, and it was kept in New Shimla for some time. At that point of time, a new SIT was constituted, and FIR was registered at DCS police station. After registration of FIR, SIT was constituted on 20th of March. Lordship. 20th of March. 19th FIR was registered, and 20th of March a new SIT was constituted by the SP Shimla, because FIR was here to investigate 2-3 high-ranking officers, SP level officers were involved, and an SIT was constituted for investigation into the death and everything. DGP has only given the version that SIT which was constituted by him has committed serious lapse. One of the member of that SIT has taken into possession that pen drive, and that pen drive was found blank. But the SIT which was constituted later found a video of a fisherman while investigating the matter, and in that video it has come that Pankaj was saying that this pen drive मैं रख लेता हूं, and we have registered a case against him under section, added the section 241 of BNS. नहीं मोबाइल नहीं रखा, मोबाइल तो चला गया, ये तो पकड़ा गया नहीं, वो सारा कुछ पकड़ा गया, सारा कुछ पकड़ा. Then my lord, that pen drive on that video was examined. After examining the video, it has come that there is a one pen drive with the Pankaj. My lord, that pen drive was obtained by this SIT from Pankaj, sent to FSL Judga, and
when was the pen drive seized by the new SIT?
My lord, it was seized on 14th April. I have written everything.
Postmortem was done on 19th March. And this 14th April.
Okay. Yes.
So, my lord, this SIT was constituted on 20th, and on 14th April, when these videos were recovered, then this SIT came to know that yes, there is a lapse by the earlier police officer. That lapse was taken into consideration. Pen drive was obtained, sent to FSL Junga. More than 15,000 documents were recovered, Lordship. That is record with us. And everything is in hard file with us today, available for my lord's perusal. 15,000 documents were recovered, meaning thereby nothing was omitted from that pen drive. And it was also found that the pen drive which was recovered was used in the laptop of deceased Bimal Negi. So, there is a corroboration of the fact that this is the same pen drive. DGP from this for this onwards has not only given his conclusion further. Apart from this, DGP has not doubted anything, but doubted on a SIT constituted by DGP himself, which ultimately is not investigating the matter. But now the conclusion at page 18 of the DGP law.
Yes.
It can be safely concluded that it has been page 18. It has been questionable investigation till now and attempted influence of SP Shimla, who has posted more than 2 years in the post and seems to extend beyond his domains. This is his observation. But how it is charged? This investigation is not good only because SP Shimla is here and they are fighting with each other, and he may not be. That cannot be a ground to send this matter to CBI. So, my summary is that the DGP affidavit, apart from their own conversation, internal documents, has only shown the documents which are part of our investigation. FSL reports.
SIT है ना, उसकी constitution का document है आपको, उसकी record पे है वो लगा हुआ.
Yes, sir. No, but because we have not faced, but that is with us.
वैसे है आपके पास?
हाँ जी, अभी है, अभी दे रही है. Now, my lords, we have the fresh SIT report which is taking into consideration. That is the basis that what the SIT is doing wrong, Lord. It is not what, but it is should be that there is a reasonable doubt on this SIT. Now I'll read the status report filed by present SIT. मतलब पैरा 3 onwards I would read.
ये कब फाइल किया आपने?
ये कल ही दीजिए.
कौन सी किसके एफिडेविट पे?
ये है SP शिमला. SP शिमला.
You are reading the affidavit of SP Shimla.
SP शिमला.
Please read.
No, Marat, we say that we still need more time to complete this inquiry. It is not investigation is complete, but we have whatever the facts have come to our notice with records is with us for perusal of my lords. Because this is a huge voluminous record of 20,000 pages. Right? So, but I am just brought that record that it is appropriate. But I am reading from para 3 onwards, and it is yes, para 3 finance that it is appropriate to submit on receiving the missing report for late Shri Vimal Negi Station Sadar Shimla initiated all out efforts to trace the missing person. 3 teams were deployed for search of missing person from district Shimla. Hue and cry notices were issued and places possible whereby the missing person could be traced. Police station were informed accordingly. That it is appropriate to mention receipt of information last dropping of official's driver of the vehicle attached with late Shri Vimal Negi was ascertained. Thereon, to pinpoint the movement of the deceased, the CCTV footage in line of the suspected probable movements were connected. During the search, it was detected that deceased could be seen walking from lift to old bus stand. But this is the first 10th itself. Shimla and near at Gurdwara, it could be seen in the CCTV footage. The deceased stopped one taxi bearing number HP 01445. The name of the driver is Shri Joginder Paul. His statement is with us. It is pertinent to mention here the identity and address of the taxi driver Shri Joginder Paul was ascertained, wherein one above mentioned driver disclosed about the fact for hiring of taxi by late Shri Vimal Negi, the details of journey performed by the deceased. The taxi driver further disclosed for interaction and discussion with deceased. He further disclosed that taxi was hired for rupees 3,000. Destination booked was Bilaspur. That during the course of efforts made to trace the missing person, that is deceased, it was detected on 10/3/2025. The deceased were attended office thereon. As per the office record, he marked his presence in biometric. The deceased proceeded to Tenzin Hospital. On analysis of the CDR, the voice calls were detected with his wife, present petitioner, Shri P.S. Shrimati Ranjana, Shri so and so, Shri so and so, Shri and so. It was detected that the deceased informed the office of P.S. Shrimati Ranjana about his ill health and his visit to Tenzin Hospital. The CCTV footage of Tenzin Hospital was also collected.
The flaw in the status report file. Please read para 20 thereof.
But first,
Just listen.
you have to connect every event.
The SIT is probing the conduct of the deceased.
No.
Unfortunately. Please read para 20, sir. It is probing the conduct of the deceased rather than probing the conduct of the accused.
Accused is also there.
No, sir.
But who are accused? That we have to start from scratch. We are starting.
No question.
Yes,
The accused is one this Deshraj on whom the accused.
Deshraj and everything has come that they have misbehaved with him.
And third is if I'm subject to correction, one Chandrasekhar or something.
No, Shivam Pratap.
Meena and Deshraj.
And Deshraj.
They are allegedly.
FIR is there.
Please read para 20 of the Iskina, sir. Kindly read.
But if my lords may permit me to go through the entire,
Please, ठीक है पढ़ो please.
then it will come that what is. But I started from scratch. Then he has to trace everything with respect to why this has happened. And every fact is to be brought to the notice of Honorable Court that this is the status report. During the course of efforts made trace missing person, it was detected on 10/3/5. The deceased attended office thereupon, as per that is I have read, Lordship. Where in presence of deceased was found in Tenzin Hospital. So on 10 he went to Tenzin Hospital. It was also detected that deceased enrolled prescription slip of self. Thereon, the hospital staff advised him to wait since many patients were in the waiting. The statement of driver Karan Chandel disclosed that deceased left the hospital premises and further told the driver that he wants to move for his treatment. During this period, he remained in contact with the office PA and kept inquiring about the review meeting, wherein review of all projects online under HPPCL used to be discussed. Further, it is appropriate to mention that deceased left from the Shimla under suspicious circumstances, whereby on the one hand, he told the office driver attached to him about his plans of going towards Mall Road, whereas in surreptitious manner, the deceased left towards Bilaspur and concealed so much so switched off his mobile phone. And due to sincere efforts made by these teams, location of Shri Bimal Negi was traced out and it was found on 10/3/2025 at around 3 p.m. He was seen near Mandi Bharari Bridge near Ames Bilaspur, HP Lodge. That it is appropriate to mention while making efforts to trace the deceased on detecting the effect, qua last location about the presence of the deceased, that is Gawarbi bus stand, the necessary correspondence qua the status and further action needed by the Office of Superintendent Police with District Bilaspur as well as the Director General of Police in Himachal Pradesh were apprised accordingly. It is relevant to mention here that by letter District Sir, the detailed report qua missing of deceased efforts made by District Police Shimla, the further action required at the level of various districts, including the Director General of Police, was requested. It is appropriate to relevant to submit on 15/3/2025. So and so the Director General of Police has constituted that I have already submitted to Marat that the team was constituted. Team name are there. Then it is appropriate and relevant to submit a SIT was formed to trace Bimal Negi was being closely monitored by the Director General of Police under the close supervision of Shri Gyaneshwar. So and so Additional Director General of Police Headquarters Shimla was assigned responsibility of overall supervision. Further, it is important to submit here that on and after 15/3/2025, responding effort to investigate the trace missing was taken over by DGP personally as effective steps to trace out the missing person, and investigation in thorough and expeditious manner and progress thereto was required to be reported to headquarters periodically. But then the 18/3 body was recovered.
The problem being faced by the court is this. There, on one hand, there is a report, inquiry report, which has been submitted by an officer not less than the rank of Additional Chief Secretary to the Government of Himachal. On the other hand, there is a report submitted by the state. I'm not doubting the veracity of the SIT or the report of the AC. The reports are contrary to each other.
No,
they are.
My humble submission.
They are contrary to each other on some facts. Let us agree to
one fact.
Okay, no issue. Let us agree to disagree.
Ultimately.
So, according to me, there is a contradiction in the reports as far as ACS you are concerned. The report of the ACS indicts the accused. The report of the SIT does not indict.
It indicts, It indicts and the process is going on.
Only to a very छोटा सा.
Behavioral, minor penalty. This behavioral aspect. That is why I am submitting. Not sure.
That is not the issue.
But my submission is let it be a justice to all.
I request the learned advocate general to guide the court. What should the court?
Court should give us 2 weeks time to complete further probe in the investigation, bring some material before my lord, and if ultimately, because my lords have said no charge sheet will be filed.
Mr. How do you respond to the contention of the learned AG that as far as this formatting of the pen drive is concerned, formatting of pen drive is not the job of this SIT as is being alleged, because it was by a member of the SIT, which was constituted by the DGP, and his act of omission, if any, cannot, so as to say, wash out whatever good work might be
done by
being done by the. How do you respond to that?
So far as the report of the DGP is concerned, my lord, he doesn't say that. He says that during the course of investigation. Number one, my lord, is we have read the affidavit of SP Shimla, my lord. We have read the affidavit of this DGP, my lord. Does SP Shimla says that it was corrupted at the time when he had not taken the charge?
No.
Do they say that?
Just 1 minute.
My lord, kindly see that.
Just 1 minute.
affidavit of DGP.
Yes, yes, मैं भी वहीं पे आ रहा हूँ. Please come to the affidavit of DGP
Yes, Lordship.
and that specific portion.
Yes, Lordship.
Page 8 of the affidavit. The system volume informed that the device was formatted on 21st of March. Now,
The body was recovered. So far as SIT.
no one is disputing. No one is disputing. What I'm trying to ask you is to respond to his conclusion that 18th को body recover होती है.
19th को postmortem हो जाता है.
21st को, as per the affidavit of the Director General of Police, the device is formatted. This can mention here. As on 21st, when the device was formatted, it was not in the possession of the members of the present SIT. It was in possession of the member of SIT which was constituted to recover the body. That is his contention.
He says कि जो अपने साथ ले गया. There are two SITs. Just a minute. There are two SITs. One is for tracing. Now the second SIT takes over the investigation after 19th.
That is what I want to say.
On 19th, they took over.
That is what I am trying to say.
हाँ जी. ट्वेंटियथ को सेकंड SIT की
7 और 8 अप्रैल को पहली बार पता चला
वीडियो से इनकरेक्ट प्लीज टेकन बाय देम
वीडियो से कि
पेन ड्राइव था आफ्टर पोस्टमार्टम ऑन 20th the second SIT takes over the charge. On 21st DGP says that it has been corrupted. Now the police being
This one.
in the preceding para.
Your argument, Mr. Bawa, is that as soon as the body was recovered, the job of the first SIT was over. After the body is recovered and the post-mortem is conducted on 19th, a new SIT comes into picture
On 18th FIR has been lodged.
So it's my on 20th. It's my word versus their word as to who's telling the truth. That is the fact.
Yeah, that is
It is my word versus their word. According to them, it was recovered on 14th of April. After that video of the fisherman was seen. According to the
March, we came to know.
Once the SIT already stood constituted on 20th, then whatever happened after the 20th was the job and responsibility of the
SIT. Now, Lordship will kindly appreciate one thing more, my lord. Now, whether the early SIT or the later SIT, they are all the part of this system, my lord.
Just
So far as family is concerned.
Just give me 1 minute.
So far as the family is concerned.
Just 1 minute, sir. You see, issue is very simple. Issue is that here the court has to take a call as to whether the investigation is to be carried out by the presently constituted SIT or it should be handed over to some other agency. It's a very simple, it's a simple issue but a complicated one. Point in issue is that assuming there is one person in Himachal Police who has misconducted himself, Will that tarnish everyone as is being suggested by them? How will
moralize these officers?
Just a minute. How will the conduct of one erode the confidence of the petitioner vis-a-vis everyone? That is what. Or according to you, there is more in it. It is just one example.
Now, Lordship will kindly appreciate that what is to be seen by the honorable court is here the prayer of the petitioner. That is not that the so and so arrested, so and so clan should be put up and this and that. No. We say the right of fair investigation. Now, the right of fair investigation on the basis of the material on record. Lordship will kindly appreciate that on 21st they corrupt the files. Now the 9 or 10 points have been given by the DGP, not only the single point. Kindly now see the just my lord will kindly straight away come to this page 12, running page 12 of the DGP, my lord. It is not question that one person has been swayed. No, it's a question that the investigation.
Please read point number 3.
Lordship, I will read the point.
Page 14.
It is also important to note that a non-member of SIT formed by me to trace the then missing Vimal Negi was sent to handle formalities after sighting of the dead body of Shri Vimal Negi in Bilaspur, as was reported. It is noteworthy that the past reputation of this person, ASI Pankaj, is not the best, as he has been involved in case of FIR number so and so, to an alleged firing incident so and so. Is a list as a result of gravity of the allegation. He has been reportedly acquitted. Then, Lordship will kindly have this para 12, this page 12, my lord. Para 1. Why was the pen drive?
Just 1 minute. Just 1 minute. Mr. Reji,
Not sure.
there is one problem.
Please.
This Pankaj was not a part of the SIT constituted.
Why he is? SHO further sent, because SHO was the part of.
On record, he is not.
No, but there was balance of the constitution. Thereafter, they also added few members. SHO sent him.
They are trying to cover up.
No, I'm not hiding anything. Please permit me to answer the query.
These questions to you.
Permit me to answer.
Our facts we may not be wrong.
But SHO deputed this person because body was recovered on 18, found it on 18. SHO, the member of SIT, deputed this person from his police station to go to take further proceedings. So he was delegated power was exercised by them, and SIT was only looking after. None else was looking after.
Delegate can't delegate. Delegatee can't delegate.
But it is my submission is SIT did it.
Just one.
SIT handed over this further, asked this person to go there. But it is not at that point of time that he will take the pen drive and put it into his pocket. And what a type of police officer who is doing this mischief in the investigation also.
एक मिनट page 9 पे अगर आप आते हैं ना sir, I want both of us, all of us to be on the same page, sir.
Not sir, page 9.
ये जो reference है ना, there is a chat between Nanta head constable. Who is he? Who is he?
WhatsApp group पे. Manoj, they have the chat on WhatsApp.
Really? Who is Mr. Nanta?
Nanta कौन है?
SIT में था. SIT
Who is Mr. Nanta?
ये जो चैट मिली है इसके मोबाइल पे पेज 68.
Really, that is true.
नानटा कौन है? पुलिस ऑफिसर है जी. इसके एक ग्रुप चैट है इनका, आपस में ग्रुप बना हुआ है. उस ग्रुप
has got nothing to do with.
No, nothing to do.
संदीप वशिष्ठ.
हाँ जी.
अग्निदित्य.
देखो मनोज में पेज 68. पेज 68
of the paper.
Yes. That this is the chat recovered. This page 67, second IRB Tigers is a group on WhatsApp, and he was chatting on the WhatsApp with these people. Nanta pen drive को फर्द का द्वारा कब्जा पुलिस में लेते वक्त पेन ड्राइव की यूनिक आईडी ये पूछ रहा है जी. ये इनकी ग्रुप चैट है सब की. संदीप विशिष्ट नैंटा और संदीप विशिष्ट नैंटा अग्नि आदित्य. इन दैट केस हियर कम्स द आईटी.
मेमो में पेन ड्राइव है सर.
हाँ जी है, हमने कर ली है पेन ड्राइव.
नहीं तो आप जी
जब डेड बॉडी
वो उस वक्त
नहीं था,
लेकिन उसने छुपा ली. वही तो प्रॉब्लम हुई.
वो जेब में लेके चला गया जी.
ने ढूंढी, इस एसआईटी ने ढूंढी है. सेकंड एसआईटी ने ढूंढी.
When the matter was in the media also.
मीडिया तो शुरू से ही है.
DGP says this thing.
मीडिया का तो कोई परेशानी नहीं.
ऐसा नहीं है.
It should be in public.
It was in
तो कल फेसबुक पे और
you are now trying to cover up. You are now trying to cover up.
Anything, any.
Mr. AG, there are two situations. One situation is that this person, he went away with pen drive.
Yes.
Thereafter, when you came to know,
yes,
then you recovered.
On 4th, we came to know.
Another version can be that a mischief has been played with the pen drive. When it came into public knowledge.
No. It was never in public knowledge.
I'm just
yes, your lordship.
I'm just giving a hypothetical example.
Haan ji.
That when it came to public knowledge, then a story was concocted, and on documents it was stated to be recovered from this gentleman.
No, truth is this, that there is a video, my lord. Video fisherman, इसी की आवाज है कि ये पेन ड्राइव मैं रख लेता हूँ, वीडियो है.
चलो ठीक है,
There is a video. My lord, we submit in order to build up confidence in our police also and to bring out the truth. My lords may give us 2 weeks more time. After 2 weeks, my lords may take it.
I'm reserving the judgment today, whether I allow the petition or I dismiss the petition.
But my lords, if my lords give us 10 days or 2 weeks time, we file a further status report closing
I
everything.
have to take a call whether their petition is to be allowed or dismissed.
Yes, your lord.
इसके अलावा नहीं है कुछ भी. अगर if I give a finding that petition is dismissed, you may proceed in accordance with law.
Yes, your lord. So then my lords may have to our judgments, but then
Just 1 minute. DGP का affidavit एक बार फिर flash कर लेते हैं, then you may give it.
yes, sir. For a DGP affidavit, why he has filed the affidavit? Otherwise, in normal routine process, only the IO should have filed the.
There is a problem.
Lordship.
Here, you see, this is why all this is creating. I'll give you an example.
Lordship.
Let us take a case that a deputy advocate general is entrusted with an inquiry, and in a case there is a direction issued to the learned advocate general to file a status report. What will be your reaction if your subordinate does not perform his duty to enable you to comply with the court order?
My lord,
It's as simple as
it is my leadership that will prevail.
Question is not of your leader. Yes,
It is my leadership that will prevail.
leadership.
His leadership should have upon it. He has more power than me.
No comment.
He has more power than
sufficient
comment.
indicators. There are sufficient
But
indicators.
this cannot be a basis.
In the affidavit filed by the
If
by
IO
the DGP and Mr. Omkar Sharma.
What you see, there is one. I'm not pointing it out. I'll point it out. DGP says that while I was in the course of scrutinizing the documents so as to file an affidavit, suddenly these people come up with the plea कि सर हमारे को तो जाना है क्योंकि मीना की वो बेल पिटीशन
लगी हुई है।
हमने उसका करना है.
वो स्टेटस रिपोर्ट यहाँ मंगा रहे, आधे घंटे में मंगाएगी जी, आधे घंटे में.
He says so. That these people were very well aware कि ये सारे का सारा है.
सबसे पहले से वो पिछले केस में मंगाएगी.
चलो जजमेंट है दिखा दो. Judgment है.
Should I pass it over, my lord? All the judgments, my lord, right from this.
Latest do what is the scope के अलावा कुछ नहीं. Acts पे
So far as these are concerned, my lord, West Bengal and other, my lord, on the CBI transfer to CBI specific court judgments, my lord.
see, scope. What is the scope of the High Court?
But it is rarest and exceptional.
I have
cases.
given on the fair. I have given the judgments on the apex court that the petitioner on the basis that the fair investigation is not going on to that limited.
So let us say this 2010, para 70. ये साहब आप इसी को रेफर कर रहे थे.
Yes, 2010, volume 3, SCC 57.
Constitutional bench.
Para 17 के अलावा para 17 के अलावा para 68, 69
भी देख.
हाँ जी
68 में भी उन्होंने काफी एनालिसिस.
हाँ जी
68 ही देख लो.
68, 69.
These are the rival contention. The rival contentions of this court.
68.
The fundamental rights enshrined in Part 3 of the Constitution are inherent and cannot be extinguished by the constitutional or statutory provision. Any law that abrogates or abridges such rights would be violative of basic structure of doctrine. The actual effect and impact of law on the rights granted under Part 3 has to be taken into account in determining whether or not it destroys the basic structure. Article 2, मतलब these are all
कोई relevance नहीं है.
contentions है, मैं तभी बोल रहा था.
ये para 70 है important.
Yes or not?
Para
Or party.
68 में जो
But 69 we may
relevant
in the final analysis of our answers to the question referred is that a direction by High Court in exercise of its jurisdiction under 226 of Constitution to CBI to investigate a cognizable offence alleged to have been committed within the territory of state without the consent of the state will neither hinge upon the federal structure of the Constitution nor violate the doctrine of separation of power and shall be valid in law. Being the protectors of civil liberties and citizens, this court and the High Court have not only the power and jurisdiction but also obligation to protect the fundamental rights guaranteed under Part 3 in Journal and so and so. Before parting with the case, now this is important, we deem it necessary to emphasize that despite wide power conferred under Article 32 and 226 of the Constitution, while passing an order, the court must bear in mind certain self-imposed limitations on the exercise of these constitutional powers. The plenitude of the powers under the said articles requires great caution in its exercise. Insofar as question of issuing a direction to CBI to conduct investigation in a case is concerned, although no inflexible guidelines can be laid down to decide whether or not such power should be exercised by, but time and again it has been reiterated that such an order is not to be passed as a matter of routine or merely because party has leveled some allegation against the local police. The extraordinary power must be exercised sparingly, cautiously, and in exceptional situations where it becomes necessary to provide and instill confidence and in investigation, or where the incident may have national and international ramifications, or where such an order may be necessary for doing complete justice and enforcing the fundamental rights. Otherwise, CBI would be flooded with a large number of cases with limited resources. We may find it difficult to properly investigate even serious cases in the process lost its credibility and purpose with unsatisfactory investigation. This is the basic crux of the point. I will also rely upon 2023 volume 2.
Just 1 minute.
12. Volume 12, SCC 592.
2023, volume 12.
SCC 592.
Pages, sir?
Page is 592. Sorry, Lord.
Yes.
Also Banu. But first, in para 45, the constitutional bench para 70, which I've read to Manoj, is quoted, and then Manoj, this bench, honorable bench, has further said.
Para kaun sa padh rahe hain aap?
Para 45, Manoj, they are first. This is constitution bench para 70. Page, Manoj, page is 41.
Constitution.
That I've read. Now, in the above decision, it was pointed out that the para 46 minor irrigations.
2002 की judgment.
Minor irrigation. This is 2000. He had said that an order directing an inquiry by CBI should be passed only when High Court, after considering the material on recall, comes to conclusion that such material does not disclose a prima facie calling for investigation by CBI or any other similar agency. In an appropriate case, when court feels investigation by the police authority is not in committee for protection of democratic rights, a proper direction, and in order to do complete justice, and in case and High Court officials are involved in the alleged
police official.
I'm sorry, High Police official. I'm deeply sorry, Lord.
Police officials are involved.
High Court ही तो हमको सब उसका part है. High police officials are involved in the alleged crime. The court may be justified in such circumstances to hand over the investigation to an independent agency like CBI. While now it is well settled that even after filing the charge sheet, the court is empowered in an appropriate case to hand over the investigation to an independent agency like CBI. The extraordinary power of the Constitutional Court then under Article 32, 226 respectively of the Constitution of India, co-issuance of direction to CBI to conduct investigation must be exercised with great caution as underlined by this court in Committee for Protection of Democratic Rights. As adverted herein above, observing that although no inflexible can be laid down in this regard, yet it was highlighted that such order cannot be passed as a matter of routine or merely because parties have leveled some allegation. This is para 70 of the same is reiteration of local police involved in exceptional situation wherein it becomes necessary to provide credibility and instill confidence in the investigation, or where incident may have national or so and so ramifications, so and so. The same paragraph. I have also brought the minor irrigation This another. Yes, sir. One another judgment 2000, this 2002 volume 5, that is there. It's a minor litigation. Shangu Rama. Then 2013 volume 12 SCC 480.
2013 वॉल्यूम 12
SCC 480.
same principle.
Same principle. But principle herein also the division bench of this court in Nishant Sharma case lordship, wherein high-ranking police official like DGP was involved. My lords have not directed the matter to be transferred to CBI, but only directed that DGP will not participate in the process. Here, my lord, no such allegation against anyone. Rather, the status report filed by the SP and the record which is available with us under present investigation, up till now, but I am very much clear that it is more than investigation. Everything is being brought into records. Every statement, Manoj have said, statement of same person. We have also recorded the statement of same individuals. I'm correct on this. Yes, HPPCL, each and every person's statement is recorded, Lordship. So, but our investigation is not in against the inquiry by the inquiring officer, that is Mr. Omkar Sharma. He has a limited scope. But so far as SIT is concerned, it has a vast scope. So far, induction of these people with respect to departmental proceedings, in that case, that is, he has recommended that department may proceed. But so far as criminal investigation is going on, that is only entirely different footing. We have to go beyond reasonable doubt. And the Omkar Sharma had to only go probability on the probabilities, Lordship. So, preponderance of probability is the report of Mr. ACS. And here doing investigation which will be beyond reasonable doubt.
In the light of the fact that there are glaring, I'll not say contradictions, but frictions between, on one hand DGP,
egos.
on the other hand, no,
Egos.
I'm using the word friction. On one hand DGP.
Yes, Your Lordship, that is there.
And on the other hand,
not SP, not it is SIT versus DGP.
But no, there is third element.
SP is also, Lordship.
Third element is also there, ACS.
ACS,
there is ACS.
I'll satisfy my lords that so far as ACS is
how can the mother, that is the state, ensure that it will not treat one of its children, one of its 3 children?
We will treat fairly, Lordship. We will treat everyone fairly. We cannot.
What is the
and
harm?
who is?
What is the harm if the matter is investigated by CBI?
Well,
how does it adversely affect the state?
Well, it may not adversely affect the state, but it will adversely affect the morals of the police.
We are not sitting here to.
Here, my lords have said.
We are not sitting here to boost the morals of the.
My lords have said. My lords have said. The Honorable Supreme Court has said.
The job of the court.
If it doesn't instill confidence, then only it can be. So, in confidence word.
Question is very simple. Question is that, you see, there is a very important aspect of just one very important aspect of the matter which the court has to take into consideration. You see, criminal law very clearly and categorically says that a person cannot be punished of an offense. Everyone is presumed to be innocent till he's.
That's what my submission is.
1 minute, sir. Till he's held guilty.
Yes.
Number one. Beyond reasonable doubt is the principle. Beyond reasonable doubt. Now, if there is a doubt with regard to the investigation which is going on.
That's I am submitting. Where is the doubt? One doubt, if my lords may point out, just because DGP was not made available the entire documents of investigation, it cannot cause a doubt. DGP has submitted his affidavit.
Last word to you. According to you, where is the doubt?
Yes.
Doubt is, my lord, will kindly appreciate that in view of the status report filed by the DGP, my lord, And in view of the,
he says that as far as the report of DGP is concerned, it is more out of disgruntlement.
Yes,
This contention.
that is my contention.
that is their officer. Now, Lordship will kindly appreciate that state cannot take the, what the other side is saying. Believe the SP and disbelieve all other persons.
Not SP, SIT.
No, under these circumstances, can we say that the investigation is fair? Especially under the circumstances when the DGP is saying that the investigation is not fair. The conclusions drawn by him are that the investigations are not fair, and these are not being taken into it. And he has given the examples also, and he did the factual aspect of the case also. And these persons, my lord, will kindly appreciate today the state, the AG, and everybody is shielding the SP. Now they are saying all are disgruntled people, or they are suffering from egos. Now under their fight, I'm suffering. What harm will be done to them in case that matter is entrusted to the CBI? Everybody will be satisfied.
My lord, my
Let
landed friend,
the justice take place. Let the truth come out.
my landed friend may read the SP status report and point out the defects. Point out the defects.
What defect? He's in habit of
Argument.
now. My lord should kindly see take this, my lord. This Supreme Court, my lord. That will also help, my lord. This, my lord, Subrata Chatterjee. I am handing over this judgment, my lord.
जो इम्पोर्टेंट है वही दो फिर
वही दे रहा हूँ जी, मैं सिर्फ वो दे रहा हूँ जो सुप्रीम कोर्ट में जहाँ CBI को उन्होंने पैरामीटर्स फिक्स करे जी, ये इसको रिलाई किया और लेटेस्ट जजमेंट में भी जी. And then this is also there, my lord. And then the judgments are on the fair and free investigation, my lord. This is the right of the complainant to have the fair and free investigation, my lord. And in case the fair and free investigation is not there, then the court is at
arguments heard, Judge. What do you say, Mr. Chandel? Do you want to make any submission?
Lordship kindly. Two, my lord, there were Lordship kindly see as per the writ petition. Two complaints in the light.
Before my learned friend starts, my lord, one sentence I will say, my lord, that
Just 1 minute. Yeah, Mr. AG, what do you say with regard to the report of the?
My lord, ACS report is yet to be. My lord, for the adjudication of this case.
What I'm doing is,
Lordship.
you see, I've gone through the report.
Yes.
It does not reveal anything which will, जिसको मैं कहूँ कि हमारे country के जो national interest है वो jeopardize हो जाएंगे. I'm directing the registry to make out a copy of this report. It will be placed on the profile. Part liberty to obtain it as per. Okay.
no, my lord, one sentence I will.
We'll return the original back.
No, then it original maybe because ultimately it is for perusal of my lords to do the justice.
No, this is not a privileged document.
Whatever you see, there will be.
It has no relevance with
transferring it. You see, let us assume
and my lords may make it a part of record. Permit me to make submissions on.
No. Why am
because I have to make submissions.
I will allow you.
Yes, sir.
Reason why I am making it a part of the copy. Assuming I take into consideration the arguments and then take a call this side or that side. If I allow their petition, you have a right to challenge the judgment. If I disallow the petition, you have a right to challenge the judgment. So how will the Honorable Division Bench scrutinize my judgment if this particular thing is not?
This sealed cover can be placed before the. But my lord, if my lord want to make it a part of the record,
these are the submissions.
then permit me to make some.
Make a submission.
Then my lord, I am not prepared on this.
2 बजे.
I am going for Delhi today.
2 बजे sir.
I am leaving at Delhi at 2.
कुछ भी नहीं है.
नहीं मुझे नहीं पता.
Mr. AG.
Then
sorry, you have read it. And
no, I have read it but not prepared the case on these lines.
It is on your advice that the matter was referred back to.
Yes, your lord.
Why not?
No, I am not saying I am not read it. I have admitted it.
If you want time till 2 p.m. I am giving to.
I am going at 2 p.m. मेरे को ऐसे ही धक्के खाने देंगे नहीं फिर मेरे को जल्दी जाने में मजा आ जाए मंडे कर लेते हैं नहीं फिर इसको इस रिपोर्ट पे मंडे में अपनी सबमिशन because this report has no relevance with respect to investigation.
I'll take note of that according to you it is an intra department.
May then take my opinion as a my view.
हाँ opinion क्या होगा?
वो इसमें नहीं आया जी.
वो दे देना. फोटोकॉपी मास्टर लेजी 22 ठीक है सर. फोटोकॉपी मेरे को दे देंगे.
ओपिनियन में दे. मेरा ओपिनियन यही है जी कि he has indicted some persons in this report saying that misbehavior was there by so and so and so and so 3 names, and my submission is that this report is a merely recording of statements and based on such statements, a conclusion is drawn. And conclusion is drawn beyond the scope. That
I know.
But my lord, my submission is if 2 weeks time is granted to us.
I'm not time deciding it. You'll get the judgment day after tomorrow.
Lordship.
Fact finding inquiry में cross examination नहीं होना चाहिए.
इसमें लिखना आपने. Third, judgment reserved. The inquiry report of
Technical points clear.
a copy of the report of the
CS.
inquiry report, which was filed, which was made available for the perusal of the court by the learned advocate general, can be retained.
Under this may also come that it is not placed before competent authority for final decision.
And made part of the record. Original be returned back to the office of the learned advocate. At this stage, the learned advocate general submits that
This report is not at all considered by the for final decision of the competent authority.
that it may be taken note of that the competent authority has not yet applied its inquiry report is concerned, and
it is pending consideration.
And it is pending consideration.
Consideration.
Yes.
Grateful, Mal.
इसको photocopy करा के वापस
Because members of SIT are here on two technical aspect, SP wants to say something if my lords may permit. Yes.
I am really grateful and highly obliged, Your Worship. I have to submit 2-3 very important, crucial aspects for the investigation. First of all, Your Lordship, we have conducted investigation in the independent manner here and absolute accordance with the statute. That is Bharatiya Nagrik Suraksha Sanghi. Lordship, the independence of investigation is very much envisaged even under Article 21 of the Constitution. And it is my bounden duty to ensure free, fair, transparent, and independent investigation. And in this case, I have ensured so. My lord, when I heard this everything here, I'm also feeling that my professional integrity is also at
No, Mr. Gandhi, let us be very clear on one thing.
Lordship, please.
Just listen. You are in a court of law.
Yes.
You are in a court of law, and you are before a judge who believes in who is a judge who talks. Otherwise, it's very easy for us to open a file, hear the arguments of one side, hear the arguments of other side, and reserve the judgment. But whatever is discussed in the open court, it should not be construed that is the ultimate judgment which will.
My lord, I'll offer just 2 points.
Ultimately, what the judgment will be, it will be based on whatever the material is before.
Thank you very much.
Only thing is,
I'm obliged.
Only thing is, until and unless we have an open, healthy discussion.
Grateful.
Open, healthy discussion, things do not come out. Let me be very candid, and
I'm
we don't come to the court. We don't come to the court regularly. But as far as they say that judges should make noise, and at least I can vouch for it that I do make ample noise. I'm not in a habit of.
That gives us opportunity to make our submission.
I'm making 2 submissions.
I'll allow you.
Justice, Your Lordship.
But what I'm saying to you is that whatever transpires in the course of the hearing of a particular case, you see, since morning, I say to the learned advocate general, you have done this, you have done that, it is not he. He should not, neither he takes it. We wear these gowns for the simple reason that whatever I say, he'll shrug it out. And whatever you say, I'll shrug it out.
I'm grateful.
Also
I'm grateful. Lordship.
Money क्या बोलते हैं? That also.
My lord, I have to submit. Being
SS Kamar Saab की बात याद आती
being
है.
investigating supervisory officer.
Also
I have to submit 2 points. Please.
And also being.
Sir, I have to submit 2 points. That's
your AG has submitted all this is not.
What is wrong? I am allowing him.
Lordship, the person deceased, late Shri Bimal Negi, when he went missing, thereafter District Shimla Police we made every effort to trace him. Lordship, on 15th of the March, for the repetition's sake, our DGP, he constituted one missing SIT. Now this missing SIT was under responsibility under duty to carry on the further proceedings.
To search the person.
Exactly. And thereon to submit the periodical report to DGP. Meaning that, my lordship, DGP was under the close supervision of everything. And thereon, lordship, what happened? This happened, everything happened in district Bilaspur, which is beyond my control, which is beyond my jurisdiction. Inquest proceedings under criminal procedure, it was, and the duty of to conduct inquest proceeding, it was the duty of the SP Bilaspur and the DGP. They were under duty. On
You come into picture only after the body is found and after the LT.
no, lordship. Here I want to clarify. What happened? They conducted inquest proceeding, and the Panchnama and everything, recovery memo, search, everything, it happened in the Bilaspur. Thereafter, when they completed the inquest proceeding, post-mortem, and the reports of the post-mortem, everything, the matter simultaneously started. One FIR was registered in the district Shimla. We started investigation. I constituted one SIT. SIT started investigation, and I allocated the because this was a very sensitive matter. I constituted a big SIT, 3-4 inspectors, 1 DSP, and 1 additional SP who was supervising this whole of the matter. We started investigation, and the allegations narrated and contents of the FIR. We prepared a chart. What is we are supposed to do? We divided this from 4 contours. First, whether there were elements of abetment in the office, vis-a-vis his work, scope of work, decision making, environment in the office. What was the interpersonal relations? The personal family matters, because lordship, when such things happen, we have to investigate broadly.
You can't rule that out.
Yeah, lordship, we have to, yes, my lord. We have to investigate in length and broad. Then family also raised certain suspicion that there might be some serious angles like murder, extortion, forceful throwing into the river. We also included that in the investigation. When we started examining everything, collecting record, so there were 3-4 aspects, lordship, that he was not getting leave, he was being made to sit in the office for extra time, he was not being behaved well, and there were certain things which were being done under coercion, pressure, or something like that, my lord. We investigated everything, my lord. We collected all papers which were relevant to the this matter, and we investigated whether he was getting leave or not. We took his leave record. Then, your lordship, we investigated his how much long and how long duration he used to sit in the office. We took the biometric attendance. How many days he remained in the office. We took his 2 diaries, everything.
That is there in your report also.
Yes, ma'am. It is everything in detail, ma'am. Because everything, it was relevant to investigation, your lordship. Thereafter, your lordship, we started investigation the other elements of crime also. I sent team to Bilaspur. The additional SP Navdeep, who's and the other DSP, and your lordship inspectors, they all went to Bilaspur. They started searching from Gumarni, where he was last seen. Then all the CCTV footages. We collected everything, your lordship. So the justice should be done to the family, to the aggrieved, and the society at large. So during the course of investigation, my lord, when our team was on the move, one of our inspector, possibly on the 14th, what happened, your lordship? We started investigating the inquest report related aspects. Then suddenly one fisherman, he disclosed there was one video in his mobile, and we saw that mobile. In that mobile, first time it appeared that ASI Pankaj, who is posted in the Southern Police Station, working under the member of SIT, the SIT which was constituted by the DGP, he withheld the pen drive. And in that video, it could be seen, my lord, that he was speaking to someone that एक पर्स मिला है, 3700 रुपए मिले हैं, ड्राइविंग लाइसेंस मिला है, और एक पेन ड्राइव मिला है, उसको मैं रख लेता हूँ. Immediately, your lordship, thereafter we associate him in the investigation. we recovered pen drive. Thereafter, Your Lordship, we sent that pen drive to forensic expert immediately. We sent laptop of the deceased to expert immediately. And so much so, Your Lordship, we even seized the mobile of ASI Pankaj also. And we also sent that to forensic science expert. Now, Your Lordship, there is a difference between two SITs. The role and responsibility of Director General of Police and the roles and responsibility of Superintendent of Police.
See, this is where I have a problem, and I have a very serious problem. You see, there is something known as discipline. How can a superintendent of police stand in the court of law and say something against the Director General of Police? No, I'm very seriously raising this objection.
Your Lordship.
No, I'm with. You see, I will record it in black and white also. Where is the element of discipline?
My Lord,
no, learned Advocate General should take note of this fact. Where is the element of discipline?
I have already stated.
How dare a superintendent of police speak against the Director General of Police in the open court?
I'm not
sorry, Mr. Sanjeev. I'm extremely sorry to say so. This is the indiscipline in the forces. This is the indiscipline in the forces.
That's have I already
There is a problem intra you and the DGP.
Yes, Your Lordship.
If this erodes the confidence of the petitioners, why the matter should not be handed over to the CBI? It should be handed over to the CBI. There is a saying, justice should not only be done, it should also be done. Let it be handed over to CBI. Let the CBI investigate the entire thing. आप लोग अपनी लड़ाइयों में लड़ते हो. As far as this issue is concerned, let it be decided by the CBI.
My Lord.
Because आप लोगों की आपस में, I am not blaming you, and neither I am giving any clean sheet to the DGP. लेकिन आप लोगों के personal issues में इन लोगों ये लोग तो रगड़ेंगे.
Investigation में कोई हेर फेर नहीं हुआ है.
Mr.
But that I say.
This is the problem.
From the affidavit, it is clear.
You see, all of us know each other very well personally.
Yes, sir. Personally.
There is no question of raising any
Fingers about anyone.
integrity on the integrity of anyone. You see, things are totally different. Things are totally different here. That is what is bothering the court. And I am not. You see, there may be problems. I am not doubting that what I don't want to indulge into as to what is the.
But my summation is, let us concentrate on the main issue.
So that is why that
investigation and fairness of that investigation. Rest their fight, we'll fight it out outside the court.
I have a final submission to offer, my Lord. I'm really grateful that I should not leave anything in my heart. Also, I'm also working the truthful and honest officer.
Who doubts that?
No, it's not a question. I'm just submitting.
And
Your Lordship.
And not only Mr. Sanjeev Gandhi. I have no reason to doubt the integrity of a person who is standing from morning 8 p.m. till evening 8 p.m. directing the traffic, or these 4-5 gentlemen who are standing behind you.
Lordship,
Because a person is a police officer or a police officer.
It is not, Lordship. It is not interpersonal. It is dispute, my Lord. I have submitted my affidavit, and I have never mentioned anything bad about DGP or anybody. I have never mentioned anything bad about DGP or anybody.
That I agree with.
Lordship, since I am working in the police department, my Lord, and I am under constitutional duty to ensure justice, I am an able and capable officer, Your Lordship, and I am able to ensure fair, transparent, independent investigation, my Lord. That I will ensure, and I ensure to this court that within the 4 weeks of time, this the Superintendent of Police, SP Shimla, will bring, Your Lordship.
You see, I have reserved the judgment. Now let us see if I you see, let us assume I do not agree with the petitioner. It is not. I am very clear on one thing. It is not the job of the High Court to supervise the investigations. I am very clear about that. That is your job. You are the masters of your job, and you do your job. If the court comes to the conclusion matter has to be handed over to CBI, law will take its own course. If the court comes to the conclusion that no, investigation is being carried out in a fair manner, law will take its own course. Court will not dictate terms to you how the investigation has to be carried out. And similarly, if they succeed, then I'm very clear about that.
So I'm
not meddle in your affairs.
No, that's I'm really obliged, Your Lordship, that I got an.
And you see, why I raised my voice is not against this issue, but issue is that today there may be something in it. There may be something in it. But this indiscipline, according to me, if I have an issue with, let us say, my Honorable Chief Justice or with my brother judges, let these things be confined to the places to which they should be confined to.
Yes.
That is what I say. That is what I say. That is number one. Number two, if my father scolds me, you see, rightly or wrongly, a person who holds the office of DGP, he is your elders or superior. Similarly, these three gentlemen standing behind you, you are their superior. You have a right to scold them. According to me, they do not have any right to reciprocate per se. To reciprocate. बाप बच्चे को डांट सकता है, बच्चा नहीं बाप को गाली दे.
I noted, my lord, everything.
ये इस केस का क्रक्स हो गया जी.
I have noted everything.
ये इस केस का क्रक्स हो गया. The behavioral attitude coming in the HPPCL organization. नहीं वैसे बता रहा हूँ.
You see,
is this example, Lordship?
Anup, you see, I have practiced as a lawyer for 25 years.
Yes, sir.
Majority of them I know because
Your
of
clients.
Because of my practice, and I think
Flourishing practice, not only practice, flourishing practice.
knowing 90 to 95% of the administrative officers as
Yes, your lordship.
officers personally.
Yes, your lordship.
But I know how to maintain the distinction between my judicial work
And the personal relations. That's applicable to all of us, Lord. Applicable to all of us.
and when we are hearing the cases and when an officer is involved, personal perceptions do matter.
Yes, sir.
They do not matter.
It matters.
Tell me that a person is corrupt. I will not take whatever is being told to me
Yes.
to be the gospel truth. I will also see कि मेरा अपना क्या 25
Life का experience क्या है?
अनुभव है. So don't worry about that.
Thank you, Lordship. I'm obliged.
इसको आपने फोटो कराते हैं एजी साहब हम आपको वापस कर देंगे एंड वापस करके आपको
तो वापस
एंड कर देना इसको दबा के वापस देश कवर पे गई ठीक है और वो ऑर्डर मैंने लिखा लिया आई मेक एन एंडेवर टू प्रोनाउंस द जजमेंट डे आफ्टर टुमारो
Please, grateful, Lord.
थैंक यू
Grateful, Lord.
वही 5 मिनट है आओ बाकी केसेस फाइल का
And वो पुलिंदा दे दिए जो ठीक लगे आपको.
ठीक है सर
One निशांत judgment division bench.
दे देना बट गिव मी दैट ओपिनियन आल्सो ऑफ योर ओपिनियन
यही opinion थोड़ी कि आप किसी के खिलाफ कुछ कार्रवाई कर रहे हो.
वो तो मैंने देख लिया है
बस यही
मिस्टर राकेश की चिट्ठी के कंटेंट
वही ओपिनियन था कि किसी के खिलाफ कोई किसी पे एलिगेशन आ चुका है और उसकी सर्विस कैरियर खराब हो गया.
let me be very clear to both the sides once again. मैंने कल भी ऑब्जर्वेशन दी थी that here my role is not to indict anyone. I am not sitting here to concur with the petitioners that they are accused or say that they are not the accused. My job is very limited. My job is A, whether the investigation is being carried out in a fair manner. B, if not, what are the repercussions? Whether in the circumstances which exist. You see, second is also important. Whether in the circumstances which exist, the petitioner has the faith that things will be done in a fair manner or not.
Faith is one question and perception is another.
जो भी है, para 70.
Yes.
Next case.
Perception and faith both are different.
Next case, para 70.
One issue.
Thank you. Now enjoy the heat of, from the heat of the court to the heat of death. Thank you. Shri A.K. Gupta. Yes, please. Miss Babita. ये फोटोकॉपी कराते हैं ना इसकी पूरी अभी 1 बजे से पहले वे इसको पुष्पिंदर दस्तखत के साथ लेनी है सेल्फी भी लेना एक साथ या सेल्फी के साथ वापस कर यस प्लीज तुम्हें पासवर्ड कर लेते 2 बजे तक 2 Manjeet Singh.
मतलब similar matter मारा issue notice list 9/7/2025
Notice. Simple notice था ना उनमें भी. Yes sir. आपके में कह रहे compliance होगी है. Show the copy. मैं 2 बजे लूंगा
Please, Lordship.
अगर compliance होगी तो we'll close it. यस तारा इनको बोलो क्या ना विक्रांत और वो भी आएंगे बोला इनको विक्रांत और क्या नाम है उनका सीबीआई के जो काउंसिल के ईडी के क्या नाम है उसका अजीत शुक्ला उनको कहना इमीडिएटली आएंगे यस मिस्टर प्रदीप वर्मा Just one minute. इसमें काला ने क्या किया है काला ने भेजा नहीं था show me the order page 19 19 So we'll take it up after at 2 p.m. लोग मेरे को लग रहा है people may be under this impression कि after lunch 2 p.m. Sir, we'll meet at 2 p.m. मैं कह नहीं सकता. I have 71 cases. अगर बारी आ गई तो आ गई, otherwise नहीं.
Grateful, Lordship.
Yes, please. Yes, Mr. Bhushan.
My lord, may just have two documents. Two documents only.
हाँ.
I bow to the my lord, I will not be having any this thing about that. My lord may see the requirement is 16 teachers, my lord. Of the this NCT, my lord. Now they got approved a list. They submitted it to the NCT. And the appellate authority directed the regional council to consider that one. My lords, under RTI, these documents have been taken. 4 of them have been teaching in one another college, my lord. So how were they approved? And they cannot be approved. 2 of them are working, are research scholars in Central University, a regular course, my lord. So only I do not have any hesitation to say that I say they may consider this. They at least look into this.
No, you see, the
And
assumption is that they will look into everything.
the
Assumption, why should the court assume or presume that they will not look into it?
yes, one thing more, my lord. One thing that after the remand they were to take a decision. They are not taking a decision.
Which way there is one more problem now.
Huh.
Your petition, you are seeking direction against whom?
I'm not seeking any direction. I'm simply saying they decide this case and take this document into consideration.
I'm not related jurisdiction. मैं नहीं बोलूँगा कुछ.
I'm not saying anything because why I'm saying so. Any person.
ऐसे करना, इसमें dismiss करना blank page रख के. ना आप कुछ बोलेंगे ना कोर्ट कुछ बोलेगा. कागज खुद बोलेगा. Blank कागज.
नहीं, उससे तो पता क्या होगा जी. There's nothing else. One because
these are quasi-judicial functions.
हाँ जी.
Statutory functions, statutory authority.
हाँ जी.
High Court will not intermeddle in these affairs.
Or on only one thing, my lord. Because as a matter of fact, if my lords may see, I can do one thing, my lord. I can withdraw this. I can with the liberty to bring all these aspects to there.
I will not say anything. मैं कहूँगा you want to bring this without making any observation.
क्या जी?
मैं बोलूँगा without making any observation.
I give them a blanket this thing.
Yes, sir. Because there is one more question. What about the territorial jurisdiction?
It will be here only.
No.
Yes.
You are seeking a direction against whom?
Actually, the college is situated here.
My doubts.
No,
my doubts.
If this issue, this I can explain. That as far as this is concerned, territorial jurisdiction will be of this all court. That I'm 100%.
Because
and the other things which my lords are saying.
Senior counsel for the petitioner. This court is of the considered view that no mandamus as is being paid for can be granted in favor of the petitioner. This stage, learned senior counsel for the petitioner submits that the petitioner will be allowed to withdraw the petition with liberty to approach the authorities concerned. ठीक है ना sir?
Please.
Petition is permitted to be withdrawn with liberty aspects.
Please.
Presence लगा लेना. Miss Babita.
Because कई बार क्या चीजें होती है ना, चलो अब तो केस तो खत्म हो गया. अब now the big question comes that the university
दुनिया में ना 2 प्रिंसिपल हैं. एक है live and let live.
हाँ जी.
Live and
let live.
दूसरा है कि हम तो डूबेंगे सनम. तुमको भी साथ
एक तीसरा
आप है इस कैटेगरी वाले.
एक तीसरा है जी. अब सुनो, जो वहां पर 180 बच्चे पढ़ने हैं जी, अगर उनका टीचर ही नहीं है तो अगर किसी के दिमाग में आ गया कि नहीं
कैटेगरी है, सारे जहां का दर्द मेरे जिगर में.
हाँ, वो भी है. हाँ, तो अगर वो बोलता है कि उन बच्चों का क्या कसूर है जो बिना किसी टीचर के पढ़ा दिए जाएंगे, और जब वो आगे पढ़ाएंगे तो उससे क्या होगा? एंड इन एनी केस जब इस यूनिवर्सिटी ने अप्रूव कर दिया, उनको नहीं पता था कि दूसरी जगह नौकरी कर रहे हैं.
मिस्टर भूषण, जब हमने लॉ की ना, वकालत शुरू की, कई हमारे साथ है जिनकी वकालतें नहीं करी. उन्होंने PhD कर ली, फिर वो टीचर लग गए आगे की काली चैम्बर में.
अब मैं एक तीसरी बात बोलनी थी जी, पर लोग कुछ ज्यादा है वो नहीं बोलूंगा. एक तीसरी वाली कैटेगरी की.
यस बबीता, देखा आपने? ठीक मैम, इसमें लिखना लर्नड एडिशनल एडवोकेट जनरल प्राइजेस द कोर्ट that the authority has now passed the order complying the directions passed in the matter and submits that she has perused the order and the judgment issued stands compliant. Proceedings closed. Next. Yes, please. Taravati.
This matter, Your Worship, the dispute was regarding apportionment of amount of compensation, Your Worship. Despite the fact that the reference petition was filed, the SDM has released the amount in question and is not forwarding the reference petition.
Notice.
Yours.
नोटिस एक और दो के लिए सरकार, तीन तीन के लिए, चार को नोटिस सर
जाएगा जी, क्योंकि उसको अमाउंट क्या है जी,
उसको नोटिस जाएगा सर.
हाँ जी.
The Kala is to make reference to the.
हाँ, डिस्ट्रिक्ट जज, हाँ, I know that. इसमें लिखना 4 को नोटिस रिटर्न फॉर डेथ टैक्स विद इन 1 वीक.
Yours.
Next.
Grateful.
Rameshwar Singh. Yes, John sir.
I agree, and I think next P7, my lord. In fact, what happened, my lord, the company, my lord, respond number 2, my lord. It was in initiating the state initiated the acquisition proceedings, my lord, for the company respond number 2, my lord. My lord, thereafter, after acquisition, the award was passed. And the respond number 2, this proceedings were initiated for and behalf of respond number 2, my lord. So, my lord, after that the award was passed, and the amount which was determined by the land inspector was paid by the respond number 2. Thereafter, my lord, we filed reference petition, and the award was enhanced, my lord. And the enhanced amount was not deposited by respond number 2, my lord. And accordingly, my lord, we had to file execution petition, but that is answer P7, my lord. That is. In that matter, what happened, that the land executive court has dismissed, this is page, my lord, 111, my lord. The concluding parts, my lord, this is para 9, that we had sought, what we had sought is that we had sought execution petition both before, against the.
But how is the writ petition maintainable? Writ will not be maintained. This is a judicial order.
Yes, my lord.
It is not maintainable.
Because, yes, ma'am, because now we have no other alternative to get positive amount.
You may approach under 227 or some other provision. 226 will not be maintainable.
And then, my lord,
also because in the light of the judgment of Supreme Court 2015, Radhesham kya hai wo? Radhesham hi hai na? Radhesham.
That, but my lord, we have, yeah, yes, ma'am, we have said that.
That is the problem.
We have written that. But still, oh, my lord, that can be, this writ can be converted into.
Oh, sir, you withdraw it, file under 227. That is a totally different jurisdiction.
Why, my lord? I say why I am under it, this jurisdiction here is because here, the state being a welfare state, my lord, because I am relying upon the judgment of the alter.
That I am not disputing. But you are before the invocation of jurisdiction is bad, sir. So you'll have to withdraw it and file under 227.
By under Article 227, the jurisdiction will be very limited, but because that will be the only surprise.
And I have to dismiss it. I don't have it. But how? I'll just show you, sir.
Yes, my lord. That's true, my lord. Still, how, my lord? Because here.
You see now, and this is a reference petition.
Yes,
3 judges, Radhesham versus Chhabi Nath. Accordingly, we answer the question: judicial orders of the civil court are not amenable to writ jurisdiction under Article 226. Jurisdiction under Article 227 is distinct from jurisdiction under 226.
That's true, madam. That's true.
आप 227 में आ जाओ, वहाँ देख लेंगे. Supervisory jurisdiction में the court can do whatever.
That is true. So I came under 226 because
against the judicial order.
Because here I was seeking a writ of mandamus against the state government that they should deposit.
Oh, you see,
because here
a judicial order comes between you and the relief.
Yes, madam.
Judicial order cannot be set aside by invoking the power of issuance of writ of certiorari. That is the problem.
But if the order is passed by the labor court, that those orders are certiorari is maintainable there. Writ petition is maintainable there, madam. Writ petition is maintainable to get that order.
You see, problem is this.
Similar is the here, my lord.
There will be a subtle difference. Under the Land Acquisition Act, the orders that are passed by the learned district judges under Section 18. They are not assailable under, they are assailed as FOs.
Yes, my lord.
They are assailed as FOs.
Not under, I am not.
Here it is an execution petition.
Yes, my lord.
Meaning thereby that that as far as a reference court is concerned, it is treated as a court. Labor court is not treated as a court.
Yes, that will be.
That is not treated. It is a tribunal.
Because here
it is a tribunal. So therein that L. Chandra judgment comes into picture. That Supreme Court L Chandra, it comes into picture.
Because here, my lord, I am, because otherwise, yes.
So withdraw, sir, withdraw करके इसमें 227 there is no issue.
Because my lord, we have to make a state, because state is also party here. So certainly when it's.
You see, you are challenging the, you are aggrieved by the order that has been passed
By the
ADJ.
By the
ADJ.
decision, my lord.
Yes.
True, my lord.
So, but naturally, it will be a petition under 227 against all those who were the respondents there.
It's not,
State is the respondent there.
yes, my lord, state is the respondent there. my lord.
पर इतना आपने learned senior after making submission sometime praise for his permitted to withdraw the petition to assail the order passed by the learned additional district Rodu by way of proceeding under Article 227 of the Constitution. Next.
My lord, the same will be in the other two cases.
Next. Yes, please, Sunil Awasthi.
I am appearing vice. मैंने kindly short pass.
ठीक है सर.
Lieutenant Counsel is busy in the court number 5.
आज नहीं है फिर आज आपका स्टे चला हुआ है इसमें. हाँ? चलो let him.
Because he's filed an application. My lord, actually he is busy in another court right now. He will be joining us shortly.
We'll pass it over, sir.
My lord, may I just put one thing? I had filed the rejoinder to this application day before. It has been sent to the branch, but they're not filed it with the file.
Let it be hear the main case.
Main case.
Hear the main case.
ठीक है.
Time permitting. Fresh compliance affidavit, sir. Nimish, ये क्या है?
This is the execution petition. My lord, may kindly have the last.
You see, Maina, let us be very candid. Read the order, whether it has been complied with or not. In execution petition, you cannot be allowed to agitate the order. Let us read the order. What is the judgment?
Yes, my lord. My lord. Annexure E1, my lords. The relevant portion would be page 19, my lords, para 12. In view of what has been, yes, my lord. In view of what has been discussed herein above, the action of settling the petitioner with the recovery without holding.
तो आपका stand क्या है ये तो बताओ पुष्पिंदर.
Well, they have reasserted the stand which has been taken earlier in the affidavits.
No, but you see, if you go through their affidavit, they say that you have been आपको 8, 16, 24, 32 का benefit दे दिया हुआ है. अगर मिल गया तो मिल गया. ACP means ACP.
2 minutes. May kindly have.
Okay, let us wait. आप लगे किस पोस्ट पे थे?
I was forest guard, my lord.
कब लगे थे?
1981, my lord.
1981. Next promotion कब हुई?
That was in 2008, my lord.
2008. 2008 में आप लगे सर?
Yes, my lord. Forest ranger IG.
Forest ranger.
Now what they say is
just one. नहीं आप 98 में बने फॉरेस्ट रेंजर. According to them आप 98 में बने फॉरेस्ट रेंजर. फॉरेस्ट रेंजर किस बने 98 में सर? पैरा 4 पढ़ो कहीं 98 में बने. अब क्वेश्चन ये है कि आपकी स्टैग्नेशन हुई है 1981 से लेकर 1998 तक. तो इसमें हमारे को ये देखना है कि क्या इन्होंने आपको एसीपी का बेनिफिट दिया या नहीं दिया. तो अगर वो मिला तो फिर
my lords, the judgment specifically speaks about 4940.
ऐसा ना.
Yes, ma'am.
Yes.
Yes,
but in the garb of the judgment there cannot be any windfall gain.
My lord, may kindly have page 9 of the affidavit which has been filed by them, my lords. This is proficiency step up white CF Chamba or number such and such. So this has been given with the same pay scale, not the enhanced pay scale, my lords.
That is a separate issue.
Yes, my lord. Yes, my lord.
आप ना रिकॉर्ड दिखाना जरा, व्हेन हैव यू गिवन द एसीपी? इसको फिर निविश किसी आप ना इसका रिबटल दे दो,
दे देता हूँ जी।
यू फाइल अ रिबटल दे दो, ठीक है?
इस मान
कोई बात नहीं, इसको रिबटल देने देते हैं।
ठीक है जी।
Learned Additional Advocate General submits that in terms of the contents of the नहीं ऐसे लिखना, Learned Additional Advocate General has drawn the attention of the court to the compliance affidavit and the apprises the court that the petitioner was already granted the benefit of 8/16-24/32 ACP scheme. Full stop. Learned counsel for the petitioner disputes this fact. He submits that he may be granted some time to file a rebuttal there. To let needful be done within 3 weeks.
इस मान
देखते हैं इसको, आराम से देखेंगे, कोर्ट के साथ टैली करेंगे, अगर मिल गया तो नहीं, अगर नहीं मिला तो मिलेगा, क्योंकि वो उस पीरियड में देखना है हमने ना, जो इनिशियल अपॉइंटमेंट एंड प्रमोशनल पोस्ट के बीच, उसके बीच का पीरियड सिर्फ असिस्ट करेंगे। आपने भी उसी पॉइंट पर असिस्ट करना है। श्री राजेश वर्मा, compliance affidavit filed.
They have sanctioned my pension, revised pension, but they are not actually paid me now. So, Treasury is.
What is the order?
They were directed to count my work charge period towards pensionary benefits. Page 9.
अब क्या हुआ है, साथ में ही क्यों किया इन्होंने?
17 से मिलनी थी जी, 17 से सैंक्शन आप करिए। एक्चुअली पे नहीं किया जी।
और लर्नड अब क्या इन्होंने किया, क्या है, पेंशन ऑर्डर बनाया हुआ है?
हाँ
Learned, the court stands informed that the pension of the petitioner stands devised. However, the arrears etc. have still not been paid to him. ठीक है?
Yes. ये जो बन रहा है वो तो दे दो ना।
नहीं वो भी नहीं मिलेगा, प्रोस्पेक्ट तो वो तो
नहीं जो इन्होंने सैंक्शन किया वो ही बोल रहा हूँ।
वो भी अगर नहीं मिलेगा तो नहीं मिलेगा, सैंक्शन करने से क्या हो जाएगा? सूरजमणि पढ़ो।
सूरजमणि तो मैंने देख लिया जी। हाँ। वो तो सिर्फ 2 साल का जो मेरा इंक्रीमेंट्स बढ़नी थी वो नहीं मिलेगी।
इसमें सूरजमणि कहाँ से लग गया? ये सूरजमणि नहीं है, डाउट सूरजमणि।
हाँ जी,
दिस इज नॉट सूरजमणि।
सूरजमणि का तो है नहीं। वर्क चार्ज पीरियड पेंशनरी बेनिफिट।
इसको छुट्टियों के बाद लगाता हूँ कंसिडरेशन पे, विल हियर इट। ठीक है?
ट्रेजरी वाले बोल रहे 5 किस्तों में देंगे जी। ट्रेजरी वाले बोल रहे कैश किस्तों में देंगे।
ट्रेजरी वाले क्या बोल रहे हैं?
किस्तों में देंगे जी, 5 किस्तों में।
टोटल कितने हैं?
ये तो ग्रेचुटी बनाई है जी, रिवाइज की उन्होंने। ग्रेचुटी का
learned counsel for the accountant general apprises the court that the pension of the petitioner stands worked out, that the revised pension of the petitioner stands worked out. Learned counsel for the petitioner submits that the arrears have not been. Additional Advocate General submits that the petitioner is not entitled to arrears as per the judgment of the Honorable Supreme Court in Surajmani. ठीक है? For consideration of for consideration of the case on this aspect of the matter. Based on that, छुट्टियों के बाद we'll consider it here. Yes, Deep Bala, counter affidavit not filed. Counter affidavit, ma'am, counter.
We have filed.
Counter affidavit is stated to have been filed. Registered to place the same on record this thereafter. Next. Fresh compliance not filed. ये वही वाला केस है, एसएमसी वाला और पीटीए वाला। दूसरे एक और केस भी तो था परसों रखा हुआ, इसमें वही है, आपने जो ग्रांटिंग एड देनी है पीटीए बेसिस पे देनी है। You see, problem is this. जब ये लगा था इसको आप कुछ भी नहीं दे रहे थे इसको जो मेगर. Now you are taking this stand see. But again the same issue arises. Yesterday there was a learned counsel who pointed out कि आप कुछ एक केसेस में PTA बेसिस पे दे रहे हैं डायरेक्शन के हिसाब से और कुछ एक पे SMC बेसिस पे दे रहे हैं तो वो गलत है.
Person who is a
Pardon?
similar person, they have granted the benefit. Madam.
Okay, Learned Additional Advocate General submits on Learned Additional Advocate General. Yes, so you see, अब इसमें टाइम नहीं मैं दूंगा या तो फिर आप इसमें तनख्वाहें अटैच करनी पड़ेंगी आपको. The court has very critically said in the light of the prayer clause, ना सर? प्रधान साहब की भी सुन लो. हाँ? आगे रख लेते हैं 10 दिन बाद. ऐसे लिखना इसको वापस ले लो. Learned Additional Advocate General prays for some more time to comply with order dated 23 April. Next Wednesday. चौहान साहब
कंप्लायंस कोर्ट नहीं.
जजमेंट क्या है सर?
Judgment थी जी, they have implemented that, they have said that we are similarly situated. तो E5 मैंने लगाई detail what they have paid and what remains to be complied with. Pay 26.
Compliance not filed 2 weeks. List not there. हैं? छुट्टियों की immediately बात. ठीक है. डेटा देते रहना. Vijay Thakur record received.
6 time to file rejoinder to the
Exactly matter.
Lordship, it is the matter where the industrial tribunal has passed an order and the retrenchment they have the industrial tribunal has considered my retrenchment as illegal. However, the compensation has been granted to me. I am seeking the reinstatement with back wages and all.
One thing, Malord.
Consequential.
The award passed on 7/4/22, Malord. He paid the amount on 5/1/23. He comes to the High Court on 13/7/24, Malord.
After accepting the amount.
After accepting everything, Malord, and after
Lordship, that
2 years, Malord. After 2 years, Malord.
How do you explain this conduct of the petitioner?
Lordship, I set in the reply, Lordship, to the facts they are mentioning. However, without instruction, I cannot make the submissions.
The reply stands filed rejoinder in 2 weeks.
Please,
Malord, may call for the
Reply not filed. Mr. Mahajan informs the court that reply has been filed. Registry to place the same on record. Rejoinder within 2 weeks. This record is there. Shri Dilip Sharma. Yes, sir.
Your Lordship, there is a case where in execution, Lordship, they are virtually overruling the judgment. Lordship.
What is the judgment?
Your Lordship, may kindly see the judgment. There is a clear finding in my favor at page 23, where 18 mark.
The outstanding amount is already due. Okay. तो अब क्या कह रहे हैं? मेरे पास तो कुछ भी नहीं.
ये कह रहे हैं कि जी ये इन्होंने एक कंप्लायंस फाइल की, उसमें कहते हैं हमने इनको कंसीडर किया और रिजेक्ट कर दिया.
दिखाओ कहाँ है कंप्लायंस?
इसमें
ही नहीं.
मुझे
आपके पास है?
8 मैं दूंगी कॉपी.
Compliance not filed.
8 मई की
10 days time prayed for granted. छुट्टियों की immediately बात.
15/5 को मुझे कॉपी रिसीव कराई.
Immediately after vacations.
It's not on record, man.
कुछ भी नहीं है. मैंने cognizance नहीं लिया किसी भी चीज. मैं कह रहा हूँ not filed.
Which statement?
बताओ. 18 sir. Yes, Suminder Gupta. HPU. Reply. Miss Pooja. चंदेल साहब आपका केस है क्या? केस क्या सर?
ये मेरे हक में ऑर्डर हुआ था ट्रिब्यूनल से. That was not complied with. But anyhow, not they are coming with some order. Not they have passed some order. Not. She may take it next week. Not I'll take instructions. Not.
Just 1 minute.
The tribunal had passed an order saying to consider. We had considered and communicated it to the petitioner. That stands rejected.
Learned counsel for the respondent university informs the court that the order of the tribunal was complied with and order was passed by the finance committee in its meeting on 13/6/2019 itself, which was duly conveyed to the petitioner. Mr. Chandel submits that he may be granted some time to instructions with this. Hafte ke baad date.
Please.
Date. Next. Yes, Shivam, yes, Shivam? Huh? What is the order?
Directions were to count the services of the petitioner for the purpose of pension and increments, Your Lordship. Though, Your Lordship, the part where increments is concerned, Your Lordship, the Honorable Apex Court has stayed. As far as pension is concerned, they are bound to implement.
Not filed, 3 weeks. This way.
I'm grateful.
Yes, please.
These are the objections that have been preferred by the state, and along with this, there's our application seeking release of the awarded amount. 50% had been released earlier. This is our second application for the remaining amount, though we still have not received any copy of the reply.
16 का case has been decided. Learned counsel for the respondent submits that an application has been filed for the release of the amount. She submits that 50% of the amount has earlier been released, but this application is for the release of the remaining amount. Learned additional witness submits that in the light of the fact that the petition pertains to those Astara, let the same be heard on merit. Ordered accordingly. List for final consideration. July के first week की date है.
Grateful.
Application में लिख देना in the light of the fact that the case has been ordered to be listed for final adjudication. No order in the application at this stage. Dr. Ramchand, yes, please.
Lordship, I am appearing vice in this matter. I am praying that this matter may be taken up next week.
आपके फेवर में जजमेंट का है दोस्त?
Lordship, I don't know about this case, Lordship. I have just been informed for seeking adjournment in this matter.
एक मिनट रुको. Notice. OB. Yes, please.
In this case, they have come with some instructions, Your Lordship, as per
Judgment क्या है पहले ये बताओ.
judgment, Your Lordship, the direction was issued.
Take the case.
Take the decision on the representation of the petitioner, Your Lordship.
The arrear of the petitioner, Your Lordship, it become 8,48,278, and we have already 3 lakh rupees we had released, Your Lordship.
What about the balance?
Today we are releasing 1,82,760 rupees, Your Lordship.
59
In favor of.
What about balance?
We will.
Rest के लिए बोल रहे हैं कि ये rest of the amount will be paid in 2 equal installments in the year 2000.
साल में तो फिर क्या फायदा होगा इनको? की प्रॉब्लम 8 लाख का. But there is one problem, dear. What was the order passed in your case?
Your Lordship, direction was issued to
कोई लाज नहीं.
represent.
If you are aggrieved by this,
Your Lordship, I will challenge the same.
इसमें लिखना notice accepts notice. Learned counsel for the respondent submits that a decision has been taken by the respondent corporation to pay the arrears amounting to rupees 8,48,278 to the petitioner. He further informs the court that out of the said amount, an amount of rupees 3 lakh plus 1,82,759 has been paid. Full stop.
ये आज
आज इनके खाते में पड़ जाएगा.
क्या लिखा है सर? नहीं, 3 lakh stands paid, whereas rupees 1,82,759 shall be credited into the account of the petitioner to date. As far as the balance is concerned, he informs the court that it will be paid in 2 equal installments in the month of May 26 and May 2027. Mr. Manohar Lal submits that in the light of these developments, these proceedings be closed, but with liberty to the petitioner to assail the act of the respondents of paying the arrears to the petitioner in installments. Proceedings closed with liberty as well. Yes, Goel Saab. इसमें order क्या?
Copy has been dispatched to the delivered in the office of the respondent, my lord, and petitioner has not been paid even a single pen. At least a gratuity amount may be ordered to be.
Notice.
My lord, actually gratuity order may be please.
Notice. या तो दस्ती सर्व करा दो सब फिर देख लेते हैं. दस्ती सर्व कराओगे इनको?
सर हमने दी ऐसे उनको 2 कॉपियां.
Notice. Steps within 1 week. Return for that.
My lord, I will have to personally deliver that.
But I can't take cognizance. Pradeep Singh.
Can we just close up with the direction that we will decide the petition in 2 weeks?
2 weeks. Closed. Liberty.
Your Lordship, they were to grant pension.
इसमें ऑर्डर क्या था मोहित?
For the grant of pension.
अभी तक नहीं दे रहे? नहीं नोटिस 1 से 3 से 4 के लिए 3 weeks. कहाँ पहुंचे सर? Total कितनी? Yes, Ankit.
Well, matter pertains to PNMD award. Judgment was passed in my favor, my lord. Way back in.
No compliance.
No compliance, my lord.
Notice 3 weeks. List on dash. पिछला वाला भी date. Satish, state.
Your Lordships, in this case, this is an execution petition for compliance of judgment of CWP number 30 of 2024. The said judgment has been partially implemented, Your Lordships.
Just one. Order क्या था?
Your Lordships, the order was
partially implement हुई है. फिर क्या रह गया हुआ है?
Your Lordship, there have been monetary benefits have not been.
Notice 3 weeks.
Obliged, Your Lordships.
Yes, please.
This is the execution petition, Your Lordship.
Order क्या है sir?
To decide the
3 weeks. 3 weeks. Yes.
28, 30 and 31 are similar.
Same order. Liberty.
Yes, Your Lordship. Grateful.
Yes, sir.
My lord, after the execution on 9th May, they have fixed the pay. The only direction which is to be issued that they may give the actual monetary benefit from the date which has been offered. Otherwise, they have fixed the pay.
May not be a, I'll order the copy to my friend also.
And it can be disposed of also. ये अच्छा ये मैं ले लूँ वही वही होनी है मेरे पे हाँ जी मैंने हाँ वही है पे फिक्स इसमें
ये ठीक है सर इसमें जो कैलकुलेशन
हाँ हाँ बस ये
रिकॉर्ड पे लेना है
हाँ इसको ले ये भी दे रहे हैं ये पूरी चिट्ठियों के साथ दे रहे हैं
क्या लेना है ये या ये
इनके वाले में ज्यादा ताकत है जी मेरे
ओके नोटिस पहले हुआ है नोटिस
नहीं फर्स्ट है
accepts notice on his instructions. The senior counsel, on the basis of instructions received from Secretary HV Vidhan Sabha, dated 20th of May 2025, informs the court that necessary order has already been passed by the authority in compliance to the directions passed by the court. The copy of the order is appended with the instructions. The senior counsel for the petitioner has perused the same and he submits that the same satisfies the order passed. The instructions are taken on record. Petition closed. Disposed of.
And they may pay the actual benefits.
Goes without saying that the actual monetary benefits to which the petitioner is entitled to be released in his favor as expeditiously as possible and preferably within a period of 6 weeks from now. Next. Yes, sir. Safi. Speaking order, 2 weeks, decide करो. Next. Please decide, है ना? 2 weeks के लिए. Kuldeep Singh.
This is my execution petition, Lordship. Annexure E1, Lordship, page 10.
इसमें है क्या?
रिकवरी का है.
हाँ तो ठीक है, अब क्या बचा है इसमें?
रिफंड और रिकवरी.
खबर इन्होंने वापस नहीं किए नोटिस. निगम बिहार की स्पेलिंग क्या होती है? आपने तो जुरिस्डिक्शन ही उड़ा दी है हिमाचल हाई कोर्ट की. विहार है, बिहार नहीं है, हैं? निगम विहार व इसमें लिखना नोटिस 1, 2, 3 सरकार 4 के लिए है. 3 weeks. Next. Yes, Dhanvanti. Yes, please. इसमें क्या हुआ राहुल?
Compliance has been done.
Where is your friend?
He was in the court.
बुलाओ जरा उनको. कुछ बता दिया है? He is happy? पक्का? दोनों की प्रेजेंस लगाना. The court stands informed that the order in issue stand for proceed is closed. ठीक है सर? Application is closed. Yes, please. Mahesh Sharma, Parav Sharma. Yes. Notice. सरकार reply in 4 weeks, 6 weeks कर दिया.
I'll appear vice
कोई बात नहीं. Present sir. रविंदर चंदेल. Yes, please. Mr. Chandel, आपका है.
It says, Lord, this petitioner, Lord, she is in fact a life convict under section 302, Lord.
P11 क्या है?
Lord, after this Lord, completion of this 14 years of sentence, actual sentence, Lord, she applied for Lord her pre-release from the prison, Lord. Lord, accordingly, Lord, this Lordship, the other members of the state sentence review board, Lord, they opined in her favor, Lord. The only Lord is the presiding judge of this trial court, Lord. His opinion was against her, Lord. Lord, but they
were seeking quashing of what?
Questioning of Lord the opinion which has been given by the Lord this presiding judge trial court, Lord.
No.
Lord, the second round of litigation, Lord, she may just have, Lord, annexure P10, Lord. This, in fact, is the judgment passed in my favor earlier, Lord. Earlier opinion and the opinion based by the state sentence review board, Lord, that was quashed by the Honorable Court. And specific direction was passed, Lord, to consider my case on the basis of judgment rendered by the Honorable Apex Court. Lord, she may have the operative part, Lord, of the judgment, Lord.
This power is exercised by the learned district judge under which provision?
Lord, under 432, Lord. 432 CRPC. Now it would be.
Please read it.
She may have, Lord. This has been reproduced in the judgment itself also, Lord. Power to suspend or remit sentence. When any person has been sentenced to punishment for an offence, the appropriate government may at any time, without conditions or upon any condition which the person sentenced accepts, suspend the execution of his sentence or remit the whole or any part of the punishment to which he has been sentenced. Whenever an application is made to the appropriate government for the suspension or remission of a sentence, the appropriate government may require the presiding judge of the court, court before or by which the conviction was had or confirmed to state his opinion as to.
There is one issue. If the learned such has passed the order in exercise of powers, statutory powers, under 432, because this court also happened to be the court, it has convicted the accused. Rather, he is now a convict. How 226 will be?
But my submission would be, Lordship, may just have, because there are the repeated judgments by the Honorable Apex Court also, Lord, and same has been referred, Lord, in the judgment and Annexure P10, Lord.
Let us see.
Take Lordship to
Annexure P10.
Please, Lord. The relevant portion would be, Lord. And if prior to that, if Lordship may just have page 34, Lord, because this is the earlier opinion which was given by the learned presiding judge, Lord.
I'm not on the merits of the case.
Please.
I'm on the issue of maintainability.
Lordship may have page 43, Lord. Internal page would be 15 of the judgment. In the case of para would be, Lord, 6(3), Lord. In the case of Raju, such and petition number 253 on 25th August, the Honorable Apex Court has held that the presiding judge of the convicting formulated his opinion based on the reasons after taking into account the pre-conviction sentence factors, post-conviction sentence factors.
Where is this judgment?
This
की citation है?
जी.
So, अभी तो खैर नोटिस ही होना है, अभी तो फर्स्ट टाइम लग रहा है
नोटिस होना है,
बट मेंटेनेबिलिटी का क्वेश्चन पता है, इसमें दिखाना था मेरे को. Show me the judgment of Supreme Court.
Probably not. This not the.
What will Supreme Court say?
Lordship may take some other day. I'll get judgment on.
Okay, I'll just adjourn it because I want to see the.
Please, not I'll.
Monday, Tuesday. Monday, Tuesday.
Any day.
Tuesday. Monday. Monday. Just on Monday. Just convince me on that aspect.
Please, no.
अब ये क्या है? Same?
Same.
ऐसे करते हैं, नहीं तो इसमें मैं इशू कर देता हूँ नोटिस सब्जेक्ट टू द इशू सब्जेक्ट टू मेंटेनेबिलिटी. नोटिस सब्जेक्ट टू मेंटेनेबिलिटी ऑफ द पिटीशन 3 हफ्ते लिस्ट ऑन डैश रिप्लाई इन द मीन शूटिंग के बाद आपने पर असिस्ट करना है इसको. नॉट वेरी श्योर. यस प्लीज.
I've been just told that steps were taken by us. Then PF was returned with some objections. It was again taken, Lordship.
Just 1 minute, sir. मैं एक एक करके लेते हैं, फिर आपने उस हिसाब से करना है. इसमें लिखना as per the report of the registry, respondents 35(1) to 35(4) served. कोई आ रहा है? As none is present despite service ex parte. Full stop. Further, service of so and so is awaited. Awaited till the next date of hearing. यही से ले लेना नरेंद्र जी है. फिर CMPM steps not taken for the service of proposed LRs. Let needful be done within 2 weeks. After notice we should return for dash.
ठीक है.
एक और CMPM है. Correct address of not filed. So and so not filed. इसमें भी let needful be done in 2 weeks. Thereafter fresh notices issued return to dash. चलिए. Yes, please. Hazri.
Lordship, this matter pertains to mining legal. I have pointed to the Honorable Court that the same matter is pending before Honorable DB Bench. Has not been listed from last
matter. What do you mean same matter?
Your Lordship, in this matter, the issue is that I have applied for the mining in the year 2013, and now I am being directed that I have the laws of 2018.
As करो, इसमें क्या दिक्कत है? एक कहाँ है बार की, अगर DB में मैटर पेंडिंग है तो सिंगल नहीं सुन सकता.
That issue is already pending before DB.
नहीं तो इसको बहस करो ना.
We'll do it on the next date, Your Lordship.
आज करो. मैं आज.
I'm appearing vice in the Learned Council level.
Let us see है क्या issue क्या है संभव.
I'll just. Lordship. The main issue is that order was
2020 के cases, these are very old cases.
absolutely, Your Lordship. Order was passed by this honorable court that I have to deposit 25% of the interim compensation. That's then deposited. Thereafter, Your Lordship, that the mining
P18. Let us see what is P18.
Lordship,
You are not prepared.
I am not having the
संभव की रिपोर्ट है। अब इसको लगा दो आप छूटेंगे immediately बात। On his request adjourn list on that. इसमें adjournment नहीं मैं दूंगा।
Please, Your Lordship. Please, Your Lordship. Great.
Yes, Mr. Gupta. ये आ गया मुशर्रफ
अली आ गया जी, लेकिन आज इतना काम किया जी, इतना काम किया, सिर्फ सवेरे से दूसरा केस अभी पेश हुआ जी, दिमाग बिल्कुल थका पड़ा है जी।
पहले तो कम वक्त हम ही हैं यहाँ बैठे।
हैं जी?
पहले तो हम कम वक्त हैं यहाँ।
नहीं, आप तो मैं बता रहा हूँ जी कि सवेरे से आई एम सिटिंग आइडली आउटसाइड। एक 4 नंबर में किया जी, दूसरा आपके पास, अब तीसरा ये है जी, दिमाग बिल्कुल थका पड़ा है जी। इसको आगे करेंगे
ये तो हम दुखी हो गए यहाँ पे पानी की गाड़ जी। ये इसको देखिए वही है ना, ये मंदिर वाला केस।
मंदिर वाला, इसमें मैं बताता हूँ जी, स्टेट का जवाब भी जो है, स्टेट का जवाब भी ये कहते हैं जी 6 to 10 have nothing to do. They are asking for setting aside of that mutation also.
एक सेकंड, प्रेयर क्या है इसमें?
For removing the illegal construction.
But who are you?
I am co-sharer.
ऐसे
मेरे को जी during the time of Raja Sirmaur, half of the property was sold to me. My predecessor in interest, who then gave it to in gift to.
Give the declaration that the construction is unauthorized.
My lord, this is what has been come in on the record. This is what has been come on the record. And
आपने किया illegal construction.
What I had pointed out on the last date, and in fact, my lord had also seen, the entry of possession in my favor has been recorded on the basis of the order passed by a competent authority, my lord, in which they were also party. That mutation, that order, that entry has never been assailed, my lord. That entry has never been. Now, there was an alternative remedy. They were party in that. They could have assailed it that.
My lord, what I am submitting is, my lord.
तो इसमें तो करण निकलेगा सनी देओल।
चलो जी भेज देंगे जी नेबरिंग स्टेट में वो हैंडपंप को काटने के लिए जी।
ये है
टेकन आफ्टर वोकेशन। मैं आई ट्राई टू सेटिस्फाई कि हाउ एंड इन व्हाट मैनर योर लॉर्डशिप कैन एक्सरसाइज द ड्यूटी।
I am not Hanuman who does not know how much jump he can.
नहीं जी, मैं तो सरकार के एम्प्लॉइज को
in exercise of my duty, in all likelihood the petition is likely to be dismissed.
मैं तो आपके थ्रू सरकार को, हनुमान जो है जी सरकार में बैठे हुए, उनको उनकी शक्तियां याद दिलवानी है। What they are doing.
They say we are a secular government.
नहीं, that's why उनकी शक्तियां याद दिलवानी है जी। They are doing.
Let's see the council press for that adjournment.
I'm appearing for respondent number 2, lordship.
Yes, Ajit. Yes, Mr.
The crux of the matter is that I was a tenant. My tenant.
वो वाला case है।
The only obvious question would be that offered something, why it is not being occupied. My lord, kindly have an application which has been filed by me. I'm sorry, I could not just we could not just have a.
अब issue क्या है?
Yeah, what they are offering is not only towards the end of the bazaar, but it is in a dilapidated condition. The persons who bought it in auction, even those persons were unable to pay the rent. All shops are lying shut, and they are offering. They have made an offer mysteriously in that remote part of the town where there are no commercial activities. Can you have this application, my lord? I have a next.
Shop number 3 दे नहीं दे रहे हैं आपको?
Shop number 4 दे रहे हैं.
What about 3? Why shop in the order?
I have made one suggestion.
It was recorded shop number 3. Why not shop?
No, that portion has been demolished.
that
No.
where I was a tenant.
Court stands informed that the petitioner can be rehabilitated in one shop.
Yes, ma'am.
That is shop number 3, which is lying vacant.
Actually, it should have been 4 according to their 3 years. They have made a.
Mr. Gupta, then अब थोड़ी मेहनत तो आपके क्लाइंट को भी करनी पड़ेगी.
अजी हमने की.
थोड़ी मेहनत तो करनी
हमने करी जी.
उसको.
नहीं हमने एक चीज बोली है. And it is well within their power and authority also. Next to the rain shelter, there is land vacant. I made one proposal. No, I am a tenant. I am not an encroacher who's asking for something. Encroacher, had I been?
I know that.
Yes, ma'am. Grateful lordship, but once my right has not been determined, they can't now put me there where the persons who bought it, were unable to pay the rent because there is no commercial activity. One, two, the condition of the building is so bad. Rest of the all shops are lying vacant. It is stated on affidavit. All shops.
But why did you come to the High Court?
I came to the High Court because proceedings were initiated against me. An order of eviction came to be passed without even considering my stand. What is my status? I'm not a tenant. I am not an encroacher. I am a tenant. My tenancy has not been determined, and it is pursuant to a written resolution that I was asked to move out for some time. अब खाली जगह है और I have
खाली जगह पे नहीं बनवाएंगे, बना के दूंगा. जो बनी हुई है उसमें से कोई एक शॉप ले लो आप.
कोई भी नहीं है. अभी कंसीडर करें.
फिर नहीं है, फ्रेश थोड़ी बनाएगा आपके लिए.
नहीं मैं नहीं बोल रहा जी. मैं ये बोल रहा हूँ where I am there, remain there only because a new building is coming up next to the rain shelter only. There is a proposal, they have passed it. I can wait for some time.
No, I can't say that. Maybe.
No, I'm not.
God knows what.
I'm not asking.
How much rent that building may fetch.
I'm not asking for anything. At this stage only, I'm saying that that's a representation being made to the Honorable Court. It can be admitted also. It can come up in due course also. Or they can consider in the meantime. They may consider. They may file reply.
Then you see, then I'll confine myself to the legality of P9 and P10.
Yes, yes. Lordship may hear me then on that.
Oh.
Yes. Lordship, this I have an extra P1. An extra P1. This stall is allotted and in favor of my predecessor in the month of July 1985. And it is in respect of a stall, Gurbachan Singh.
Who was your predecessor?
Mr. Gurbachan Singh.
Relation?
My father, it's his father. I was inducted as a tenant in respect of one stall. The rent is also indicated there. And in July 1985, I occupied my lord. The area is.
You see, you did not occupy it. Gurbachan Singh occupied it.
Gurbachan, my predecessor.
So, meaning thereby that it is not as if shop was allotted to you.
No. My predecessor. It is stated so.
So let us say one Gurbachan Singh.
One Gurbachan Singh. One Gurbachan Singh is allotted this shop allot in 1985. The area allotted is 120 square meter, and like him, many other persons, my lord. Now, my lord, what happens is.
What happened after his death?
After
you come in possession thereof.
I am continuing. After his death, I continue, my lord.
What capacity?
As legal heir, my lord. No, I'm a tenant.
No, sorry. These are commercial. These are commercial premises.
It is within the notified area committee.
The commercial premises demonstrate that you are in the same business, etc., etc.
I'm continuing, my
lord. Your possession, it is unauthorized the moment the original person dies.
Yes, ma'am.
Anyone in occupation thereof, the possession becomes unauthorized.
Well, one thing is there. One Gurbachan was a tenant. The tenancy is there, not determined by any order.
That determines it.
My lord, automatically after that, my lord, I, the legal heir, will have to show that the business is being continued.
Because it is a commercial premises.
Yes, ma'am. So under the Rent Act also. It is under the notified area committee. Provisions of the.
They proceeded against you under the public premises. Let us see what was your stand.
Yes, ma'am.
Before the authority.
Yes. Before that, lordship would like to see that resolution on the basis of which I yes, that is the next of P3 at page 24.
Please read it.
At page 24, kindly have my lord. After these presence is recorded, पुष्टि बैठक में सदस्यों द्वारा पिछली बैठक की कार्रवाई की पुष्टि की गई। प्रस्ताव संख्या 2 सफाई व्यवस्था बारे के आगे 1 at page 25.
26 or 25 लास्ट प्रस्ताव संख्या नंबर 5 लास्ट पेज 25 लास्ट एट द बॉटम। नगर पंचायत के बस स्टैंड पर असुरक्षित घोषित शॉपिंग कॉम्प्लेक्स के किराएदारों के रिहैबिलिटेशन बारे बैठक में नगर पंचायत के बस स्टैंड पर असुरक्षित घोषित शॉपिंग कॉम्प्लेक्स में नगर पंचायत के जिन किराएदारों के पास कारोबार करने के लिए जगह स्थान नहीं है उनके रिहैबिलिटेशन बारे चर्चा की गई और निर्णय लिया गया कि सुखचैन सिंह की देशराज व श्रीमती सुरेंद्रा, ये पिटीशनर है, सुरेंद्रा देवी को अस्थायी तौर पर बसाने कारोबार करने के लिए बस स्टैंड पर बनी वर्षा शालिका तथा उसके साथ कुछ खाली स्थान पर 3 दुकानों का निर्माण करके
Mr. Gupta, the issue is very simple.
Yes,
The issue is that proceedings have been initiated against you on the ground that there was a rain shelter and the petitioner without any legal right was shutter लगा के उसने उसे कब्जा कर दिया. This is their case, good, bad, ugly. This is their case. So first hear the queries. Now your contention is that sir I was in possession of a particular area. मैंने वो खाली किया क्योंकि इन्होंने reconstruct करना था. Issue will be that these are two separate issues. Prevail upon your client की जो मिल रहा है चुपचाप ले लो.
May I just today I made one application. Let them consider it. Let them come back to the
doubt whether anything can be given to you.
I have
मिल रहा है चुपचाप ले लो.
I have represented to them, and the petitioner has also met the official. They may take a call. They may take a.
There will be any further cause of action. Let me assure you, it will not be a further cause of action. ये देख लेना आपने ध्यान से. भागते चोर के ना जो मिल रहा है चुपचाप ले लो कहना.
अब ये लंगोटी होती तो भी ले लेते
दोनों कहते ना खुदा ही मिला ना.
Kindly appreciate one thing. I am not an encroacher. My right without data.
You see, I have a very serious doubts.
I'll tell
How do you enter into the footsteps of Gurbachan?
My lord,
that itself is an issue.
I will answer, my lord. It is in the notified area committee. Provisions of the Rent Act will apply. And if one Gurbachan was a tenant, if I can show to your lordship that I am legal heir.
I'm not going to go into it. That is not the job of the High Court under 226.
No, I'm not asking for determination.
Determination otherwise also.
I have to
because I will decide this list strictly on the basis of the defense taken by you.
Yes, ma'am. I have taken that.
देखूंगा मैं. अगर डिफेंस नहीं हुआ तो
मैं लिया
उड़न खटोला. लगा उड़न खटोला.
ठीक है.
Mr. Gupta submits that an application has been filed by the
yes.
And it would be the interest of justice in case the same is taken on record. ठीक है sir? As in terms thereof the petitioner intends to make certain prayers. ठीक है?
Yes, ma'am.
This is directed to place the application on record list on that. Should I have
Checking that in this maturity, I will file the reply to that application.
the record में तो आना दो ना. तब तक instructions दे लेना. If you have already a copy, have instructions. It can be helped because of.
We are intending to help.
Court is not coming in the way. R.L. Thakur. Yes, please.
No.
Yes, please.
No, this is my question. And not the respondents have constructed road in the year 2017 on my land without my consent.
But they have appended with their replies the gift deeds.
Those gift deeds pertains to otherwise other customer numbers. Not
these are disputed issues. Go to the civil court. High court can't decide.
Not these
are civil issues. These are disputed questions of fact, not to be decided under Article 226. 226 only if facts are not in dispute.
Not the consent. Quasi Khasa number 177.
This is a disputed issue. No? High Court will not become a civil to determine that the consent was given for which Khasa number. You have a right to receive money, but go to the trial. जल्दी सर मेरे पास टाइम नहीं है.
My statute pertains to these customer numbers. As far as the gift deeds they are talking about, that pertains to other customer numbers.
My problem is that these are disputed issues. How can the High Court go into it? That is what I am requesting you.
Not an accept even. Not an accept even is categorical that
Okay, let us see the customer numbers you say that have been.
The next P1 is 171, 178, and 179. And this is not a disputed question of fact that we are the owners. And this is also not in dispute that the road has been constructed over these customer numbers.
Just one minute. Huh? Show me the gift deeds.
Not gift deeds is we have a pending. Next R1 to R4.
How do you correlate the khasra numbers in the gift deeds with the khasra numbers which are mentioned in the written deed?
Number one, taking number 2 to 5 have given written deeds affidavit in the favor of the sponsor of this road. Petition number 1 is the co-owner of the land in question. Petition number 2 is 2 to 5. At the time of construction of the road, petition number 1 has actively participated in the road construction work, and the work through the land was carried out in his place with the legal is considered. Consent was given us.
Not.
We have that's the last this judicial paper also.
Not those gift deeds does not pertain to these customer numbers.
First, I will have it determined as to whether the land which you donated, whether it has been utilized for the purpose of construction of the road or not.
But para 2 they says that land in question.
What their stand is कि आपसे इन्होंने कि आपका रिजॉइंडर में स्टैंड ये है, आपने गिफ्ट में डोनेट कराई है, कहते हैं अब इन्होंने जबरदस्ती आपसे करवा लिए थे ये, लेकिन सड़क वहां से निकली।
I know, man.
This deed, this kindly read page, internal page 2 of the rejoinder.
Page 2 also.
पढ़ो इसको भाई।
It is also vehemently denied that the petitioner number 1 is to be participated in the construction of the road.
है कहाँ पे ये road?
Gori Bandi road है।
But that is this is the problem. These are disputed issues. I will not go into them in 220.
May I submit? Not in para 2, they say that road has been constructed over the land in question. So this is an admission on their part. The road has been.
But they said with the rider that the road has been constructed over the land for which gift deeds were executed by you.
Not those gift deeds were quasi khasar number.
That is the disputed issue. I will not decide it under 226. That is moving.
But my lord, the gift deed, the number for which gift deed has been given, I am also not disputing those khasar numbers. But I am disputing. They are admitting the fact that over khasar number 171, 78, and 79 road they have utilized this.
But as far as other land that has been gifted by you,
I have not gifted any land, my lord. Huh? I have not gifted.
You have not gifted. Who are you?
I am the one of the co-owners. As far as these khasar numbers, neither the petitioners, the gift deed of which has been annexed herein, even they have not given NOCs. Numbers.
You are successors in interest of Mansaram.
Please, Raj. The land in question is still in joint.
Just 1 minute. You see, ये तो है आपका दासूराम son of Mansaram.
Please, that is one of the corner and the deed. But my lord, that deed, the Dasuram deed, the number 177, 70%.
Issue है ना, मैं कैसे जा सकता हूँ? मैं आपसे यही तो request कर रहा हूँ. You have to lead evidence when there is a dispute between the parties.
Not because this is a revenue record pertains to Mandi.
Civil court में जाओ. ऐसे लिखना by way of this petition, the petitioner has paid for the following leaves. In terms of the reply filed by the state, the stand is that the road has been constructed over the land after gift deeds were executed by the parties. Stroke voluntary handing over of the land was done by the parties in favor of the state. This is emphatically denied by the petitioners who claim that no gift deed was ever executed, nor any voluntary handing over of the land was done by them in favor of the state in writing, as is being claimed by the state.
Quad khasra number.
Quad khasra numbers in issue. Taking into consideration, next paragraph, taking into consideration the fact that there is a dispute as to whether the land has been constructed over taking into consideration the fact that there is now a disputed question of fact as to whether the land is issued for which the claim prayed for by the petitioners was subject matter of the gift deeds, etc. This court is only considered.
This is not subject matter of the land because these are separate khasra numbers.
Sir, I am not disputing it, but High Court 226 में नहीं करता ये काम. That is the subtle difference. You will have to go to the civil court.
Court of rights have presumption of truth.
सर सिविल कोड को पढ़ाओ ये सब. मेरा काम नहीं है 226 क्या लिखा सर? That as these are disputed questions of fact which parties shall have to prove by leading cogent evidence. These proceedings are disposed of, but with liberty to the petitioner to the compensation filing appropriate suit in the civil court. It is clarified that it should not be construed that the court found merit in the contention of the petition. The court is not invoking its writ jurisdiction for the simple reason that there are disputed questions of fact. Therefore, it intends to give both the parties an opportunity to lead respective evidence before the learned court. Next. Yes, please. Yes, sir.
We request you review order communication with court.
क्या ये?
This is that matter where the house.
सर ये तो उड़ा दें इसको. बिल्कुल सर इसमें. By way of this application, the applicant.
दो section देख रहे हैं 39 और 49 to 40.
The applicant has prayed for the following. Having gone through the performance in the application as well as the order review of which is being sought. This court is of the considered view that there is no error apparent in the order and no ground is made for review of the order. Next.
I'm saying it will make for this one because I have filed an application. One is that I am paying it judgment because of the reason that on the last date of my not
इसमें नहीं है कुछ भी.
And इसमें कुछ नहीं है. That's why we have filed an application before the chairman my lord because I have constructed the house.
वो करेगा chairman.
But इसमें सिर्फ they are also favoring me, but they are saying that there is a judgment passed by the honorable court. It may not come.
I can't observe.
in the way.
I can't observe that.
Because what
I can only say that इसमें लिखना learned counsel for the petitioner submits that in the light of the fact that the petitioner has freshly approached the authorities for the redressal of his grievance, these proceedings be closed with the observation that the application of the petitioner be sympathetically considered by the department.
Yes, ma'am.
Proceedings are closed with the observation that let the application
one line
sympathetically considered by it. How can I negate a judicial order? यार उसमें एक बार
what
एक मिनट call that ऐसी वाला था stand petition उसको बुलाना था जो जिसका पीछे था ना 3 खसरों वाला उसको बुलाओ जरा इससे पिछले से पिछला ऑर्डर है. Just call that one. That's all. Next case.
Look, presence of my learned senior. He's here. Mr. Darisu.
कितना राजा जी की कोर्ट का कोई अफेक्ट
do it. Under what law? I don't have the powers.
Otherwise,
you are flattering me. I don't have the powers under Article 142. This is 142. Only Honorable the Supreme Court has 142. How can I say someone who has suffered the orders that up to the Honorable Supreme Court? Next case.
इसमें सिर्फ मैं यही बोल रहा हूँ कि basically they are favoring me because I have constructed the house and I have made a representation कि जी
Sir, I can't pass an order negating the judgments passed by the court upheld by the Supreme Court. Vikram Thakur. Empathetic. मैंने कुछ observation Vikram Thakur.
In case the file is in, I have tried 5 times, but I could not serve some of the private respondents, my lord. I would only seek a file the appropriate application.
But what is the issue?
My lord, the property is adjacent to my property, my lord. I have the corporation have issued notices to them. It is more of an execution petition, my lord.
Let us see. Prayers क्या है?
Please, my lord. My lord, the prayers are at page 11, my lord. My lord, the substantive would be at 12. That a writ of mandamus be issued against the official respondents, directing them to demolish the structure in question at the earliest. The entire record and
किसका structure गिराना चाहते हैं?
my lord, adjacent owned by the private respondents, which is in dilapidated condition. In case this my latest CMP seen, CMP 10676 of 2024, my lord. I prayed for interim directions and I have also annexed certain photographs which illustrate the dire state of affairs.
But इसमें ना Vikram,
My lord.
how can such a writ be issued by the High Court?
My lord, in case annexures are seen, initially annexure P1, my lord, in case is seen. This is my ownership of my lord. Annexure P2 at page 20 is the legal notice which I sent to the corporation, my lord. No action. P3 is the letter by the respondent corporation declaring the building as unsafe. Then, my lord, next notice at P4, page 27.
I'll dispose of this petition with the direction that you may approach the authority afresh.
My lord, only one submission. Kindly make it time bound.
100%. और यो आप दोनों भी पेश हो उनके पास. आप किसके लिए मैम? Municipal Corporation for 1 and 2. Who is appearing for the private parties?
Also, I'm appearing for respondent number 6.
बाकी कोई नहीं है.
They are not being served, but from the same family.
इसमें लिखना by way of this writ petition, the petitioner has prayed for the following. In the light of the order that the court intends to pass as no order adverse to the interest of the unserved private respondent is being passed. Therefore, this court is not insisting upon the petitioner to have them served. The petition has praised for this is disposed of with the direction that let the petitioner file a fresh application to the authorities highlighting therein the grievance raised by him by way of this writ petition, and the representation as from the date of receipt thereof be decided by the authority within a period of 8 weeks after complying with the principles of natural justice, i.e. after giving hearing to all the stakeholders. It is clarified that this court has not made any observation as far as the merit of the case is concerned, and the application shall be decided by the authority without being influenced by any observation made by this court in this law. Yes, please, Mahesh Thakur. Jai Krishan. Yes.
Yes, Smith. This pertains to the acquisition made for the Shruti hydroelectric project. Notifications which have been issued to lot. The first is the next E5 lot at page 46.
Can it be naturally? Not sure I could not mark the matter today in the list.
Notifications have been issued under section 90. First, under section 11.
I'm turning it now.
Under section 90, there is no provision for issuing repeated notification extending.
Not
could it be because what we are praying is that the notifications are bad. Could it be next week? It can be disposed of in the court.
File references now that
No, subject to our rights here in this writ petition, because otherwise our limitation there would have run out.
Fourth कर ले.
Fourth कर.
Nagar.
Fourth out.
Clear.
Lohara cooperating. Yes, Tarun. Doctor. Lohara. ये क्या आया था?
An award was passed in my favor after Mumbai National.
ना reply filed by R4 is under objection. आपने rejoinder file करना है उसका?
No, Lordship, not.
Okay, go ahead.
Check, sir.
हाँ?
I'll check, sir.
इसमें लिखना as per the report of the registry, reply filed by R4 is under objection. Mr. Arun submits that he will remove the objections within 1 week. Let the reply be placed on record if in order. Thereafter, if in order, rejoinder thereto if any within 2 weeks. Please thereafter. Yes, please, Kiran Verma.
Dhyanchand sir. हमारा judgment in question standing implemented for nothing.
हो गई है?
हाँ जी, हो गया. Area screening.
Mr. Chandel informs the court that the judgment is issued. Proceeding shows notice this. Yes,
Please, my lord, in this.
Mr. Bagga.
I filed forward on your behalf.
Okay.
I'm taking some time to file it.
Just 1 minute. इसमें लिखना आपने steps not taken for the service of respondents 10 and 11.
Lordship, we were not able to procure the correct address lately.
On the request of Mr.
However,
Bagga, 2 weeks more time is granted to take steps for the service of respondents 10 and 11.
we have taken the steps.
कब लिए?
Lordship, on 19th, on 20th, Your Lordship.
Okay. As per the report of the registry, steps have not been taken for the 10 and 11 by providing their correct address. Mr. Bagga submits that needful has been done on
20th of May.
20th of May 2025. Let fresh notices be issued of the steps so taken to the said respondents returnable for dash. ठीक है सर? अच्छा, इसके बाद है आपकी एप्लीकेशन है LR स्कोर के लिए, वो अंडर ऑब्जेक्शन है.
Lordship, we have removed the previous objections. However, the registry have put forth
फिर से लगा दिया.
objection. Lordship.
आप इतने दुखी क्यों हो रहे हो? अभी तो नए आया वकालत में, ये तो लगते रहेंगे ऑब्जेक्शन, है ना? Okay. Further, as per the report registry, the application filed by the petitioner to bring on record legal representatives of R6 is under objection. Mr. Bagga undertakes to remove the objections within 1 week. List after the removal of objection. Then, meanwhile, Mr. Chauhan may file power of attorney. Correspondent number. Yes, Mr. Charan Pal Singh.
Not even do the reply on behalf of 6.
Okay.
You not permit me to refer.
You see, there is one issue. I'll not be hearing these cases today. Reason, my hands are full before vacation. हैं? तो pleadings वगैरह complete अगर नहीं हुई तो करवा देते हैं, vacation के बाद सुनेंगे. तो ठीक है, वो भी खत्म हो गया. हाँ? Okay. आप किसका reply adopt कर रहे हैं? Okay. He is adopting. ठीक है. Learned Deputy Advocate General submits that respondent number 6 shall be adopting the reply filed by respondent 4 to 5. His statement is taken on record. Now what remains as far as pleadings are concerned?
Pleadings only if me not permit me to only one thing maybe for. I am not only praying that by the order passed on 7th of January, they were directed to come with the team they have prepared for rehabilitation and resettlement.
Just allow me to go through the order. Huh?
Yes.
Who is to prepare this scheme?
This is to be prepared by Kala,
By
authority for land acquisition. And in addition to this, the North has issued this notification after filing this petition.
As per your information, what has any progress been made in this?
No, my lord. They are doing nothing on this.
Okay, learned counsel for the petitioner, next para, has drawn the attention of the court to the order passed by, has drawn the attention of this court to the order passed on 7th of January 2025. He submits that despite the fact that the court had directed respondents 3 to 6 to ensure that before the next date of hearing, steps, if any, taken for preparation of rehabilitation and settlement scheme under Schedule 2 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act be placed on record so that appropriate orders are passed in this regard, comma, nothing has been done till date.
But in addition to this, it is documented by the ministry itself, it by the MOD. They say yes, second and third schedule is applicable, and Allahabad High Court in 34 cases passed the.
Learned counsel for the petitioner further submits that as per his instruction, no steps have been taken by the concerned authority for the preparation of the statutory scheme. This preparation of the said scheme,
They have not placed.
which is statutory in nature.
Yes, my lord, which is statutory and mandatory.
Which is statutory in nature and mandatory. Stated
They have
any.
not come up with any reply. Maybe they have started taking steps.
Learned Additional Advocate General submits that he may be granted some more time to have instructions in this regard. List on dash, the Learned Additional Advocate General to have specific instructions with regard to the order passed by this court on 7/1/2025. ठीक है?
This is also helpful.
आप इसको रख लो फिर ले दे देना. Don't worry, we'll take care. We'll take cognizance of this.
Any actual date?
Actual date, जुलाई के first week में. First second, 7 के हफ्ते में लगा. Pardon?
On behalf of
हाँ लगा दो presence लगा. Yes, please, next please. 8 July. Mr. Ashish Patel.
Yes, to file rules regarding Himanchu domiciles, issuance of Himanchu domiciles. I have filed the application. What is it?
Issue case.
The respondent of file note issued me a domicile certificate that you are not the resident of the area. My lord, in writ petition, kindly have agriculture certificate in my name.
ये वो है जो मदर आपके मदर वो वाला केस सर्टिफिकेट. Learned counsel for the petitioner submits that an application in terms of order dated 14/5/2025, which is directed to place the same on record. Tuesday को लगा देता हूँ. Just on next Tuesday.
So I have cleared everything yesterday.
वो है नहीं अभी आया ही नहीं. Udit Shureshwar question. ये क्या है सर? आपने रिप्लाई फाइल कर दिया? हाँ.
He said that initial demarcation of the authority due to some technical procedure, again they are initiating the demarcation. Lordship, I have spoke to the concerned official. He says the official signatory of the area is not here, Lordship. That's why I am not able to supply the instruction, Lordship. And as per the instruction, Lordship, the land was, the area was demarcated by the officials, Lordship, revenue official as well as the forest official, Lordship. And my lords, as per this, after the demarcation, Lordship, it says that some of the area of particular area was enclosed by the private respondent. Now they have filed affidavit before the appellate authority that they will vacate the that enclosed area, Lordship. So
what are your instructions?
Because I had also applied for the demarcation. Because when the forest department did the demarcation, at that time it was done just 2 months when there was a crop of wheat on the field. Now I had also applied for the demarcation.
Okay, Mr. Sumesh Raj prays for time to file reply. Let date will be done in 4 weeks this year. Shri Jagannath, Jagan ji, ये क्या है?
Lordship, my query is to direct the respondent for demarcation, Lordship.
मैंने आपको बोला these are disputed issues.
Lordship, there is no civil dispute.
क्यों?
Lordship, my query is simple. kindly see Annexure P6 Lordship at page 25 Lordship. They have the action Sundarnagar register number 4 has written a letter to register number 5 Lordship. Application to remove the encroachment from PWD road at Khasra number so and so measuring so and so. Application dated shown along with the enclosure received from Shankar Singh so and so so and so so and so necessary action in the matter. It is requested that the compliance in this regard may please to done with the.
You see, in their reply they say that there is a no enforcement.
Lordship, इन्होंने इनको लिखा जी ये बोल रहे जी ये पड़ता जी सुंदरनगर मोहल में वो बोलते ही पड़ता सड़क आदमी इधर से उधर कार है जी. Now after filing the return, they have just to Kango गया जी वहाँ पर they are not the competent to demarcate the land. Very simple prayer है जी demarcation कर दें.
मैं करवा देता हूँ खर्चा दो.
सर गाँव के आदमी खर्चा
देना पड़ेगा. ये तो किसी को कमिश्नर अपॉइंट कर देता हूँ 1 लाख रुपया.
Lordship, may I submit Lordship? Otherwise Lordship
है ना थानेदारी करनी तो फिर तैयार रहना पड़ता है.
Lordship,
आप कर क्या रहे हैं? थानेदारी कर रहे हैं.
Lordship, otherwise Lordship kindly see Annexure P2 Lordship, it is very clear.
हो जाएगा. बड़ा खर्चा पानी लगेगा.
Lordship, kindly see Annexure P2 Lordship, it is very clear Lordship.
सब कुछ करा दूंगा आप.
Pay
the cost.
He is unable to pay Lordship. He is poor people.
Then poorly dismissed.
मैं इंस्ट्रक्शन लेने की बात नहीं, छुट्टी की बात रख दी, मैं पूछ ली.
50,000 रुपया दो मैं.
Otherwise Lordship, वो he is unable to pay.
फिर लेने दो. फिर
छुट्टी के बाद रख ले.
क्यों लेने?
नहीं छुट्टी के बाद.
क्यों लेने? उनको बोलो अब क्या एनक्रोचमेंट हटाओ, ये करो वो करो.
और अदरवाइज
एक और
फिट केस Lordship.
एक सेकंड. उम्र कितनी है पिटिशनर की?
88 Lordship.
हैं?
88 Lordship.
कितनी?
88 Lordship.
फिर से बोलो.
88
तो 88 साल में कर आप सबर करो.
Lordship, the conduct of the respondent Lordship, kindly see page.
Commissioner की fee.
Lordship, kindly see the conduct Lordship, page 27. The Deputy Commissioner has written a letter to the Tahsildar Lordship.
Fee for conduct, fee for commissioners.
Lordship, they are the government of Lordship, kindly see the conduct. At page 27 Lordship. It is very clear Lordship.
These are all luxury litigation.
Lordship, the conduct of the Deputy Commissioner has also written a letter.
Dismissed.
Demarcation नहीं कर रही, इतनी सी बात है.
What the authorities concerned?
Lordship, डिपार्टमेंट वही नहीं कर रहा. डिप्टी कमिश्नर का लेटर लीजिए, उन्होंने लिखा जी पेज 27 Lordship. From duty
लिखना by way of this petition, the petitioner has paid for the following reply to the petition stands filed. A perusal of the reply filed by respondents 1 to 4 demonstrates that the land was demarcated.
Lordship, that was demarcated by the Kango. He was not competent.
That there is no encroachment over the aforesaid land belonging to the government as alleged by the petition. The court, full stop. Learned counsel for the मैं अभी भी बोल रहा हूँ. आपने करानी है demarcation.
छुट्टियाँ बाद रख लीजिए.
दो इंस्ट्रक्शन
नहीं, वो नहीं सुनाई नहीं पड़ता है थोड़ा एज छुट्टियों के बाद.
रहने दो मत.
नहीं, उसके बाद कर लेते. मैं इंस्ट्रक्शन ले लेता हूँ फिर ऐसा.
कल टुमारो.
नहीं कल नहीं हो पाएगा, फोन पे नहीं होगा. ही जोड़ में
मेरे को मार्क हुआ था, बोला जे केस डिसाइड कर सिंह.
Lordship, he also lost in civil litigation. Lordship, I next the judgment.
That is another concern.
No.
Lordship, Lordship, my humble request, Lordship, may I take now.
In the light of the fact that the respondents are of the encroachment upon government.
Lordship, otherwise it is very injustice, Lordship. From the perusal of the record, Lordship, it is very clear case. Kindly see the Lordship, kindly see the Tima Lordship. Where is the that Khasra number Lordship? There is a road Lordship. Another line from the another person. There are thereafter another Khasra number which was acquired by the government land, and so they road Lordship.
No case for interference is made out. The counsel for the petitioner submits that the demarcation carried out by the respondent is no demarcation in the act of law. In case the petitioner is agreed by the then he may assail the same in the court.
What Lordship?
Challenge it, sir. Demarcation is not Magna Carta.
No, Lordship, that is not by the competent authority.
That is a Jaganji, that is a
very Lordship, मेरी छोटी सी simple request है.
That is a ground to challenge.
As per law demarcation कर दी, मैं थोड़ी कुछ बोल रहा हूँ.
मैं कह रहा हूँ पैसे दो, जूते ले लो, पैसे दे दो.
Lordship में मैं पूछ लेता हूँ.
अभी पूछो, मैं बता रहा हूँ आपको.
Lordship kindly.
अभी 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 सुक्का नहीं है कल तो दौड़ गया 50,000 रुपया Shri Karan. Yes, Karan.
Madam, in this we have exchanged certain proposals. This is that matter pertaining to that crematorium. We have certain proposals, so probably something may happen. So it may be taken up after a few days.
Yes, madam. Okay, learning application for the parties submit. As the parties are making an endeavor to amicably settle the issue, the case be taken up after 3 weeks. List on that. Yes, please.
Educational Society.
Yes, Mr. Goyal. Vivala ये भी की different.
This is nursing and BSc nursing and A&M course.
It is up.
हाँ जी.
ये क्या issue क्या है?
So in this we have requested that we be attached to the hospitals around Shimla within 50 kilometers.
What are they saying?
So the case was recommended by the secretary, which is at page 55.
Finally, now what do they say?
The honorable, there is rejection.
Private party has to manage the hospital. Attachment.
Lordship may just have page 56, 57 and 58. It has been rejected by the honorable minister in the end.
Just 1 minute. But if I'm not mistaken, अब कोई ऐसा इसका है तो नहीं पॉलिसी में चेंज हो गया कि जो प्राइवेट है उनको अपने हॉस्पिटल करने पड़ेंगे?
नहीं ऐसा नहीं.
ऐसा पॉलिसी दिखाओ कहाँ है? पॉलिसी. Where is the rejection?
My lord, page 57 I was pointing out.
Just
56.
57.
If lordship will have page 56, note 39.
Note
39, my lord. In second para, in view of the above, the proposal of the Director of Medical Education for attachment of Civil Hospital Sunni and CHC Dhami with Shimla Nursing College, Shimla is submitted to the higher authorities for consideration. Further orders, please.
ये कितने किलोमीटर के रेडियस में होनी चाहिए?
Within 50 kilometers. 50 in hills.
अच्छा फिर where is
the next note 40 also, my lord?
Sudha Devi Muthu.
Then next page note 43, my lord. Submitted for approval with effect to attachment of the following hospitals with Simla Valley Nursing College as recommended.
Reason क्या है सर आपका आपके हिसाब से? What is the reason?
Rejection is at page 58, 45.
Reason for
there is no.
Only we say as per the plan, we say that these private colleges has to manage their hospital attachment. And then
why do you say? You see, there is a subtle difference. There will be a difference. You see, the stand you are taking, वो दो धारी तलवार है. आप कहते हैं कि you are not bound to provide them. That then assuming goes to CHC Sunni, और CHC Sunni का जो सबसे बड़ा डॉक्टर बोलता है कि मैं अटैच कर लो आप इंटरफेयर नहीं करेंगे. You will have no business to say that the authority over there, if satisfied, has no right to attach the beds of that particular hospital with the institute of the petitioner. क्योंकि ये तो monopolize करने वाली बात होगी ना.
And once there is a recommendation,
and you have to
the authorities
see on a lighter side, you see the predicament of the petitioner. He has been able to see from the principal secretary health, which itself is a big surprise.
Only to be rejected at further level.
In between the lines, just feel for them. समझे कि नहीं समझे? तो इतनी मेहनत करके भी अगर कुछ नहीं मिला तो क्या लो लाइट भी गुड होगी.
At least it can be. I was going to point out in extra PF that notification which lordships were wanting.
P8 क्या कहता है सुनिए?
My lord, page 62, my lord. Hospital.
ना अब now they have come up with a new policy. कि जो मेडिकल कॉलेज कुछ है उसमें किया ना कि अपने हॉस्पिटल होंगे उनके.
My lord, in here, if lordship will have page 62, my lord, hospital at
8. P8
starts from page 59 and the relevant would be at page 62.
अच्छा, anyways, इसमें लिखना आपने learned senior counsel for the petitioner submits that the of the petitioner for attachment of certain beds of Civil Hospital Suni and Community Health Center Halok Dhami, है ना? Have been arbitrarily rejected by the respondents, despite the fact that there was a recommendation to this effect by the Director of Medical Education as well as Secretary. Okay? A perusal of the rejection demonstrates that no reason stands therein as to why the proposal was being rejected. A learned Additional Advocate General, on the strength of the reply filed to the petition, submits that the private party has to manage the hospital attachment at their own level, and state government is not bound to allow hospital attachment to these societies. This court is of the considered view that if this is the stand of the state, then of course the court will not insist upon the state government to offer attachment. क्या लिखा आपने? Then of course court will not insist upon the authorities like Secretary Health and above to go into the nitty-gritties of the attachment of beds with such like institutes. But then, if such like institutes are able to get beds attached of any medical hospital, primary community health center, etc., then the authorities concerned named above shall be having no right to interfere in the decision to be so taken by the Director of Medical Education. Faced with this situation, submit that he may be given 3 weeks list on that. Yes, please. Roshan Lal. Yes, please. Yes, please. ये चाहिए वो वाला केस है इसमें मैं नहीं कर रहा हूँ ऑर्डर we'll see into your video. You see, Mr. ऐसा ना, his contention is very simple. He says कि जो डोनेट किया लैंड है ना, इसमें ऐसे लिखना the grievance of the petitioners in these cases that their land is without compensating. तो पहले किसने लिखा तो उनको कहना जजमेंट मत, उनको कहना जजमेंट मत. The point of the state is that the land has been utilized after the land was gifted by the petitioner. Copies of gift deed as per him stand appended with him. Learned counsel for the petitioner submits that the writ is pertaining to khasra number 170, 178 and 180, and for these 3 khasra numbers, no gift deed was executed by anyone, including the petitioner. Learned additional specific instructions as to whether any gift deeds were executed with regard to these 3 khasra numbers. And yes.
Record on the RTI specifically mentioned that there is no record available pertaining to these khasra numbers.
And if yes, then to place that specific gift deeds on the list on that. We'll see if we can help you by to that. Please.
In this matter also I am seeking only 2 week time to file the reply, because on the last day there was observation if you will not file the reply that will be closed, but due to the they are seeking a mutation.
The properties originally belonged to my father. House number 93A, B and 93C. The mutation was attested in his name. And prior to that, the property was evacuee property, which was purchased by my father. One property, other property was.
You see, stop order has already been passed. So I can't give you any more time. इसमें लिखना court time is over, list of theories.
Please. Please. I'm so grateful.
Court time is over, list of theories.
Please, I'm so grateful.
Yes, Karan.
My rejoinder is ready. I will reply.
Reply not filed by
I of R7 has not been filed. Others have filed. Rejoinder also I have filed and filed.
आपकी जरूरत है?
वैसे बाकियों में कवर हो जाता है.
इसमें लिखना reply not filed by R7. Possibly filed with Meanwhile, rejoinder to the reply. Yes, Mr. Answer. Reply file. करण के केस में उसे लिख लेना R7 adopt the reply.
What is this?
Yes, what is this case?
Lordship, these are land acquisition cases, Your Lordship. I am seeking time to file rejoinder.
What is the stand in the reply? Admitted है.
Admitted as Your Lordship.
We are now we are trying to file this supplement here.
कैसे? कोर्ट ने बोला?
With the permission of
उसने तो
Lordship already.
we are ready and willing to return back to the station.
जमीन ले लो कि वापस हो जाए.
Lordship, औरों में तो फिर award हो गया ना. There are already.
Pardon?
Lordship, there are awards that have been done in favor of the same road in different. Lordship, I was actually at the lecture P3.
मैम अच्छा रिप्लाई सेंड फाइल मैम प्रेस फाइल ग्रांटेड 3 वीक टाइम फाइल रिटर्न. आप उसमें बताओ.
Next, we say.
Same ma'am. Mr.
Please.
Mohanlal. Yes,
A reply sent file by the state, my lord.
Rejoinder within 4 weeks.
Please, ma'am.
Reply not filed. Case क्या sir?
For the acquisition of land, that is annexure P1 at page number 15.
4 weeks.
Please, madam.
Land acquisition का ये भी.
Please, madam.
Utilization of land without payment.
Please, madam.
होगी मैम कंप्लाई.
They have given already first installment.
टोटल कितने मैम?
3 years till year 8.
Actually ऐसा ना, if you see these people, चाप इनके 90,000 के क्लेम है. ये एक लंप सम में दो इनको 6 हफ्ते 8 हफ्ते. हाँ 6 वीक्स ले लो पर दो एक मुश्त. ऐसा ना इसकी बरकत ही नहीं होती जैसे कि अगर 10-10 हजार रुपए के देंगे आप इसको बरकत ही नहीं होती. ट्रेजरी ने क्या ऑब्जेक्शन दिया? Treasury cannot sit over the. वो तो आपने अपनी सहूलियत से किया हुआ है ना, तो आपका अपनी इन्होंने क्या लेना देना उससे. इसमें ऐसे लिखना आपने compliance affidavit stands filed. Current counsel for the petitioner has pointed to the compliance affidavit and has stated that the areas that have been worked out are being paid in installments. This court is of the considered view that taking into consideration the amount involved, it is injustice with the respondents to pay this meager installment also in installment. This meager amount also in installment. Accordingly, these proceedings are closed with the direction that let the balance amount payable to the petitioners be paid to them in lump sum within a period of 8 weeks from today. In case needful is not done within 8 weeks, then the petitioner shall be at liberty to revise the procedure. Yes, Babita.
Thank you for the introduction.
Order क्या था मैम?
They were able to re-engage the service of the petitioner.
60 years वाला. Yes, he has crossed the age or not? 3 weeks actual date.
Your Lordship, reply is awaited, Your Lordship.
Order क्या?
They have to transfer the petitioner, Your Lordship. Then
2 weeks. Just on dash. Mahesh Thakur, reply not found.
Reply is awaited.
Yes, कैसे?
Sir, it's a land acquisition, sir. Road is.
अच्छा, reply. Chaitanya Mahajan.
Tomorrow morning.
Let's say for Boxing Federation of India, I am appealing.
तो list tomorrow. Learned Council पर इसमें लिखना Learned Council for the parties pray that case will list tomorrow so that the order passed by the Honorable Supreme Court can be placed on. Ordered accordingly.
Your Lordship, the presence of Mr. R.L. Sood.
Where is he?
Your Lordship, he's with the dentist. With his dentist. He's with his dentist, Your Lordship. He has some problem in his tooth.
I hope he's not in ADC.
Nitin Mahajan.
Ankit Dhiman.
Your Lordship, invite Sri Hemant Thakur. Reply is still awaited.
क्या? What is the matter?
The matter pertains to the internship stipend for internship and the fee for internship. Your Lordship, I am a foreign medical graduate and I am at par with the Indian medical graduate. Though I am charged a fee for internship.
बाकी केसेस भी थे ना ये लगे हुए. आप ये फॉरेन बाहर के ग्रेजुएट्स हैं?
Yes.
ग्रेजुएट फ्रॉम
Foreign medical. Foreign medical. Yes. Yes.
कहाँ से की है? यूक्रेन से की है तो मैं रिलीफ दिला देता हूँ.
Your Lordship, from different.
कौन से यूक्रेन से तो नहीं है कोई?
Your Lordship, I am not aware of.
यूक्रेन से है की हुई तो रिलीफ मिलेगी. टर्की से किया तो नहीं मिलेगी.
As your Lordship pleases.
चलो ठीक है, लिख लेना, नोट कर लेना.
Yes.
यार इसमें रिप्लाई फाइल करो जो भी है. रिप्लाई इज नॉट फाइल्ड डिस्पाइट रीजनेबल अपॉर्चुनिटीज ग्रांटेड. एक मिनट, एक ही अपॉर्चुनिटी है. रिप्लाई स्टिल नॉट फाइल्ड, बोर्ड एंड फॉर 4 वीक्स. R5 unserved. आप इसमें लिखना as per the report of the registry R5 unserved. He was not found at home and his son has refused to accept it. This court is of the considered view as a major member of the family has refused to accept it. There is deemed service of the said respondent. Accordingly, respondent number 5 is deemed to have reserved. As said respondent has not put in appearance despite service, proceed against ex party. अब क्या सकते?
This is my case, my tourism registration has been cancelled, madam. To the requisition
फाइल किया उन्होंने?
फाइल करते हैं.
किसने फाइल किया?
1, 2, 3. No, my lord, they have in the reply, my lord, name of the person who submit application has not been disclosed.
Reply to the petition stands filed by 1, 2, 3. Reply if any by R4 in 4 weeks. This thereafter in the meanwhile. Reply be filed by this rejoinder to the reply by 1, 2, 3 be filed. Continue to continue. Shri R.K. Baba.
Same man of where my land is utilized for construction of road.
R11.
Lakshmi.
आप आ रहे सर?
Kindly come to this next P1 madam.
Before that, Lakshmi, kindly come to page 10, para 12.
This was for consideration on the interim madam.
I'll just show that. I'll show it from that.
Yes.
Para 12, Lakshmi.
You have had enough time today. Yes.
Lakshmi, kindly see para 12. That page 10 mark. Feeling agreed by the illegal acts of the respondents, the petitioner had filed so. However, the Honorable Court made its order dated so and so, passed in CW number so and so, dispose of the matter with the liberty to the petitioner to file a fresh petition in respect of issue regarding utilization of private land comprising in case number so and so of the petition by the respondent. Now, Lakshmi, kindly come to page 78. Mark. The reliefs are quoted. Then page 79, Mark. Para 2. This court is of the considered view that as the primary allegation and grievance of petition is the acts of the against the omission of private respondent, this writ petition is not maintainable because in a list between individuals generally, a writ does not lie, shall be well advised to approach approved for a civil court for the redressal of her grievances against the private respondent. Now, para 3 is the liberty matter. At this stage, the senior counsel for the petitioner submits that there is another issue, which is the land of the petition has been utilized by the respondents. Now, respondent means state matter for the purpose of construction of the road without her consent. If that is so, then the petitioner, to this limited extent, may file petition as paid for, and the disposal of the petition shall not come in play. Now, my lord, relief, which he has again paid worship. Page 29, my lord. Page 28. To set aside and quash the impugned action of respondents, inasmuch as the respondents have illegally.
Mr. Sharma, because this last case was also listed for me. If you kindly come to page 78. No, sir, page 78. The relief being prayed for by the petitioner was that a mandate must be issued directing the respondent to restore the land of the petitioner to its original form by removing encroachment. I asked the learned counsel that encroacher. Encroacher was stated to be the private respondent. I said that no. If that is the issue, then you go to some other court. This is not the domain of the High Court. Now, if you see the first order passed by me in this court, now I am not saying whether the allegation is good or bad. His allegation is, I have specifically recorded in the order, sir, is raising construction over the land which is in possession of public works.
In possession of
public works department. वो मैंने order में लिखा हुआ है, जो first order आप पढ़ेंगे ना kindly. It's only for this purpose that.
It is in consonance with annexure P1.
What I say is,
आप reply file करो.
But Lordship, may kindly see there is another writ petition, wherein Lordship, the CWB 7125 of 2020-25 against this very construction, and this one court has permitted me to continue with the construction at my this one.
No, that is incorrect, my lord.
7125 2025.
There is a writ petition.
इसी कोर्ट से किया.
इसी कोर्ट.
तो क्या रेट है नंबर है?
Mr. Baba, we'll take it up next week. I'll order.
मैं अभी क्लैरिफाई कर 7125. किसी और पार्टी ने की होगी जी, किसी और
कंस्ट्रक्शन के बारे में
किसी और टेक्स्ट में करी होगी जी. नाउ ही इज ट्राइंग टू वेट. पहले तो इन्होंने ये कोशिश कर ली जी, मेरे को 4 लाइनें बोलने दो जी, उसके बाद ये जो मर्जी बोलते रहे. हाँ जी. P1 में कैन बी सीन. नेक्स्ट P1 में कैन बी सीन. आप देखेंगे जी P1 को देखेंगे जी. P1 देखेंगे जी.
Mr. Baba, let Mr. Sharma respond to it within 3-4 days.
बड़ी तेजी से कंस्ट्रक्शन हो रही है जी.
No,
very it will become
construction 15 only working out within that.
No, that is absolutely wrong. इन्होंने नक्शा पास कर दिया जी इसका. The map has been let me complete.
Mr. Baba, let us do one. I'll list it tomorrow. Let the other writ be placed on.
हाँ जी.
और अगर आपने कोई इंटरिम का रिप्लाई वगैरह बनाना है अब तब तक
तो कल तक दे दें जी.
ये ऐसा है जी, इसमें इन्होंने 15 से लेकर के आज तक की कहानी है.
मैं
R11 stands served. Felicia put in appearance on behalf of the said respondent. On his instruction, the senior counsel has also put in appearance. The senior counsel submits that there is another writ petition, that is CWP number
7125 2025.
In terms whereof the petition has been permitted. In terms whereof respondent number 11 herein has been permitted to carry out the construction.
At his risk.
At my risk.
At his own risk and peril.
Yes.
As prayed for.
कल की
It is directed to list the said case also along with this petition.
Tomorrow.
Please.
वो लिस्ट कुछ और है जी. मेरे तो आई एम द सफरर. मेरी जमीन पे सड़क बना दी और सड़क वाली जमीन पे नक्शा पास कर दिया.
R.K. Sharma.
Remove the issues. Suppose issues are placed on the court. Submit one. Yes. I misplaced the file.
Pardon?
I misplaced the file. Somehow is there.
परसों मंडे को लगा दूं.
कल के लिए कह रहे हैं जी.
लगा दे. कल एक सेकंड कल कितने केस हैं? कल लगा दूं.
ठीक है.
On the request of counsel for the respondents tomorrow.
Please.
Not in this application 711 application. Not to fix any date one. My learned friend has lost the file. That is one another thing. He's finding it out. But in any case, without this 711, anything would be actually contrary to the law. That would be an awkward situation.
That can be heard. That can also be heard tomorrow, Your Worship.
But that will, because that will take some time. Manoj will take it on any other day.
तो कल कर देते हैं. कल 56 केस हैं तभी मैंने पूछा.
Please, please.
Prepared on 7.
Please,
711 4-5 दिन का टाइम दे दो.
नहीं नहीं. This will be heard tomorrow.
Please.
आपने प्लेट से बताना है whether any whether the petition is good.
मैं वही बोल रहा हूँ कि 6-7
प्लेट से बताना है और आरपीए से बताना है.
Please.
Representation of People's Act में clear कट है कि किन grounds पे challenge हो सकता है.
Please, please.
If he has gone outside those grounds.
ठीक है जी. ठीक है जी. Please.
इसीलिए मैं बोल रहा हूँ कि जो 4
कल लगने दो ना सर.
हाँ कल के लिए ऐसे कल के लिए क्या नहीं हो पाएगा.
नहीं कल इश्यूज के लिए लगने.
इश्यूज फ्रेम करना जो है वो बिफोर 711 थोड़ा हो जाए.
कोई पाबंदी नहीं है जी इशू फ्रेम करने के लिए.
वो तो जजमेंटरी है, लॉ है, जिसपे तो ऐसा नहीं है. पर मैं तो बोल रहा हूँ 711
filed at any stage. 711.
हाँ जी.
711 can be filed at any stage.
That can be. That is to be heard, Lordship.
But once it is filed, then at least then it has to be decided.
Mr. Bhushan, ये वो वाले इश्यूज नहीं है जो कल फ्रेम हो गए तो 2-3 दिन में बड़े हो जाएंगे. ये कागजों में ही रहेंगे. ये वो वाले इश्यूज हैं जो कागजों में ही रहेंगे. तो don't worry. Let us frame the issues tomorrow. We'll fix a date for 711.
That can
cover. 7-11 की कल डेट दूंगा मैं जब इश्यूज पे जाएंगे ना. फिर एक लाइन में ऑर्डर. Yes, Mr. Karan.
In this matter, on the last date, I put a query whether the predecessor in interest of the petitioner had filed appeal before the divisional commissioner. Madam, may I kindly have page 116 of the paper book. 116.
These are hearing matters.
Yes, my lord.
Page
116. Over here, the appellant number 3 is Duni Chand. He is the predecessor in interest of the present petitioner.
बताओ मेरे को facts दो फिर से थोड़े.
My lord, in this case, the dispute is regarding the reversion of land under the HP Tenancy and Land Reforms Act. This is a case in which land was, the present respondent had filed an action for reversion of land. That application was allowed by the collector. Subsequently, the learned divisional commissioner set it aside, holding that he already is in possession of more land and he is not entitled to any more benefit. Subsequently, when this was carried in appeal to the financial commissioner passed the impugned order, my lord, which my lord had gone through on the last date, which is at page. This is the next year P9, my lord.
P8.
P8, my lord, yes. Which is an order which is without any reasons, my lord. Let me kindly have page 73. No reasons assigned. In fact, some of the grounds that have been mentioned for setting aside the order of the learned divisional commissioner are not even borne out from the record. In fact, on the last date, I had taken, my lord, through the order of the learned divisional commissioner also, which is a much detailed order and a reasoned order. So during the course of hearing, my lord, an objection was taken from the memo of parties. In fact, if the memo of parties of this order is seen, my lord, it does not reflect name of all the parties. The order passed by the learned divisional commissioner. Therefore, my lord had put a query whether the predecessors were party before the divisional commissioner and whether any appeal was filed by them, my lord. Even though the petition that has been filed before the learned financial commissioner, that also shows my name. It is Hansraj and Indri Devi, implemented by them only.
There is one issue. You see, if the financial commissioner has concurred with the order passed by the divisional commissioner.
Not concurred, my lord. Set aside the order. Order has been set aside, my lord. My lord, may kindly have page 76.
अपनी रीजनिंग कोई नहीं दी।
अपनी कोई नहीं है जी। Rather, divisional commissioner की reasoning is better.
मैंने पिछले टाइम भी यही
कहा था जी।
My submission is, I filed with petition to the petition. I have taken the first ground. That my submission is that could the person who is the petitioner, when he has not assailed the first order.
No, but he was a party in the list, na? Wrongly, his party in the list.
He was not.
He was.
Kindly,
You see, this is the order passed. Who has passed this order? Financial commissioner.
No, we will go certain.
No, we will, yes, seriatim wise. But now there is an option. There is an option from A to Z or Z to A.
It's both ways.
So we'll go from Z to A.
I know the first day the order was passed by.
Who is Prakash Singh? Who is Prakash Singh?
He's the landlord.
Who is representing Prakash Singh?
Me.
So you had preferred the revision petition.
First, LRO passed an order.
Just Mr. Balian, answer the query of the court. You had challenged. You had filed the revision petition.
Miller.
Whom treated as party respondent?
It was not me, Miller. We'll go by certain. LRO passed the order.
No, sorry. Mr. Banyal, kindly answer the query as is being put by the court. You filed the revision petition. Revision petitioner में आप थे petitioner. Respondent कौन थे?
Respondent थे Miller. In fact, why I am saying so? Prem Singh, Hari Singh, Tuni Chand and Gyan Chand, Basant Ram. We are put to be according to last date of hearing. In fact, the order was passed by LRO Bhatt sir. As special provision of law, the appeal lies to the deputy commissioner of the concerned.
I have followed you.
And
I followed you. You are saying that because according to you they had not assailed the first order, therefore they have no right to assail this order.
Miller.
That I have understood. But that will not oust them from challenging the order. Why? So, Mr. Banyal, let us apply some common sense. You filed the revision petition. You were the petitioner. Who were the respondents therein?
My lord, I came in.
Who were the respondents therein? Before the divisional authority.
Before the divisional, I was the respondent, Lord.
Huh?
I was the respondent before the divisional commission.
Sir, before the financial commissioner.
I was a petitioner.
Who were the respondents?
The other, Lord, other tenants.
He also.
He also.
So he has a right to challenge the order. How can we?
I'm not saying. I'm saying my mood submission is when the present petitioner he never assails the first order. That
have you ever laid challenge to any of the proceedings on this ground?
Not my submission is it's the legal submission. I know my submission only rest is to my daughter. Because as per the special provision of law, he ought to have assailed the order passed by LRO.
Sir, ऐसा है ना, you see, Mohinder Singh Gill क्या कहता है? Mohinder Singh Gill. Mohinder Singh Gill will come. You see, issue is very simple. Herein, what prevented you from not implementing them as party respondents before the financial commissioner or divisional commissioner?
They are a part in that. As far as this present petition is concerned, he was part.
You see, there is a problem. As Mr. Karan has pointed out, in the appeal that was filed before the divisional commissioner, his predecessor in interest is respondent is appellant number 3. His appellant number 3.
Why I'm saying he became appellant there only.
सुनो ना मेरी बात. What prevented you from taking this objection before the divisional commissioner that the appeal is not maintainable on behalf of Duni Chand?
I'm saying so, my lord. My submission is even if that plea is not taken, I'm saying so. Then this plea is not. I cannot.
No. You go before the divisional commissioner. I'm relegating you back to the divisional commissioner. वहाँ पे कर लेना आप ये रेस. वहाँ पे आप ये रेस कर लेना please.
My only submission is I am making submissions.
No, I'll give that liberty to you.
I'm making submission. My submission will be recorded in the file.
No. ऐसा है ना, that is no issue. That is no ground for. I am not forced to record. Why? Because I'm going to decide it on a totally different ground. मैंने उस रास्ते पे जाना ही नहीं.
My submission is I have taken all the number one, number two. Interesting point is number two. Why not go through hurriedly reply filed by me?
लिखो सर इसमें by way of this petition the petitioner
he filed the civil suit also. I have placed on record the judgment passed in the civil suit. And civil suit was filed.
Mr. Banyal.
These are the facts.
The question is not of facts. Question is I am deciding it on the ground that
He filed
it is a non-speaking order.
civil suit. The judgment of civil suit. He filed civil
लिखो सर
suit
इसमें by way
on
of this
17 September.
by way of
one month.
by way of
Instead
this
of challenging the report, DCM report.
by way of this
He preferred civil suit.
by way of this petition, the petitioners have paid for the following things. The petitioners are aggrieved by the order passed by Financial Commissioner Appeals in Division Petition number 86/97 entitled Prakash Singh versus Prem Singh and others, in terms whereof, while accepting the revision petition filed by the respondent herein, Learned Financial Commissioner set the order passed by the Divisional Authority. Learned Counsel for the petitioner has inter alia argued that the order impugned is no order in the eyes of law for the reason that there is no reasoning given in the order as to what weighed with the Learned Financial Commissioner so as to persuade the authority to set aside the order. He submitted that it is settled law that an order has to be a reasoned and a speaking order from which it can be from which it can be deciphered as to what weighs with the authority so as to arrive at the conclusion which is so arrived at in the order. In the present case, he submits that except for the last one para of the order, the rest of the order is devoted to the facts and contentions of the parties and what was contained in the order passed by the authorities. The Financial Commissioner has only given the following reasoning to set aside the order, so quote kar dena, and perusal thereof demonstrates that there is no discussion of the contention of the parties, no independent reasoning assigned by Learned Financial Commissioner as to why it was not concurring with the order passed by the Learned Divisional Commissioner. Accordingly, he praised that as the order is per se, at being a non-speaking order, the petition be allowed as paid for. On the other hand, Learned Senior Counsel for the private respondent has submitted that the order is a well-reasoned order and perusal thereof clearly demonstrates as to what weight with the Learned Financial Commissioner by setting the order passed by the collector. Learned Senior Counsel further stated that otherwise also the petitioner has no locus to file and maintain this writ petition for the reason that the first order passed by the Land Acquisition Officer, LAO, by the Land Reform Officer, was not assailed by the predecessor in interest of the petitioner before District Collector Hamid.
And therefore, rest of the proceedings.
Accordingly, he submits that as there is no merit in the petition, the same deserves to be dismissed. I have heard Learned Counsel for the parties and I have also carefully gone through the orders passed in the matter, including the impugned order. A perusal of the order passed by the Learned Financial Commissioner demonstrates that deciding the revision petition, the authority took note of the facts of the case and also the contentions of the parties. Thereafter, in the penultimate para, it referred to the findings returned by the appellate authority. After taking note of all said facts, the authority did not, the learned financial commissioner did not dwell on the grounds of revision petition and set aside and went on to set aside the order passed by the divisional commissioner by passing a totally non-speaking order and by observing that from the above, all the points on which divisional commissioner accepted the appeal as meriting further inquiry stroke construction were dealt with very thoroughly by district collector. Who in his order had given clear findings on the issue, and therefore the revision petition is accepted and the order of divisional commissioner is set aside. It is settled law that reasoning is the soul of the order. Every order which has civil consequences as far as a person is concerned has to contain reasons demonstrating that the final conclusion arrived at by the authority has been so arrived at by. In other words, the authority stroke quasi judicial authority has to take into consideration the respective contention of the parties, and then it has to dwell on the respective contentions vis-a-vis the order under challenge, and it has to justify its decision by laying down the reasons in the order on the basis of which the final conclusion is arrived at by the authority. In the impugned order, all this is lacking. The same does not contain any reasons as to what weighed with the authority so as to set aside the order passed by the divisional commissioner. No reasoning has been given in the order as to why the findings returned by the divisional commissioner were bad. There is no discussion on the respective contention of the parties justifying the setting aside the order passed by the divisional commissioner. Therefore, this court concurs with the submissions made by the Learned Counsel for the petitioner that the impugned order is bad, being a non-speaking order. As far as the objection raised by the senior counsel for the petitioner for the maintainability of the petition is concerned, this court is of the considered view that the objection is without any merit. A perusal of the record demonstrates that the appeal before the National Commissioner was filed by Prem Singh, Hari Ram, Duni Chand, Gyan Chand and Basant Rao. The petitioner is the successor in interest of Duni Chand. The appellants who preferred the appeal before the learned divisional commissioner were successful. Feeling aggrieved, the private respondent herein filed a revision petition against the order passed by the divisional commissioner. A perusal of the record demonstrates that therein the private respondent himself impleaded
It is this petitioner who joined 3 persons before DIVCOM.
He himself impleaded the predecessor in interest of the petitioner, and thereafter his legal heirs, including the petitioner, as party respondents, obviously for the reason that Duni Chand was one of the appellants. Nothing prevented the private respondent from raising an objection with regard to the maintainability of the appeal before the learned divisional commissioner on behalf of Duni Chand on the ground that the same was not maintainable. That was not done. That being the case, the petitioner cannot be allowed to become wiser now, more so in the light of the fact that the present petitioner happens to be petitioner wiser, respondent wiser now, for the reason that the present petitioner in fact has got the locus to assail the order in issue from the fact that he was implemented as a party respondent before the Learned Financial Commissioner by the respondent. Accordingly, in view of the above discussion, this petition is allowed. Order dated 10/10/2006 is quashed and set aside, and the matter is remanded back to the Learned Financial Commissioner appeal with the direction that post remand the matter be decided afresh by adhering to the principles of natural justice and an endeavor be made by the authority concerned to dispose of the matter as expeditiously as possible in preference for 30th of September 2025.
Obliged, madam.
Yes, Seema. Yes, Neha.
Please, Your Lordships. Your Lordships, this is the same matter wherein the state had handed over the pen drive in the last date, Your Lordships. It's a matter of unlawful arrest, wherein the lady, wherein the petitioner, she was arrested from her matrimonial home on the basis of the complaint which was filed by the who herself is an accused under 498.
The court time is over now.
Please, Your Lordship.
It requires some time. So we'll take it after vacation.
Please.
And उस दिन आपने 2 बजे मेंशन करके बता दें.
Please, Your Lordship, I'll do it.
फिर उस दिन सुन लेंगे. Relief क्या मांगी हुई है आपके केस में?
Your Lordships, I'm praying for an inquiry by CBI. Your Lordships, may kindly have page 27, 28.
We'll look into it.
Please, Your Lordship.
Allegation क्या है?
SIT, Your Lordship.
Allegation.
Your Lordships, she was molested in the police custody. In fact, the CCTV footage around that time is also missing, Your Lordships. And there is also an observation made by the National Commission Women, Your Lordships. It's at page 350, Your Lordships. Your Lordship, may kindly have page 350. It says the Attendant of Police Hamirpur shall conduct an internal inquiry regarding the allegation made by Seema Mishra against the police officials of Hamirpur Police Station, as the fact that CCTV footage of only that moment when she was taken to the lockup is missing is quite questionable.
No problem, we'll see it. It's very nice. The court time is over. Problem with district. We'll take it in the first, second week of July.
Please, Your Lordship. In fact, they've themselves in their final report pointed out that there is some police official who's been seen near the switch of the CCTV camera, Your Lordship.
It's on 23rd of the Sunday. So, but
I'll make a mention, Your Lordship. Please.
जगन जी क्या इंस्ट्रक्शन है?
लॉर्डशिप में बात नहीं हुई जी, पर ऐसा है जी, अगर वो टाइम दे दे थोड़ा सा जी,
उस पे बोलो, मैंने फिर उस पे अपॉइंट कर दूंगा.
फिर अदरवाइज रिटायर्ड अथॉराइज की है जी, वो फिर वो नाम भी ले लूंगा मैं इन द मेन टाइम. तो उनको रिटायर्ड तहसीलदार ना या अथॉराइज.
रिटायर्ड टू कोई नहीं, मैंने यहाँ से लॉयर अपॉइंट करना है. 50,000 फीस पे बता दिया आपको पहले.
अदरवाइज लॉर्डशिप रोड की डिमार्केशन की नहीं उन्होंने जी, वही है जी मेन. देखो
चैलेंज कर दो ना उसको, वही ऑर्डर रहने दो.
प्लीज थोड़ा टाइम में पूछ रहे थे, बात नहीं
ऑर्डर बात नहीं कर दे. डिमार्केशन
नहीं वो टाइम दे दे जी, मैं क्लियर कर लेता हूँ.
हाँ, you challenge it.
तो थोड़ा मेरे को टाइम दे दीजिए, मैं इंस्ट्रक्शन ले लेता हूँ.
नहीं लो तो चैलेंज कर दो सर, उसको बेटर है.
सर गांव के आदमी नहीं, ही इज अनेबल टू पे लॉर्डशिप, इट इज वेरी डिफिकल्ट.
मैं कह रहा हूँ ना सर, उसको चैलेंज कर दो ना.
मैं बोल रहा हूँ जी, मेरे को एक टाइम दे दीजिए, मैं इंस्ट्रक्शन तो ले लूँ जैसे.
कल तक साइन नहीं करूंगा इस ऑर्डर को.
नहीं सर, कल वो उसे नहीं, ये जी फोन पे बात नहीं हो पा रही.
फिर मैं ऐसा है ना मिस्टर जगन,
लॉर्डशिप
नेसेसरी लिटिगेशन है चली हुई.
नहीं दैट इज नॉट अदरवाइज रियलिटी जी, अदरवाइज रिकॉर्ड के मुताबिक सब कुछ है जी. अदरवाइज
ठीक है, हो गया जो होना था. यस
सर, एक टाइम दे दें जी प्लीज.
ठीक है सर, इट्स बेटर.
लॉर्डशिप
कुछ
नहीं, हम्बल
आपको लिबर्टी दी हुई है डिमार्केशन के चैलेंज करने, उसमें मैं
बट अदरवाइज लॉर्डशिप इट इज द गवर्नमेंट रोड. लॉर्डशिप
दीस आर डिस्प्यूटेड इश्यूज, मेरे थोड़ी भी लेना.
लॉर्डशिप
उसमें मैं ये लिख दूंगा कि जो डिमार्केशन, जब अगर आप चैलेंज करते हैं डिमार्केशन, उसको वो देखेंगे अनइन्फ्लुएंस्ड बाय द ऑर्डर पास बाय द हाई कोर्ट ऑन मेरिट.
बट अदरवाइज एक अपॉर्चुनिटी दे दीजिए इनको. मैं तो और कुछ नहीं बोल रहा. अदरवाइज लॉर्डशिप
मैं आपको डिमार्केशन चैलेंज कर दो ना, मैं बोल तो रहा हूँ आपको, ये चैलेंज.
लॉर्डशिप उन्होंने पर्टिकुलर एक नंबर की किया जी, अदरवाइज तो के मुताबिक नहीं किया जी.
In this case, 2 SCMPs are pending, my lord.
They are main merit पे बताओ.
My lord, actually, my lord.
लॉर्डशिप एक टाइम दे दीजिए, मेरी मैं हम्बल रिक्वेस्ट.
तो जगन, इट इज इन योर इंटरेस्ट कि वो ऑर्डर ले लो, काय को पंगा.
मैं यही रह जाएंगे, पर मैं वो बात नहीं हो रही. वो
अगर आप कल तक कोई और इंस्ट्रक्शन लाएंगे,
ओल्ड आदमी जी नहीं बात नहीं हो रही क्लियर उनसे जी ये बात है
देख लो कल तक
बेर
actually खाना मत on the request of Mr. Jagannath Tuesday
और मैं रिक्वेस्ट करा जी मैं घर छुट्टी में जाना जी वो अगर वो बात हो जाए जी उससे अगर मैं बोल मेली होती बात ये रिक्वेस्ट है जी
चलो छुट्टियां कर दो
छुट्टियां ओबलाइज
लगानी ट्यूसडे
ठीक है जी ओबलाइज लॉर्ड
और यही ऑर्डर होगा उस दिन भी
चलो कोई नहीं जी होगी मैं एक बार इंस्ट्रक्शन भी ले लूं
बहुत ज्यादा जरूरी थी यस बताइए प्लीज
Actually, my lord, in this case, my lord, the petitioner has challenged the allotment in favor of the respondent number 4, my lord. Respondent number 3, my lord. Actually, my lord, in this case, my lord, the petitioner by annexure P1, my lord, a draw of lots was held, my lord, and he was declared selected, my lord. That is annexure P1.
Was declared as selected.
Is my annexure P1, my lord. After that, it deposited the amount, my lord. The receipt is annexure P2, my lord. After that, my lord, in the month of December, 5th of December 2019, my lord.
ये तो है नहीं
Subject to the decision.
तो आप बनाओ आपको किसने रोका हुआ है
But in fact, earlier there was a writ petition. I had been rejected. I came to this honorable court. There's a division bench judgment in my favor. He was a fence sitter, my lord. There was an interim order passed by this honorable court. Respondent number 1, it went ahead with the draw of lots and present petitioner was declared successful, my lord. Then he did not approach this honorable court. I filed a contempt against respondent number 1. Therein they said we will not proceed, but the matter was heard thereafter, and the judgment, if lordship will have the judgment which has been passed by the division bench, my lord, it is at page number 44.
Yes.
The moment this judgment was passed, he filed a review petition, my lord, the very next day, and obtained a stay order. Ultimately, that review petition dismissed, he was given liberty to file a writ or have recourse to other remedies. That is where he files this writ petition.
There is no stay.
But they are not proceeding.
आपको क्या को नहीं proceed? You proceed. Who is stopping you? You proceed.
Because it is there only. It is respondent number 1 who has created this mess for everybody.
No mess has been created. The only ground is before my lordship. There was a draw of lot. The Honorable Supreme Court, as well as the Punjab Haryana High Court, they consistently said draw of lot does not vest any right. No concluded contract. Nothing is between us. He's just trying to harass the court.
My lord, the reply of the respondent number 1 may kindly be seen in the writ petition and also in the review petition, my lord. They have taken a contradictory stand, my lord. In the writ petition, they have taken the stand, my lord, that he has made a false statement, my lord. Now in the review, my lord.
आप इसको पेट्रोल पंप दो. जब there is no stay, what is stopping you from? What is preventing you from going through the formalities? करो आप आपस में establish करो बाद में देखते हैं.
They have to start the process.
Mr. Mishra, I clarified that the pendency of the petition shall not come in.
My lord, that is also already, they are already in the order, my lord.
Because what is commercially, we are also suffering.
And this.
Who is stopping you, Sunil?